The signal that all the commercials are over. We're good to go. I'd like to call this meeting, regularly scheduled meeting of the December Tennessee Real Estate Commission to order. First on our agenda is the roll call by our Executive Director, Ms. Eve Maxwell.
This meeting's date, time, and location have been noticed on the Tennessee Real Estate Commission's website, included as a part of this year's meeting calendar since September the 7th of 2012. Additionally, the agenda for this month's meeting has been posted on the Tennessee Real Estate Commission's website since Tuesday, November 26, 2013. This meeting has been noticed on the 10Gov website since Wednesday, November 27, 2013. Now the roll call. Alexander?
Here.
Bloom?
Here.
Collins?
Here.
Nachara? Here. Flitcroft?
Here.
Grease?
Here.
Haynes?
Here.
McMullen?
Here.
Stevenson?
Here.
Everyone's here. That's great.
Full staffed.
Aren't we special?
Next on our agenda, I would like to call on one of our East Tennessee Commissioners, Mr. David Flitcroft, to lead us in our invocation.
Thank you, Chairman. Let's bow our heads and pray. Say it together. Trust in the Lord with all your heart and lean not on your own understanding, and in all things acknowledge him, and he will make straight our way. Dear Lord, during these next 2 days, do make straight our way. We ask for discernment, not just wisdom, spiritual, divine guidance as well. Bless these proceedings. Thank you for the rich and many blessings we've received. Amen.
Amen. Are there any additions or corrections to our agenda?
Mr. Chair, I'd like to make a motion that we move the legal report up right behind Mr. Giannini.
Say again.
If you pay attention to talking over
My
there.
vice chairman had a very important topic he needed to tell me.
We need to move the legal report up to right behind Commissioner Giannini so that Ms. Ryan can prepare for our hearing tomorrow.
Second that motion.
I have a motion by Commissioner DeShar and seconded by Commissioner Flitcroft that we amend our agenda to what you have heard. Anybody else have any additions or amendments to our agenda?
If that's the case, are you going to be here for a rule-making discussion today?
I am here for everything that is on Ms. Kropp's portion of the agenda. So she is here to present the legal report, the consent order log, the proposed advertising rule, and the policy discussion.
Like all of that to be this morning?
All
then?
of it, I want all of that to be before other things so that at the end of the day, it's probably Eve.
Right.
I just need to be able to have some time to do final prep for tomorrow.
So I'd like to amend your motion that all of those items that Ms. Ryan is here for be heard following Commissioner Giannini. What do you think about that?
Well, that's what
That was the motion.
That was the motion.
Well, it's more than a legal report.
No, right here.
Well, but
Right
that's what
above
it calls it at the top of the.
I'll call the legal report.
Thank you for clarifying that. for me.
Question's been called. All in favor of the adopting the agenda as amended by Ms. DeShara's motion, say aye. Aye. Opposed, no. The agenda is amended as,
Oh, me, it's going to be one of those meetings.
it's adopted as amended.
We have some grumpies today.
Next on our agenda
Wendell.
is our minutes. Are there any additions or corrections to the minutes? If there's not, then the chair will entertain a motion to approve our minutes from our November meeting.
We don't have any.
Don't have them,
We don't have any.
so we haven't read them.
We haven't read them.
Why don't we tell them, John, what we want to do?
We'll
Move to postpone that discussion until next meeting.
Green,
Second.
good morning.
motion by Commissioner Grease and seconded by Commissioner Mullen to postpone the approval of the November minutes until our January meeting. All in favor say aye. Aye. Opposed, no. Motion carries. Next on our agenda is Mr. Mark Green, Chief Legal Counsel of Regulatory Boards.
I'm sorry, I didn't hear that.
Just as well.
Commissioner Alexander said there he is in living color.
Good morning. I wanted to give the commission an update on the matter that has been appealed to the Court of Appeals. When last we met, we briefed you regarding the Attorney General's recommendation. We submitted, just to refresh everybody's memory, at the time the commission had recommended going with the Attorney General's recommendation of making an offer to settle the matter, and the terms of that offer was a split of the cost, a voluntary suspension of the license for Ms. Bobo for a certain amount of time. I believe it was, do you remember, Ron? 3 years, and a split of those costs of the matter. The Attorney General, the Assistant Attorney General Nick Barker, contacted the attorney for Ms. Bobo, who rejected the offer and made no counter to it. And so, as that stands, the appeal is going forward. The Attorney General is working on the appeal brief, and we are waiting for that document. When originally due December the 2nd, they asked for an extension of time, so it will be due January the 2nd. At that point, the Ms. Bobo will have a certain amount of time to file her response brief, and then at some point after that it will go to the court. We are probably looking at sometime in the summer before we have a decision on that, but that's where we are. So the appeal is going forward, and that's basically where we are. I'd be happy to answer any questions you might have regarding that. Collins.
Have her license at this time, or is there a stay on our motion?
No, she has the ability to renew. However, she has not. She is in retirement status.
Mr. Chairman,
Commissioner McMullen.
thank you for that report, Mr. Green. Do you know whether your office will have any input into the brief?
Yes, we have requested that be the case, that we receive the brief in a sufficient amount of time so that we can review it and add what our comments are. General Barker has already contacted me regarding factual matters as to how the matter came forward, and he did the matter at Chancery Court, so he's somewhat familiar. But we're in discussions about further facts that were brought up in Chancellor McCoy's order. So we are working with them, and we certainly have requested, and they've agreed to work with us before filing that brief and getting our input.
Mr. Chairman, just an observation for Mr. Green. Mindful of our Farragut meeting, I'm thinking of open meetings rules and laws that this commission and to a certain extent the legal staff is almost hamstrung. It's a shame for them to know exactly what our position is before we propose it. Yeah, that if opposing counsel had access to, and they do have access to what we told them in Farragut there, they knew exactly what we had in mind before we told it.
Well, what they have access to is it's just the recommendation. It wasn't the discussion that was done under executive session, which was a legal client discussion.
That's correct. But the second portion pretty much outlined what our position was, so they knew what we were gonna do before we told them.
Okay.
If they read the minutes.
If they read the minutes or watched the video.
Well, they know what we were going to recommend as far as settling the matter. And I don't have the minutes with me, but I don't know if we put on the record the in-depth comments about as to why.
Oh, no, there wasn't anything about the first discussion.
Right.
Anybody have any other questions of Mr. Green?
We will keep you updated. I mean, I don't, we will let you know when the appellate brief is filed and when the response brief is received. And we certainly will keep you updated on that matter. At this point, we will, we will, I anticipate it'll be the summer before we know anything, so that's, I don't know. I don't know if oral arguments are going to be, I will know when I get the appellate brief if there will be oral arguments at the Court of Appeals.
Would just keep us updated as this continues forward.
Well, Mr. Chairman?
How long do you think it'll be before we have a ruling? Midsummer?
Summer.
Okay.
That's what I anticipate.
Is it possible the chair will be called to testify?
No, there'll be no testimony.
I was worried.
It'll all be on the record and the briefs.
That should happen. I will delegate that to my vice chair. That's true. Anybody have any other questions of Mr. Green? If not, thank you for coming down and giving us the update.
Thank you.
Okay, thank you, Mark.
Have a good holidays.
Hey, you do the
Merry
same.
Christmas.
Are you going to eat lunch with us?
I'm sorry?
Is he going to eat lunch with us?
No, I'm not going to be able to make it this year. I have other matters that. Well,
We're just in the room.
well, I may try to stop by, but
Please
I
do.
appreciate that. I do appreciate it. Thank you.
Christmas.
You too.
We'll get you
And
to
Chairman
go.
Alexander, Commissioner Alexander, I was in Dresden this weekend. Rolled
Tell me you
through.
didn't come see me.
Well, I looked for you, but I just didn't have time.
Well,
See him standing on the street.
you're always welcome back home.
Next item on our agenda, we have two informal conferences. And first, we have Jason Miller with the principal broker, John Lithcomb. If you two would come over here, these two seats, two chairs on the end, and just, I forget whether or not.
Robin will swear.
Robin, you'll swear them in.
As soon as they sit down. If you both will please raise your right hands. Do each of you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
I'm going to give just sort of a brief overview of what you've told us, and then you can fill in whatever other information that you would like to add after I sort of give them a brief overview. And when you talk, if you remember to talk into the mics, just because they sometimes don't pick up everything that people say, and there are these big gaps when we go to listen to it. Mr. Jason Miller has indicated he would like to be an affiliate broker. He had not tested when he sent his information to us. Have you tested at this point?
Oh, ma'am.
Okay, he is not tested. He is here with his principal broker, John Linthicum,
No, Linthicum.
who is the principal broker of the Cry-like Inc. Realtors in Bartlett, Tennessee. His principal broker has no complaints. He was first licensed in 1979. He got his broker's license in 1980, and he got his principal broker's license in 1994, or became principal broker in 1994, according to the Trek records. Mr. Miller has disclosed to Trek that he was convicted of a felony in the U.S. District Court. The felony convictions were possession with intent to distribute cocaine and possession with intent to distribute a controlled substance and carrying and using a firearm. Mr. Miller says that he had picked up an individual, a young man, who had needed a ride, and he was pulled over by the police, and the police then asked him to step out of the car, which he did, and it left the young rider in the car. At some point, the police searched the car, and the young rider had left the car by that time, and there was cocaine found in the car and a firearm. Mr. Miller says that the firearm belonged to his dad, who owned a bar at the time, and the cocaine, he says, was not his, but after the trial, he ended up pleading guilty, and he was sentenced to 106 months in prison and 4 years of supervised probation. And that ended in 7/25 of '03. The conviction took place on 5/5 of '92. Since that time, Mr. Miller has worked as at a pizza establishment as a manager and several other jobs. And from 1999 to the present has had no other problems that he's disclosed with any legal authorities. And I'll let you fill in whatever else you'd like to add.
Excuse me. Yeah, I'm not saying that I wasn't ever involved in any drug activity at that time in my life. I'm just saying that particular situation, I wasn't guilty, but I did accept responsibility of myself because at the time I was in, that was not the same person I am today. I'm a completely different person. It was 22 years ago. So,
Tell us why you'd like to get a real estate license.
I'm really excited about the real estate business. I've always known, I've seen other people in it, and it seems like a really interesting and challenging thing. And I've met people that were involved in it, and they seem like really good people. And also, to make money.
Give us your employment, since you finished the completion of your probation, which I think in 2002. Give us a history of your work, history since then.
Since 1999, when I was released, I've worked for X-Line's Best Pizza in town. I've been a manager. I'm still a manager at the one in South Haven, Mississippi. Also, I've thrown newspapers. I work for a company called KCI, which is Kinetic Concepts, cleaning hospital beds and delivering medical equipment as part-time. I always worked full-time for X-Line's Best Pizza in town for the past 14 years.
Jason, I noticed in the notes we were provided that you've got a fairly large family. Number one, you might want to speak to that, confirm what was written down here. Number two, what attracted you to Cry-Like as opposed to other?
In the area, I live in Bartlett. In the area, that's the most signs I see. They seem to be a big company. And after meeting John, he told me that they're great advances in technology and trustworthy. I've never heard anything bad about Cry-Like. I'm very excited about the company, and I hope I have an opportunity to work for them.
About your kids, grandkids?
Well, I've been married for 11 years. I have 4 children and a daughter. My daughter, actually, she's 21. My oldest stepson is 29, and I have 2 step nieces that I raised. So I had 7 kids in the house at one time. And
so do you support all those kids?
they're all adults now.
Are you a role model for them?
Very much so. Actually, the young boys, I've encouraged them to stay out of the street life, and shared my experiences with them to, that those kind of behaviors would not get them anything good in life. And 2 of my stepsons are truck drivers now, independently. One owns his own truck; he's an independent operator, and another one has a family of 3 now. I have 3 grandchildren by my oldest stepson, and he takes good care of them. He's home every weekend. And I just try to be a very supportive and good role model for my children and grandchildren.
Any other commissioners have any questions of Jason Miller before we hear from his principal broker, John Lithcomb? If not, Mr. Lithcomb? tell us a little bit about your company, how many agents you have, and how you're going to, if we vote affirmatively to allow Jason to get his license and go to work for you. Tell us how you're going to train him, mentor him, and make him a good participant in this industry.
Well, we're going to do the best we can with that. First off, I do want to say that, Jason, when I first talked with Jason, he told me up front over the phone about his background and issues. And, of course, I said, that there may be some issues at Trek as far as getting your license with that. So we'll have to deal with that. And that was when we just talked on the phone. And then I interviewed him. Had a real good feeling about him and a good interview, and did do a little checking. Did talk with Walt Exline, who's the owner of the pizza restaurants that Jason's worked for a long time. Is somebody I know a little bit, not greatly, but I felt comfortable in calling him and getting a straight answer from him. And he talked very highly of Jason and his family, which I think is Jason's mom is heavily involved, or president of the corporation or whatever. So he spoke very highly, and Mr. Exline has got several different restaurants that he's been involved with for years. Very successful businessman, and he also mentioned his children. He said he always respected Jason for kind of taking on the four stepchildren and doing a great job and being a good father, stepfather, and all that. Also, Kevin Figg, who is the Success Real Estate School teacher, actually called me and left me a voicemail. It wasn't something that I solicited or asked her, but she called and just said that she hasn't known Jason that much longer than I have, but did speak highly of him and the classroom environment and what she had learned from him and learned of him. Jason's a homeowner in Bartlett, bought a house several years ago, teaches Bible study in his church. And I feel really very comfortable with him and his character. You spend 3 hours driving up here from Memphis this morning, you learn a little more too, and I feel just as comfortable, if not more now than ever. So as far as our office, Crye-Leike Bartlett, we have about 56, 57 agents. I'm the manager there, been there for 19 years, full-time manager, very accessible. I do still sell and list some real estate myself, but not a great deal. And have always prided myself in being kind of an office person, so I'm in the office quite a bit, and certainly there to answer their questions and help all our agents. Crye-Leike has a training program called Crye-Leike College, which is about a 4-week session that different managers like myself, as well as all the managers in the Memphis area, teach different segments of, and then each one of our department heads within Crye-Leike, relocation, accounting, marketing, whatever, also teaches different parts of that training. So it's a good training program that we run for about 4 weeks. It's not all day, every day during that 4-week period, but it's usually 3 to 4 days out of the week. And then we repeat that. So some folks that can't make every session of that particular month or period, they can go to it anytime they want to. It's offered. The encouraging part for us lately, of course, is that our class has been bigger and we have more people in them, and that's a good sign. We have sales meetings in the office just about every Tuesday, and that is a continuation of training really. We try to have topics. My goal with sales meetings has always been that it's not necessarily going to change your life or anything, but it's a tidbit of information that's going to help you in your real estate career, and I try to pride myself on not wasting their time when they're in there for the hour and doing all that, but giving them something that can help them. And then we also, typically I try to hook up the new agents with a mentor. I usually try to kind of find a person that kind of matches maybe the personality of the new agent, and I give them a list of some things that the mentor can do to help the mentee, and sometimes that works real well. I've got one right now that's working really well. You know, sometimes it doesn't. It just depends on how they grasp it and how they take to it. But we try to do all we can to ensure their success. Obviously, we want them to be successful. I want them to be successful. They're not all successful because it's not made. You know, real estate business is not made for everybody. But we try to do the best we can to take care of them.
Sounds like Crylike's got a good training program for a new licensee coming on with your company. Just out of curiosity, real quickly, how many agents did you have in 07? You've been principal broker for, you said, 21 years. How many are you down from 07 to today?
Yeah, I probably had about right at about 100.
And you're down to 57, 56, 57 now?
Yeah, but
Okay.
I've hovered at that level and probably started to tick up a little bit over the last year and a half. So,
Okay.
and I think that's probably Crylike too, and our local association's all about the same. You know.
Okay. Does anybody have any other commissioners have any questions of Mr. Lithcom?
Mr. Chairman?
I have one question.
Commissioner Haynes?
Are you going to work part-time? Are you going to continue to work at the pizza place and then work part-time for a while? I'm just curious.
I do plan on I plan on real estate being a supplemental income at first until, it gets off the ground, yes.
Mr. Collins?
Chairman, I'm very impressed with the applicant and his broker, and I think together they're going to go far, and I'd like to recommend that we accept his application to go forward.
I have a motion by Commissioner Collins to approve this applicant. Do I hear a second?
Second.
Second by Commissioner DeShara. Any discussion on the motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion has passed unanimously. Go forth and make this industry proud.
Mr.
Very
Chairman,
much.
Commissioner Flitcroft.
request permission to address Mr. Litham.
You do?
Sir, if he comes back, you come back.
I know that. I understand that. I've been living with that for a long time, so we're not planning on coming back.
Good.
Thank you all
very much.
Thank you.
Merry Christmas.
Same to you.
Christmas.
Good luck, Mr. Miller.
Thank you.
Next, we have Linda Bird and Mary Alexa Bass, the applicants with their principal broker, Dorothy Lee.
They are here. They just called Kelly and said they were parking their car.
Yeah, they're here.
Oh, they're here.
They're
Okay.
behind you.
Sorry. Didn't know they were here and I didn't see them coming out.
Would just come on up here and take these 3 seats.
Each of you, please raise your right hands. Do each of you affirm or swear to tell the truth, the whole truth, and nothing?
Miss Bird is. Oh,
Ms. Maxwell, hang on just a second. Mr. Chair, I need to recuse myself from this hearing.
Let the record show that Commissioner DeShara has recused herself from any of the deliberations in this matter of Linda Bird and Mary Alexa Bass. So you just sit here and be quiet.
Since you all missed the first individual, I'll give just sort of a brief overview of what you have given us, and then the commissioners, you all can fill in any blanks, which I'll leave, which I'm sure you'll probably want to do, and then the commission will ask you questions and ask your principal broker some questions. So as I say, I'll go over a little bit about what you all had disclosed to us. As was mentioned in the information that you all got, the commissioners got beforehand, Ms. Bass and Ms. Bird's conviction is intertwined, and that's why they're appearing together, and they both want to test for affiliate broker, and they have the same principal broker. So since they were involved in the same situation, it just seemed to make sense to bring them in together, and so that's why we did that, which is a little bit of an unusual move, but that seemed to be the best thing to do, to look at their situations. Ms. Linda Bird, and Ms. Mary Alexa Bass are here today with their principal broker, Dorothy Lee. Dorothy,
Maxwell?
Yes.
Which is which?
Dorothy Lee is the principal broker of K&S Homes, LLC, DBA Exit Realty Extreme. She was first licensed, according to the Trek records, in June of 1997, and she became a broker and a principal broker in September of 2002, and has been a principal broker with, I think, the exception of one small area of time since 2002. Ms. Bird and Ms. Bass have disclosed to Trek that they had a conviction for theft of property that was greater than $10,000 but less than $60,000, and that occurred in April of 1998. In conjunction with that particular conviction, they also had a conviction of forgery for $500 or less. Ms. Bird and Ms. Bass have said that the conviction stemmed from a business that they owned which bought and sold cars. Along with buying and selling the cars, they also sold upgraded lug nuts and rims, wheel covers and rims and tires that you could purchase. They had a rep that came by from time to time, and they would purchase those items from them. And they would once or twice a year have a truckload sale, get about 35% off. This particular time that involves the conviction, the rep came by and they purchased more than they usually purchased, and the price was at a 65% discount. As it turned out, the sales rep had stolen the merchandise that he had sold them. The police and the jury and the grand jury, I guess, ultimately decided that everyone who bought from that sales rep should have known that the items were stolen. Ms. Bass and Ms. Bird were ultimately convicted of the theft of property and of the forgery, and the forgery resulted from the fact that they gave the individual half the money in cash for the merchandise and half by check, and the check for about $200, I believe, ended up bouncing, and so that was why the forgery charge resulted. Ms. Bass and Ms. Bird both received 4 years suspended sentences on each count of 1 and 2, and they had a 1-year probation, which is really all they ended up serving in the end, was a 1-year probation. That probation ended on 4/9 of 1999. Since that time, I think they've owned a number of businesses and been in construction, I think, and owned a spa and a tanning salon. Is that in conjunction with the spa? So they've owned a number of businesses independently. They have each have a domestic assault charge, which was a misdemeanor charge, and they're here really in front of the commission because they have the felony conviction back in 1998. And I'll let you all fill in the blanks if you'd like to.
Yeah, which one of you, I want to get you're Miss Bird. Okay. We just, in your own words, just tell us, I know since y'all are here together, this is a little unusual to have two people instead of just one, as you just witnessed this other individual who came before us. But just in your own words, tell us what happened and why you wanted to do what you want to do as far as getting your real estate license.
Well,
you
as a
talk,
business-
you just need to lean over and talk loud into that
Okay.
microphone.
As a business owner, you tend to rely on your suppliers to uphold their end of their integrity in business. And we actually dealt with the supplier for over 2 years and this individual representative for probably over a year. So we had confidence in their products, the discounts that they offered us during the time that we owned the car sales, which we upgraded rims on those vehicles that we would purchase in order to entice the buyer with a nicer looking vehicle for those that needed it. That particular individual, the representative, came to us one day, and we had no reason to believe at 65% that there was anything wrong with that type of a discount. Had it been maybe 80%, it would have probably indicated something doesn't seem right about the rims. But that individual, because he stated that everyone that purchased from him had prior knowledge, it indicated to the jury that everyone that had purchased had to have some sort of liability in that way. Although the detectives did feel that we've never been in trouble before, our story did seem very much true, and they did reduce a lot of those charges. And obviously the check that had bounced was around $200. And that was only because when the police came and stated that the items were stolen, we weren't able to check our bank account to see when we had to put additional money in to cover any other expenses that we may have with the business overhead. So in our coming here in front of you all, we are in 2002, we took the real estate course and had a desire to go into investments in real estate, not just the sales part of it, but possibly on the investment side of it, to buy and sell homes that we would purchase. And we have always had that desire. We've put that on the back burner because we did start a day spa and salon and tanning studio, and we owned that for about 3 years. Mary and I were in a relationship of 11 years at the time. At the end of the 3 years that we owned the salon, the 13 hours a day caught up with our relationship, and it did come to, I guess, a bitter end. We've maintained our friendship since then. We did have probably a 4-year time span where we decided we wouldn't be friends. And one day after church, Mary saw me and gave me a call and asked me, if I would take time to talk with her and possibly at least reconcile a friendship. And it took 2 years for us to do that, and long story short, we are good friends now, and we've been able to have a good friendship of loyalty, and so we've thought that we would go back into real estate again. She came to work for me after her business slowed down in her entertainment company, and then I was able to see that she was a loyal friend and was helping me with my heating and air company. And through those efforts, we were able to help grow the business as well. But now we'd like to move on to the chapter of going back into real estate again, and hope that you all will decide that through the successes that we've had in our new businesses and the integrity that we have upholded, and that you would allow us to have our license.
Anybody have any commissioners have any questions of Ms. Linda Bird before we hear from? Now, you go by Alexa or Mary?
I go by Alexa.
Alexa, okay. Anybody have any questions of Linda? If not, we're going to have Alexa tell us in her own words why she wants to get a real estate license. Alexa, you have the floor.
Well, this is as scary as I thought it would be. I'm a basket of nerves, but
hey, just calm down.
Just calm down.
Don't worry about us. Just tell us in your own
ramble
words.
like I did.
Calm. I ramble sometimes when I'm nervous. With any relationship that ends, after a long length of time, there's a lot of pain in that. And we went through a split, and it was a little bit bitter for a little bit. And what I know, and I can be kind of too short sometimes, so I'm sorry, but what I know is through it all, we've just really depended on forgiveness and learning to forgive each other. and have become better friends, you know, after all of this. And we know we are a good team because we were successful before in the Salon Day Spa. It was awesome. It's still standing. It's on West End. It's wonderful. We built that space, and that's where we've built a lot of our clientele, a lot of our friends, you know, over the past 17 years of living here. We've always wanted to go into real estate, but I believe back when we changed our mind, we were scared of this today. So we changed our mind and said, you know, let's just open a business and go into the day spa industry because we're scared to go before the board and have to face it. And it's embarrassing. So we've decided after all this time, and we've gone into to other things. I've gone into promotions. I promote singer-songwriters in the city, events, Inspired for Women. Through all the things we've been through, I've tried to use my experiences to help other people. And I've learned so much through the decisions I've made. They have been poor choices at times, but I've grown. At 47, I've learned so much through those mistakes and those things. And I am from a good family, have a huge family. We all sing, and we're all ministers' kids, so you got to watch out. You know, sometimes we make the wrong decisions, but in the end, it's not to hurt anyone. It kind of just, you know, is meant to be that way, and we're supposed to learn from it and help other people. So, again, I'm very fortunate that I feel like I was the cause of that breakup. Not 100%, but I'll take a lot of the responsibility for it, and I did cause a lot of hurt, and I'm appreciative that Linda forgave me after so many years. And, you know, I don't really know what else to say. I'm rambling.
Does anybody have any questions of Ms. Bass? Commissioner Grease.
So, after hearing from both of you, is your intent to pursue investment real estate for your own account?
As a team.
Or do you, if that's the case, I'm curious why you'd want to get a real estate license. Mr. Alexander occasionally points out that you're much more restricted to license than you would be not licensed.
As far as investments?
Yes.
Well, we would like both sides of that. Obviously, when you invest in a property, it does take time before, for instance, I just recently sold my property on 33rd Avenue. Well, there was a zoning change that had to take place. It took 6 months in order for that to sell. It was a lucrative investment to start that home. Luckily, I had an offer to purchase on it, but it took 6 months for that. So in the meantime, I could have utilized the fact that I had a license to continue to accrue income if I had a license.
You'd expect to also work with third-party buyers and sellers, not just for your account. Is that a safe statement?
I think what he's saying is you want to list and sell property belonging to other people.
Yes.
Thank you, Bear, for understanding what an East Tennessee boy meant to say.
I've always had an interest in real estate, you know, from a young age anyway. So I've always wanted to sell homes, and so buy and sell.
We also do have an interest in the franchise itself as far as Exit is concerned. We feel it's a very good company with a lot of potential, and looking at a franchise in the future is also something that we are interested in. But in owning a franchise, it does take time to generate income. So in order to offset that, it would be nice to be able to have our license to also sell in that respect as well.
Anybody have any other questions? If not, we're going to...
Wait a minute, yeah.
Yes,
Yes, Commissioner Bloom, I'm sorry.
In the write-up, Mary, Alexa, you wrote that in your dust-up there was a mallet involved, and Linda, you identified it as a knife.
Oh, I probably just, yes.
Well, in the write-up, it stated a knife, actually, but it was a mallet. We had a heated argument that morning that I felt threatened in a way, when she approached me when we were arguing, and I picked that up just to basically state, please don't come any further, because I had called the police because Alexa was mad and was talking with her girlfriend, and the girlfriend is about 6 foot tall, and stated that she was now ex-girlfriend, stated that she was going to come and beat me up. And so I called the police, and I did have the mallet, just to make sure, that no one was going to attack me.
And had the police not come, she wouldn't have used it. I know that. So, because of Heather.
Let me just ask one other question. I think the felony was some time ago. That's kind of history for me. But a more perplexing thing is that you, Mary, just were taken off probation in 2010.
With Heather.
That was a misdemeanor, I understand.
That was Heather, the one that caused this between us.
I understand. But how can you convince us that we won't read about you in the paper in 2014?
I think because, I think because I've allowed myself to get involved with someone that I should have known early on, and I did see signs, and why we do the things we do and go ahead with a relationship and stay in it for a little while, I don't know. But I do know that I'm in a different one now, and this person is just totally different. It's just night and day. So to be in an abusive relationship and to come through that and survive it, you come on the other end of it and you go, I'm going to be better at, identifying that in a person from now on. And, I knew that she was the reason that Linda went to jail. Heather was. And then later down the road, it ends up putting me in jail. She went to jail first, Heather did, for hurting me. But she made sure a year later that I went when I finally kicked her out and got her out of the door. She made sure she turned that story to my neighbors and had the police called so I could pay for sending her to jail. But, long story short, I had to have a restraining order against Heather and keep her away from me. And, life is so much better now. And I'm thankful for even coming through that trial, my life. I am. I'm thankful because it's helped me to identify that kind of person and be able to, make better choices. And, I'm not a weak person by any means, but I think I have too good of a heart sometimes, and I think that I was trying to help this person. She had a drinking problem, and it almost killed me.
I have a question.
Mr. Haynes.
I'm confused at your intentions because you mentioned, are you going to be buying the franchise?
Well, we are looking into the future potential of franchise for Nashville, the Nashville location. But the owners have just recently acquired the region, and so we're not sure yet the availability of a Gulch location. So we are looking at that for future potential.
So in the meantime, are you going to be a team, a real estate team together?
We would like to be.
And will there be other agents that what's your intentions there?
If we just solely worked as in the
right now
as
you're
an
going to work
affiliate
as a
broker,
team, and then eventually you want to buy the office and then have agents.
we would like to. Obviously, you'd like to measure success first and in sales to be able to see if we can establish a good franchise. I do know that we are a good team together. That's why we chose to do this in the sales aspect of it first.
If I could interrupt here just for a minute, Commissioner Haynes, I'd like to hear the relationship between these two individuals, if we vote to grant them to get their license, what their relationship with is going to be with their principal broker, Dorothy Lee. Tell us a little bit about your company and how you're going to, how all of this is going to play in. Because you're going to have two ultimate team right here, sounds like. But tell us about your company and what you're going to be doing.
Yes, sir. I am the managing broker of Exit Realty Extreme. We opened this franchise just a little over a year ago. I used to own my own company in Mount Juliet, D. Lee Realty and Associates, and I just got tired of struggling and trying to fight the big mouse, I call it. Excuse me. So I did a lot of research and decided I wanted to be a part of something larger. Research Keller Williams, Remax, and Exit was kind of new to the area, but they were just slamming, and I had to check into them, and that just told me that that was where I needed to be. I also, in my 5-year plan, I do hope to own a franchise as well. I met Linda and Lisa through another associate through my company, and actually I look forward to doing some teamwork with them as well. With me being from Mount Juliet, my prior company being from Mount Juliet, and I represented a builder for 7 years, I kind of stayed in that area, but I want to tap into the Nashville area, and I feel like that Alexa and Linda are going to help me do that. I don't speak for anyone lightly. I've been a broker since 2002, and I take my career very, very seriously. I would not put my name or my license on the line for anyone, and if I thought that they were a risk, I wouldn't do that. I feel like that they are going to be a benefit not only to Exit Realty Extreme, I also feel like that they're going to be a great asset to the franchise itself. And I'm hoping that with their help that I can tap into the Nashville area, because it seems to be where we're having a lot of growth, as well as I plan on tapping into Mount Juliet. I do know that they've had a lot of business success. We all make mistakes. I've made my own, and hopefully that I believe that they have learned a lot from it and grow from it, and I do believe that they will be an asset to the franchise and the company.
I have a question. Do you own this franchise, or are you just the broker?
I'm just the broker.
Chairman, a question. Does Exit Realty have their own mentoring program, or do you have a mentoring program on your own?
The franchise.
Is it company policy?
Will you state that question again, please?
Does Exit Realty, as a franchisor, do they have a defined mentoring program, or do you have any mentoring program? Who's going to take these kittens and make them into full-blown cats?
The franchise itself does have a great sponsoring and mentoring program, and as the broker, I am the one that's going to be training them individually, but as the whole franchise, the international franchise, actually has a lot of good training and mentoring programs that he has to offer our agents. And none of our agents come on board and are just set free. We actually have I believe it's just was printed out, I believe it's a 90-day plan, step-by-step plan to help these girls follow our procedures and get them on board and showing them how to go about getting their listings and getting their sales and how to do it and follow the ethics and all the contract rules in addition to what they get through the Real Estate Commission.
Ms. Lee, you're saying you're going to do it?
That's right.
Good.
With the tools of the franchise, with the franchise.
Tell me again how many agents you have under you.
I believe I have 22 right now.
22, so this will make 24?
Yes, ma'am.
Are any of those new agents, or are they all seasoned?
Some of them are new agents, but actually we're getting ready to clean the roster a little bit, so I think I'm getting ready to probably let about 4 go.
And your office is located where now?
In Madison, across from Rivergate Mall.
Okay.
Commissioner Grease?
So, Ms. Lee, you're not the owner. Is the owner of your franchise aware that these ladies would like eventually to be competition for him? Or am I misreading what's going on here?
Yes, sir. They are very aware, and it's kind of a unique situation because the owners of my franchise just bought the Tennessee region of Exit Realty.
So they're looking for more investors, for lack of a better term?
Yes, they are.
Sound like to me, whoever bought the franchise for Tennessee would love to have another income-producing office somewhere.
Well, I know, a lot of times agents work for a broker and then proselyte their agents and go open up another store somewhere, but that's the plan, and it's announced, and the owner is comfortable with it. Is that?
Yes, sir. That is the plan.
All right, thank you.
Are the owners aware of the situation these ladies have been through?
Yes, sir. They both are. We all 4 met together. And both of these girls come up to myself and the owners and sit down and told us the whole situation.
They actually did want to come on our behalf to speak, but we were told that it probably wouldn't be accepted. But they would be welcome to a phone call if you need that as well.
Mr. Chairman, I'll move that Ms. Byrd and Ms. Bass be allowed to continue on their path to getting a license here in the state of Tennessee to sell real estate.
We have a motion by Commissioner Grease to grant the application request
Second the
for
motion.
licensure for Linda Byrd and Mary Alexa Bass, and it has been seconded by Commissioner Flitcroft. Is there any discussion on the motion? Hearing none, all in favor say aye.
Aye.
Opposed, no.
Mr. Chairman, I'd like to abstain.
And I also.
Let the record show that Commissioner Bloom and Commissioner DeShara abstained, which makes the vote 7 yes and 2 abstentions.
Mr. Chairman, may I raise a matter with Ms. Lee?
Yes, you may, while everybody's here.
This commission for the last 6 months has been toying with what we think is a bad word, and the bad word is a team approach to real estate. There's nothing wrong with having a team, but the problem is if the team doesn't include the principal broker, it's in violation of the existing rules. And John Grease here has spent a lot of time working on this. Let me encourage you to look at some of the past tapes. John, we got rules coming up at some point in time, but the whole concept is you're the principal broker, you're going to stay the principal broker. Compensation needs to flow through you, not through team members, and we don't want to erode a principal broker. This commission cannot manage 23,000 realtors, but we can manage 4,000 brokers, and that's brokers' responsibility. I just want to encourage you to take some time. John, what's the best way of doing it? Look at some of the tapes of what we've done, or wait for the rules, or?
We'll have a discussion later, but the deal, bottom line is, this commission, and I think the trade association that you all belong to, believes that the firm is who a property is listed with.
That's correct, sir.
There are examples of teams where a team captain or head of the team or whatever they're described as says, this is going to be my buyer's agent, this is going to be my seller's agent. That's not their decision. That's your decision as principal broker. And so if you have teams or call teams or any other collection of licensed individuals inside your firm, you are still in charge. They don't make decisions without your approval. And you're the one we will hold accountable, bottom line. And
Yes, sir, I'm aware of that.
May I elaborate on the team is on my explanation?
Let me caution you. We've already approved you, so if
Oh, yes,
if you,
sir.
Okay.
I was just
you
saying.
don't have to sell it.
No, sir.
Don't talk us out of anything.
No, sir, I definitely would not want to do that. No. Our team effort, I think, is what I mean by that is Alexa and I will make joint efforts in networking, sending out cards and things like that, not as a team of like splitting commissions or something. I just mean as a team working out there, getting our name known, even if it's sharing in the expense of postcards and farming the communities.
I think our point will be to you is that anything you send out that indicates you two are working together needs to be not subservient but no greater than the name of the company that you're affiliated with. And that's your broker's responsibility to make sure that what you send out meets the standards this commission is the statutes have put in place. So anything you do, you need to run by her first. And if something's screwed up, we're going to go to her because we don't have time to go to all the affiliates. We'll go to principal brokers and hold them
We certainly
responsible.
will.
One thing you need to understand for sure, one of you can't represent the buyer and the other the seller. If you're a team, you cannot do that.
I think we just mean from a advertising perspective.
But according to the direction of your principal broker and
I will make sure of that.
thanks.
Yeah,
And advertising, if I might, advertising is probably our biggest concern.
because Ms. Lee, you make sure you supervise these two agents.
Yes, sir, I will, at all times.
Or you will be back.
Like I said, I work too hard to keep my broker's license, and I'm not gonna let anyone risk it.
Ms. Lee, I have one question for you.
Yes, sir.
When you advertise your exit business, do you advertise it as it's registered with the Tennessee Real Estate Commission? The whole name?
I haven't advertised the company, sir. The franchisees did, and they haven't really done much of that, so. I've been too busy taking on broker agents and training, so no, sir, I've not really done any advertising. But I have a question for you, please. So when there is advertising done, it needs to be advertised as K&S Homes, LLC, DBA, Exit Realty Extreme, correct?
Whatever the name of the firm is. But anyway,
It's got to at least be a DBA, right?
Yes, sir, it is.
You got that name, just the DBA name.
Licensed with the Tennessee Real Estate Commission. In Ms. Lee's case, it is K&S Homes. Is that right? Inc., DBA, Exit
is correct.
Realty
Yes, ma'am.
Extreme, I believe, is
Yes,
what
ma'am.
it is. So that's the way it's licensed with TREC.
Sign ought to have all the K&S and Exit Extreme.
Yes, yes.
Okay,
All right, let's move on, Mr. Chairman.
okay, I'm ready.
Sure, and check back
Thank-
and look at the rules that we're going to go over today, and hopefully they'll be clearer by the end of the day. But be sure and look at
Ms.
it.
Lee, if you want to stay for part of it here, you're more than welcome.
That would be great, because now you've raised some questions. Did I understand that you said that the real
Well-
estate signs have to have that on there?
Miss Lee, and we have our Assistant Commissioner,
Okay.
Bill Giannini here, who's waiting to come on to the program. If you want to stay around after Commissioner Giannini speaks before us, brings his presentation, we're going to have a short break, and at that time, if you just want to sit back there, you can discuss some of this with the Commissioner. But anyway, I just want to say...
We posted on the website also.
Miss Bird and Miss Bass, good luck, and
Very much.
I hope you...
Thank you.
I wish you success.
I appreciate the opportunity.
Thank you.
Thank you.
We take a break?
No.
Okay, good. Let's get Bill up here then, let's go.
Commissioner Giannini, you're next on the program. Go on.
Okay, Gropey.
Good morning, Mr. Chairman.
Morning, Commissioner.
How are you all?
We're fine.
Good. I understand y'all are right up against a break, so I'll make this as short as you'll allow me to.
If we all get up and walk out on you, you'll understand, right?
As we promised last month at the meeting, we would come back to answer a few questions that you had. Before I start, did you guys have anything additional or has come up this morning? Because I will proceed right into this if you don't.
I'm mum.
Good. Thank you. I appreciate that very much. You guys had asked about the copy of the actual versus the budget. I think Steve just distributed that to you. You have that now in front of you. You certainly can look that over and ask any questions that you like. If you'd like to take it back with you and digest it and then bring it back next month, you can do that as well. So,
Commissioner, when does the fiscal year 2013 end?
it ends in June 30.
It ended June 30.
Right.
Okay.
This
Yeah,
is-
2/3.
that's our
So this was for last fiscal year?
Yes.
Correct.
Okay, thank you.
So can I just follow up on that? So since we were like 400,000 under, did the 2014 budget reflect a decrease budget number? We haven't seen that, I don't guess, or is it still approximately 1.6 million?
It is the way that you're, and it's one of the things that's a little bit misleading about the way that the budget process works. You're appropriated money each year at the beginning, and I'll let my accountant step in at any time when I misspeak. She's much more adept at explaining this than I am. But you're appropriated money each year, and it's typically based on historical data. And so the fact that you've come in considerably less than we expected was not unexpected. I think we talked about in the meeting last month that there was a point during the year, all we have to look at is your budget and your actual numbers at the end of each month. And there was a point last year where we were greatly concerned that you might actually come in under budget or overspending. But that also calculates, based on the previous year, your overhead costs that are charged to you are based on the previous year. When we look at the end of the year, when you're actually billed, that number drops substantially because you had a decrease in activity. So you benefited from that. It says that the process works, that you are being billed fairly for your consumption. Does that answer your question?
That's a good explanation. I'm sure your accountant could have done a better job.
I'm sure she could too.
But our 2014 budget is about 1.6.
It's actually 1.9.
Really?
Yes. And that that includes anticipation of raises and increase in costs. And actually, each month, I'm looking at what's in your packet. Your budget is actually called your work plan, and you can see that alongside. But I'm more than happy to, provide just the budget to you at another time. I can send that to Ms. Maxwell and have her forward it to you.
I don't think we got the work plan.
It's actually on your iPad.
Oh.
okay.
Under the budget, it's a few pages in, it's kind of small. That's why I said I'm more than happy over the course of the next few days to provide that to Ms. Maxwell, and she can forward that on.
That's cool. I just want.
And you are taking into account that it looks like agents are picking up and more people are testing, and you understand that there
Well, again, when
may
you're-
be more business.
Right, but when your budget is prepared well in advance, I can tell you that at that time, we have taken a very cautious approach to that. And because in spite of the fact that the economy and the market may pick up temporarily, I don't think yet anybody's willing to step out there and say that this is a long-term improvement to the economy. So we continue to be cautious.
I just don't want the staff to be so overworked that they, okay.
Mr. Giannini, a question there, or just a comment. We lost, partially by retirement there, but in the long-term loss, the auditors, with the expectation that we would need more investigators or more investigative service. Does this budget proposal take that into account?
Yes, sir.
When you can come in under budget like this, that's a good thing.
Yes, sir.
It ought to be in the newspapers.
Should increase the next year by 300,000 more.
I was going to say, I'm being a little feisty today. How much of that $300,000 increase is due to Obamacare?
He's not answering that.
I'm being facetious.
No comment.
No comment.
Looks like almost the entire $300,000 increase is under the state professional services line.
That's exactly the point I was making, that because, again, all we have to go on is your actual budget that's already in the books and your actual numbers. And because a decrease in activity, when you are using less resources, it's going to result in a lower charge at the end of the year for your attorneys, for your administrative staff, the things that you're billed for. So that is the result of that. That's exactly what that was. And it is not a perfect system, but it is the most fair and equitable system that we can come up with when distributing costs across 24 different boards to do. And I think this is a great example of how that system really works to your advantage.
To Ms. Maxwell and to Commissioner Giannini, we are at 15 staff now, Ms. Maxwell?
We have 17 people on the staff.
We have 17. Do we, as the number of licensees is slowly increasing, I just wonder if, how long we will be able to maintain that current level of employment in the department.
Here you're
Yeah.
asking Assistant
That's
Commissioner
what I just
Giannini.
asked.
Okay, I
Yeah,
apologize.
I mean, I think that Assistant Commissioner Giannini and I have talked about that and what the staffing needs might be, particularly as the fingerprint bill comes on line on 1/1. And I think that we'll be in a position to fill whatever need that we have. I mean, not like hire 100 people, but we would be in a position to hire an individual perhaps if we needed that once the fingerprint bill starts.
And I have one more question. I don't know how the budget's put together, but it's part of the reduction because we are no longer having hearings for errors and omissions and the change in the law, because we were spending hundreds of thousands of dollars on hearings. So that would be part of that reduction, I would assume. Okay, good.
Just to add to what Director Maxwell said, we have talked about that. We certainly, I think now, given the fact that the economy seems to at least be planing out and that you are actually seeing a very small increase again, that certainly feel better about adding staff as needed than we did, 18 months ago.
Mr. Genie, I would appreciate if you can. I don't want to create an accounting nightmare because I've seen it before, but the legislative changes which allow suspension of bad boys and bad girls who don't keep their E&O up, I would hope that that has some very positive results with this commission, and I'd appreciate an update maybe at 6 months or something so we can see how we're doing. Is that trackable?
Not what I,
Well,
just,
Hey,
it's,
may I
that's
address
that.
that for a moment?
Yeah, you please do.
The period for E&Os is not present this time this year. So you know, it would have been from June until December that you might have seen the difference in this year. After that, it's another 2 years before it comes up again, if it comes up again. So as far as hearings going, they're done for the year. So he would have to look back from June till now. It would have been, in this 6 months, I would have had the hearings.
Anybody have any commissioners have any questions of Commissioner Giannini? I want to say thank you, Commissioner Giannini, for the way you have been working with all the boards, not just this one, but the other boards that's under your authority. But I think you're doing a good job, you and your staff.
I did want to have one more comment. I heard it through the grapevine that Commissioner McMullen wanted to talk about CORE. And
Hey,
am I misinformed?
no,
I don't know what that is, so didn't even know that I wanted to talk about it.
The new licensing system.
Oh, okay.
Is that?
The computer system.
Okay. Well, there was a question brought to me that I thought I would use this opportunity to talk to you all and make sure you understand. The question was presented to me as from you, whether or not that's accurate or not, but that you were concerned about the board running in the red paying for the licensing system. And we have actually been able to, through talking with F&A, we've determined that we can pay for the licensing system from your existing reserve. So we will not impact your current year revenue at all, which is fantastic. It is, and we're going to be able to do that division-wide. So you won't run into, despite the fact that you didn't ask the question, I'm here to tell you.
I may have asked a question about that some time ago.
You did. All right. So have no fear that you are, that your current year revenues will not be impacted at all going forward. We will be able to use that, put that money to good use that has been sitting there heretofore.
Thank you for that explanation.
You're very welcome. And call me anytime.
Austin, thanks for bringing that up, too.
Does anybody have any other questions of
Are you
Mr.
going to join
Giannini?
us for lunch today?
I wish I could, but I can't. I already have commitment. So, but thank you. You guys are having your Christmas. I may try to stop
Here.
down for a minute or two.
Yeah, just stick your head in the door if you
Come by
can.
and see us.
We'll do it. Thank you.
Merry Christmas.
Thank you for coming.
Merry Christmas to you all.
This time, we're going to take a 10-minute break. Call this commission meeting back into session. Next on our agenda, I think, is our legal report.
You think right. I don't. I've just been asked if I have time to complete this before lunch, and the answer is no. The food is prepared in here, so I will get as far as I can prior to lunch. I should let you.
Priority straight. Food's more important.
I will tell you that unfortunately I do not have the ability to be an auctioneer, as does Ms. Kropp, but I will do my best. I will also tell you before we get started, many of these cases here today, I have the knowledge that you will have here, that so that if there's a specific question for some of them, I may have to have a chance to look at the file. I will also tell you, though, that the majority of these issues have been discussed already between Julie and myself, so I hopefully will be able to address the question. But since I am not the board attorney, I just wanted to let you know I may not know the answer as quickly as she would. Before I get started, I would like to read this into the record. Any consent order authorized by the commission should be signed by respondent and returned within 30 days. If said consent order is not signed and returned within the allotted time, the matter may proceed to a formal hearing. Number 1, 2013-011341. This was presented in the November 2013 meeting. Complainants were licensees, and respondent is the principal broker of a licensed firm. Complainants state that they entered into 2 leases, a 12-year month lease and a 6-month lease, with a company which is substantially the same name as the firm for which respondent is principal broker, except the firm with which complainants state they dealt had a division name added to the end of the name. Complainants state that the property was not habitable, so complainants moved prior to the end of the second lease term. Complainants state there was a broken window at the time the complainants moved in, windows were not airtight, and the door was not airtight or windtight, as well as other issues which complainants state the company refused to repair. Complainants state there were a number of matters which were not handled in compliance with the Landlord-Tenant Act. Finally, complainants state that they were sued by the company, which included the division name, and are in a legal battle. Complainants state they received a letter from the executive director for the Tennessee Real Estate Commission stating the company with which complainants dealt was not a licensed real estate firm. Respondent states the complainant signed a 1-year lease and then another for 6 months. Respondents state that all monthly payments were paid until January 2012 when complainants move out, breaking their second lease after purchasing a home. Respondent states that all tenants are asked to send a list of any issues with the property prior to moving in, and such a list was provided by complainants. Respondent states that the list included for a cracked window, and the lease provides that the tenants accept the property in an as-is condition. Respondent states there was nothing filed to request the window be replaced, or that the response were giving a 30-day notice. Respondent states that a lawsuit was filed and a judgment was entered against the complainants. This has been appealed, and the appeal is currently pending. The respondent states the respondent's firm is a licensed firm in the state of Tennessee and addresses complainants' allegations if they were alleged against the respondent's firm. Respondent does not specifically address the allegation regarding a company with a substantially similar name which dealt with complainants and which does not have its own firm license. Based on the internet search of the company which complainants state they dealt, it appears to be an LLC registered with the Secretary of State. Respondent's licensed firm is also registered with the Secretary of State as a corporation and also has a website with the company's name at the top of the webpage, which states it is a property management company. Website also includes the name of respondent's firm at the bottom along with address and phone number, but the phone number does not match the firm telephone number of respondent's firm as displayed on respondent's firm's website. Additionally, complainants provided copies of the lease agreements, which include a letterhead of the company with its division in its name and a security deposit check, which was written to the respondent's firm but was stamped deposit and account, including the name of the company with division in its name. In light of recent discussion regarding topics of a substantially similar nature, it is recommended the commission discuss this matter, and the recommendation was discussed. The decision of this commission in November was the commission voted to defer the matter to allow Commissioner Grease to review the file and report at the next meeting. So the new recommendation is to listen to Commissioner Grease.
Commissioner Grease.
Thank you, Mr. Chairman. You all look different from this view right here, I would say. Especially you, Bear.
Are we scary?
All I usually see with the bear is his ear, and now I've got full frontal on him. It's not good.
Does that mean we're scary?
I'd prefer the ear, that's right. All right, here's the kind of my quick analysis. Throw out anything that has to do with condition of the property. It's being handled in a lawsuit. I don't think that's an issue that is an issue at this point. The question before this commission is this. There's a real estate company that says it has a property management division. However, the real estate company registered with Secretary of State has a name different than the property management division. So two entities, both separately registered with the Secretary of State. The property management division does not have a firm license. The real estate company does have a firm license. The property management division, if you want to call it that, has a separate website, separate phone numbers, separate escrow account. So, in my opinion, the question before the Real Estate Commission, and I'm happy to give you my opinion at some point, is the fact that these two entities are in the same building, maybe in the same office. Does that, because this property management division has a separately registered name with the Secretary of State, separate website, separate phone number, but not registered with the Tennessee Real Estate Commission as a firm, so there is no principal broker associated with this firm, is that a violation that we ought to consider handing out some sort of punishment to? So that's my quick summary. I hope it's clear, but I'm certain that it's not. So if you have questions, I'll be glad to try to answer them generically.
Commissioner DeShar.
Well, I want to know what your opinion is on that.
Well, my opinion is, personally, but it shouldn't flavor your decision. You might want to wait and see if there are any questions before I give it to you.
I mean, just from first read of your quick synopsis, it almost looks like there's a company that's affiliated with the state of Tennessee and does not have a firm license. It almost seems like to me some unlicensed activity.
I think the broker would argue that even though they're two separate firm registrations, in all practicality, it's the same company.
Does this not go back to that discussion we had, which would apply to commercial division, property management division, investment division?
To me, this is a little bit different than the discussion we've had before, because that was all incorporated, in my mind, under one corporate structure. These are two separate corporate entities. My guess is the property management is incorporated to provide some sort of liability shield. I mean, that's why most incorporate to do that. But these are two separate entities.
But the people affiliated with the property management, their licenses is with this firm?
Correct.
So they're licensed with the firm.
Let me say it a different way. There are no licenses associated as registered with the Real Estate Commission with this property management firm because it doesn't even have a firm license.
John, can I ask you another question?
Sure, Gary.
Are there any employees of the property management company that are unlicensed?
I don't know that. I will tell you that the response to the complaint was handled by the broker of the firm registered with the Real Estate Commission. But I don't know about employees and how the property management division, separate entity.
I mean, if they're unlicensed, they could not function in any capacity with, other than keeping books or something, but they couldn't show or list property.
This is a lease type thing instead of a sale thing.
Yeah, but you couldn't show and lease without a license.
Well, and so the question before the commission, as much as anything, is this property management entity an unlicensed firm? I mean, that's the question that's in front of us.
Okay, I have Jones Realty, I'm the principal broker. Then there's Smith Management Firm.
LLC, let's say.
LLC. So Smith Management Firm has employed people that work for Jones Realty. They're all in the same building, but their advertising is property managers. And
have a website.
And have a website. So Smith over here is, I think they need a license, and I think they need a broker.
I think they're practicing unlicensed activity.
Because if they're registered with the state, they need to be registered, unless they're selling their own properties or managing their own properties. It's a different story.
That's not the case.
Ms. Maxwell, this is a question for you. If we were to send an auditor to that firm and audited the real estate books, would they not also audit the property management books? because there's an escrow account there? I mean, would they have that authority to do that?
Well, I don't know what you would find at this particular location.
No, that's
but-
just a general question. If they came to my office and I
Right.
have a property management company, they have the authority to audit my property management books just the same as they do.
If it's licensed with the Tennessee Real Estate Commission, yes, they do, to make sure that the escrow account and/or security account is, kept up and you've got records for the last 3 years and is being properly.
But if they're not licensed, who?
Well, if they're not licensed, the auditors in the past have asked if they could come in and audit, but we cannot force a firm to allow us to do that that's not licensed.
I think, though, in answer to part of your question, that issue can and does come up, but it's not normally going to come up when both entities are in the same office as it was here. And this is something that is operating in the same office, so the question is exactly what Mr. Grease was saying, is that whether or not this entity that's involved in the same thing needs a separate license.
I don't know how they could not be practicing unlicensed activity.
Know anything about the ownership of the licensed entity and the unlicensed entity?
The only thing I can tell from my review is that the broker of the licensed entity answered the complaint which was filed against the unlicensed entity.
I think that it's fair to say, I did review this one, so I think it's fair to say, in this situation, it was an entity with a separate division going on inside, and yet everybody that is licensed was involved in it. And the question is really, is this separate entity that is advertising by itself, using all the same employees, basically as the licensed entity, everything in it, but
Other name?
advertising by itself as a property manager needs a separate firm license.
But a violation for a person who is licensed to own an entity that's engaged in unlicensed activities.
Sorry, say that again?
We're talking about possibly it's unlicensed activity, what the property management company is doing. But is there any violation if a person who is licensed owns an entity or controls an entity that itself needs a license but doesn't have one? Is it a violation by that licensed person?
I don't know that there's exactly anything in the statute that exactly addresses that. This particular complaint, though, you should know, is against the principal broker of the licensed entity,
Right, but
who
we're
is
talking
acting on behalf of the unlicensed entity.
right.
So you're asking is what punishment could be against that principal broker for acting on behalf of the unlicensed entity, right? I don't know that Julie had a record. Did you?
I got a question.
I know that 309 requires each firm to have its own license and its own principal broker.
See,
So it could be under 312.
If I'm in
Yeah,
the same
it could be-
building, I
It could
can,
be under 312 for substantial misrepresentation in the act, so the principal broker could be for that.
if I'm in the same physical building, I can be the principal broker of both firms,
You can if both firms are licensed, for sure, there's no question about that.
even though they're not the same company.
Right.
Right.
I got one of them. I'm registered with the state.
What Austin was asking is and we were just looking at this, what can you find, if you find there's a violation against a principal broker for representing basically the acts of this unlicensed firm? And there's nothing exactly that speaks to that, except for 312 does say that you can't make any substantial or willful misrepresentation, and by acting as the broker of an unlicensed firm, or a firm that should be licensed, it might be willful misrepresentation.
If I have a rental firm, have I got to be licensed if I run it under my same company?
Well, that's the question.
I don't think so.
That's the question you're having today.
But it's not under the same company.
It's a
two
different
separate
name.
corporate
It
entities.
is a separate court, it is a separate individual.
What if I
'cause
don't
it's a-
have it as a separate corporate entity?
That's,
But this
that's
does.
different, that's different in this situation.
This one is.
Yeah, but yeah, that's the question at hand. This one is.
John, who is the complaint against?
The principal broker of, that's what I said, it's a complaint against the principal broker of the licensed firm.
I'm not,
Well,
my
you-
recollection
you-
is it was against the property management division.
It's against the principal broker of the licensed firm.
John, you said it's against the firm.
My recollection, and I'll yield to our attorney, is that it was filed against the property management division. The broker of the firm responded on behalf of that, on that property management division firm.
I think we got the wrong guy.
I believe it's
Let's take a look.
opened against the principal broker. That's what my notes say, but let me check the file for sure.
If it is against the principal broker, he of all persons should know that it should be, his property management should be licensed under the same name.
It is against the principal broker of the licensed firm. Thank you. That is what this was opened against. Thank you.
John, can I do this? Okay, I own a real estate company, and we list and sell real estate, and I'm so successful that I've got 10 properties that I manage, and it's just too busy for me, so I have an unlicensed person handle that for me, my secretary. That's a violation of the law. She shows the property, she collects rent, that's a violation of the law.
Right.
Why is this not?
I'm not, I've got a recommendation in a minute, so I won't, I'd say on your recommendation, what you discussed is a clear violation.
Don't keep
I
us
don't
in,
know how it's different.
don't keep us in suspense any longer.
Oh, is either other
What's your
question?
recommendation?
Here's kind of one more factoid. So when this tenant wrote a check, they made it out to the licensed firm, who stamped it on the back and said, for deposit only, and put the company, the other unlicensed firm's account name on the back of it. So it was coming into a licensed firm and then being deposited into an escrow account that belonged to the second entity. Here's my recommendation. In my mind, this is solved fairly easily if the principal broker of the license or the firm registered with the Tennessee Real Estate Commission also became the principal broker of the property management division. He can do that. As Mr. Alexander stated, they're in the same building, maybe in the same office. So my recommendation, in my mind, that unlicensed firm is practicing real estate, a form of real estate without a license. I think they're guilty. So my recommendation would be to fine, if it's against the principal broker, $500, make them come to a real estate commission meeting within 180 days, and within a certain period of time, and you all may want to discuss this, as a condition of this, what do we call these things we're offering to them? Consent order, that he become the principal broker of the property management entity within a certain period of time. So I have three parts to my recommendation: $500 fine, attend a meeting, and become principal broker of the property management firm, or set that up as a firm licensed with the Real Estate Commission where he would be
Yeah,
also
that's
the
my
principal
question.
broker.
May I address that? I don't think you can do that part of it. What you can say is he must cease and desist behavior for this, acting as the broker for the unlicensed firm. I don't think you can make him become unlicensed firm.
It's either got to license it or quit.
Well, then can we fine the unlicensed firm for operating without a license and a principal broker?
We would have to open a complaint against the unlicensed firm and present the facts, which you can do, but that's what would have to happen. This is against the principal broker alone.
Walk us through that.
You know, and
Well, what happened is this time, is the issue today is, and Mr. Grease has analyzed it all correctly, but the issue today really involves this principal broker and his responsibility. As I indicated earlier, under 312, if you found, to be specific about it, you could find a violation under 312, willful misrepresentation, as holding himself out as a principal broker of a firm that is not licensed. and he is not the principal broker, you can tell him to cease and desist acting in that way, but as far as making him the principal broker of this unlicensed group, you do not have the power to do that.
Well,
You could open a complaint against the unlicensed firm for the same activity and tell them they have to get a license, yes.
If we put it in a consent order and he agreed to it, are we okay?
They don't have the power to do that. There's no law that would give you the power to do that.
Mr. Chairman?
A law that says he has to come to a meeting? I mean,
Well, that's part, yeah, there is part of your policies that is as a term of fulfilling division of, but it's an employment issue, which you can't, we don't have power over doing employment. Help me, Mr. McMullen.
Well, couldn't you say, though, that we're going to open this complaint?
Yes, we could say
If you
that.
do not have
I'm
a
gonna make
licensed
the motion.
principal broker, we're about to go
We
open a
could, we
complaint?
could say, not in the complaint, we can say in the consent or cease and desist. We can say in the cover letter that this other firm needs to be licensed and there needs to be a principal broker there.
Sounds like there may have also, was there also a violation potentially of Section 312B5, failing to account for or remit monies coming in licensee's possession that belong to others? Because it sounds like this check was made payable to the management company.
It does, but what you have to do is account for it. I mean, it was accounted for. I mean, you knew where it was. I think this particular section has really to do with when there's a question about where's the money, how is it going, and you haven't made any accounting for it. This was accounted for. The issue is not really that we didn't know where the money was. The issue was the confusion about how it was all being handled. And it was held in an escrow account in both instances. So it's not like it was also not held in an escrow account either. I think that's harder.
Mr. Alexander.
Since there's no motion, I'm prepared to make a motion.
Have at it.
My motion is, I see a lot of confusion. I think it's a lot of other people's out here in this world operating the same way. And my recommendation is you write this broker and these two firms a letter of warning explaining where he's operating and how he's operating outside the law, if he's outside. And let him come to school for continued education here at the commission. No fine, nothing else.
So are you saying a civil penalty? I mean, a consent order with this in it, or a letter?
I'm gonna drop the schooling because you got to have a consent order. All I want you to do is write him a letter of warning and explain to him where he's in error. That's my motion.
One of the things you said, Commissioner Alexander, these two firms, there's only one firm.
Oh, there's two firms. He's got his own firm, real estate firm, and he's got his own management firm, and I'm of the belief from what I've heard that he's operating both of them, and that he is licensed. The only thing that
There's only one license, though.
There's two.
That second one is not licensed.
That's the problem.
Management firm is not licensed.
The management firm does not have a firm license.
No.
I think that's where we need to make some laws or policies or whatever, that a property management company has to be licensed if
He's
it's
got-
associated with a real estate
But
firm.
he's got both firms licensed,
No, they're
registered with
not.
the state
It's-
of Tennessee.
No.
He is licensed, the firm that he's working in is licensed, the property management division is not licensed, and that's the issue.
both are registered with the Secretary of State.
Okay.
One is with the Tennessee Real Estate Commission.
Yeah, they have the same name, it's a division of the same firm, but it appears to be holding itself out, that's the issue. It appears, and the question is whether it's holding itself out to be a entity that would require a license as this separate entity. That doesn't mean you can't still tell the firm that it's dealing with that this division needs.
Tell me,
a
ma'am,
firm.
what's the difference that and all these teams running around advertising if they're in business?
Well, I think part of the difference is when the teams are in business, the teams so far are not required to have a separate license, and all firms are required to have a separate license.
Mr. Commissioner, what's the time frame for the attendance of the meeting?
Mr. Alexander, Mr. Flitcroft, talking to you, get on up there so we can hear.
It's within 6 months, but if you do that, you gotta write a consent order. But if you wanna do that.
Well, let's see if you got a second. Is there a second on Wendell's motion? Is what?
I think your motion failed for lack of a second, Commissioner Alexander.
That's quite all right. At least I tried.
Does anybody
I'd like to modify his motion, just.
Well, just make,
Just start all over.
Just make a whole, I mean, there's nothing on the floor, Commissioner Collins.
I make a motion, we send them a letter and be done with it.
That's
A
what his
warning or
motion
instruction?
was.
Warning letter.
A warning?
Letter of warning.
That's what Wendell's motion was.
No, he wanted to come school.
Please.
No, he took that out.
Oh, I missed it. I'm sorry, Wendell. I second your motion.
We have a motion on the floor by Commissioner Collins to, in this matter, to send a letter of warning to the principal broker of the firm that is licensed. Do I hear a second?
Second my motion.
He seconded.
Or if you're gonna take his motion, I'm gonna second his motion.
Thank you, Wendell. You're a gentleman and a scholar.
We have a second by Commissioner Alexander. Discussion on the motion.
I just don't think that's strong enough, because I think
I
that
don't
principal
either.
broker knew what he was doing.
I agree with you, Janet.
I think that John's on the right track with what he has suggested, so I'm going to make a motion that.
Oh, we got a motion on the floor. We got a motion on the floor.
Let's
Let's
vote.
ju-
Did it
let's-
say-
we're-
oh, no, Wendell seconded
Let's
it.
vote on the motion. If you're against it, vote no. All in favor of the motion that was made by Commissioner Collins to send a letter of instruction to the principal broker of the firm license, say yes.
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 Opposed, say no. No. Call the roll.
2 noes.
We had more than 2.
And 3.
It's 3 yes, 5 no.
This is whether or not there would just be a letter of warning. The motion was to send a letter of warning to the principal broker of the licensed firm. Flitcroft,
Yes.
Haynes,
No.
Alexander,
Yes.
McMullen,
No.
Bloom,
No.
Collins, Grease, DeChara,
No.
Stevenson.
No.
Okay, there's 5 noes, 3 yeses, and 1 abstention for cause.
Okay,
So the motion
we're back to
failed.
square one.
I'd like to make a motion that we fine the principal broker for, what's the statute?
You're offering a civil penalty.
Offering a civil penalty
Is this for willful
for
misrepresentation?
willful misrepresentation, and I don't know what the statute number is.
62-13-312.
62-13-312C1.
B1.
B1. And in that would be a $500 civil penalty. We would also explain to him what our rules are and laws are. Can't do that?
Not in the consent order.
Not in the consent order. And then he should have some education. Within, what have we got, 3 months is what we usually do?
180.
6 months.
180 days.
6 months.
6 months, and I don't want to specify, I would think property management would be, but maybe we just ought to say, has anybody got any suggestion on education?
Actually, I think property management is where he would need to get some education as well as attend a commission meeting.
Yeah, property management, education.
Many hours?
4 hours.
I'm
going to throw that out. I don't know, what do we got, Steve, in property management? We got 4s and 8s?
We do. We've got, off the top of my head, I cannot tell you what the minimum and the maximum, but we do have plenty of property management classes in one.
I'd say a minimum of 4 hours.
Okay.
A minimum of 4 hours, and attend a commission meeting.
Steve, is there a class on just licensing requirements or something like that?
That's handled just in pre-license.
Okay, we have a motion on the floor for Commissioner Haynes to, in this matter, a civil penalty of $500 and attendance of a course in property management within 180 days.
Within the time frame of 180 days?
Yes, 180 days. That was in the motion.
A real estate commission meeting.
Call for roll call.
Well, wait a minute, I hadn't got a second.
In a meeting.
Yeah.
I'm going to second it when he finishes. He ain't got his ducks all lined up.
Is that just the 2 things?
That's the
commission
2
meeting.
things for right now, but I'm going to have another one after that. You want me to add that to it?
Yes.
Attend a commission meeting.
Well, we said to attend the commission
He
meeting.
left that out.
But I think it needs to be separate, that we start do an investigation of his operating without a license company.
No, that can't be in this motion.
Because I don't think
Yes,
that can
go
be
ahead
in
and
this
do it
motion.
separate.
No.
And that's what I was thinking about doing, that we do an investigation, but that can't be in this motion, so I was going to do a separate motion. Am I all right with that, Robin?
I'll second Michelle's motion.
Okay, we have a motion on the floor for a $500 civil penalty, 4 hours of property management within 180 days, and attendance of a TREC meeting within 180 days. Do I hear a second to this motion?
Second.
Second by Commissioner DeShar. Any discussion? Hearing none.
I call for a roll call.
Commissioner Alexander has asked for a roll call vote. Call the roll, Ms. Maxwell, please.
This is the motion by Commissioner Haynes was for a civil penalty of $500, education, 4 hours of education in property management.
Property
Yes.
management.
In 180 days and attendance at a TREC meeting.
Correct.
In 180 days.
Within 180 days. Flitcroft,
Yes.
Haynes,
Yes.
Alexander,
Yes.
McMullen,
Yes.
Bloom,
Yes.
Collins,
No.
Grease,
Use for cause.
DeChara,
Yes.
Stevenson.
Yes.
So there's 7 yeses and 1 no and 1 abstention for cause.
And I have another motion.
Let me explain.
Can I
Before
make,
you-
okay, before I do that, explain.
Since this party is not in front of us, I think the first thing you would have to do is request a complaint be opened against this separate entity.
Okay. My motion is to open a complaint against the entity that is not licensed. And that's all my motion. I don't know anything else I should add to it.
We have a motion by Commissioner.
Second that.
We have a motion by Commissioner Haynes to open a complaint against the firm that is not licensed, that is operating without a license.
Oh.
And second by Commissioner DeShara. Any discussion on the motion? Hearing none, I'm going to ask Ms. Maxwell to call the roll.
I think Gary had discussion. He had a question.
Gary, you got some discussion?
Well, I just wondered what we're trying to accomplish with that. We already know he violated the law.
I think part of what we need to accomplish there is to make him aware that he needs to get that firm licensed. And that he is, in fact.
I think we're doing that with what we just did.
Well, there's more to the complaint than just not licensed. And so we need to be I'm thinking we need to be very specific what we're looking at. We're not really looking at there was a broken window or whatever. We're looking at the unlicensed activity of the firm.
But that
And
other part's being handled in a legal matter.
I understand that, but they need to know where we're coming from, and without us opening up an a complaint against them, they won't know, well, why did they do this, I don't think, in my opinion.
Ms. Maxwell asked for roll call alphabetically.
Alphabetically? Yeah.
Well, okay, let me see.
You're great.
Alphabetically, okay. This is a vote on the motion to open a complaint against the unlicensed firm. Was that your entire motion? Okay. Alphabetically, okay. Alexander,
Against the motion.
Bloom,
No.
Collins,
No, and I want to explain why. We have these companies in Gatlinburg that are doing the same thing every day. We don't bring them in. We've got commercial realtors in Memphis, Nashville, and Knoxville that are having employees show property all day long that are not licensed, and I think we're barking up the wrong tree. No.
okay. DeChara,
Yes.
Flitcroft,
No, and the reason is that we don't have the Oklahoma statute, and I feel like we're just gutless when we do anything on unlicensed activity.
Grease,
Recuse for cause.
It's a new cause.
Still related. I have knowledge you don't have, let's say that.
Okay.
Haynes,
I know that.
Yes.
McMullen, Stevenson.
No.
Did I leave anyone out?
Nope.
So it's, 2 in favor of the motion and 5 against and 1 abstain, recuse for cause. So the motion fails.
Motion fails. Now,
Well, I want to thank Commissioner Grease for all of his endeavor in looking into this, and I really appreciate what he did.
Thank you, and I'd like to acknowledge Julie Gropp. Unfortunately, she's not here today, but she did yeoman work to help this poor boy out trying to understand what was going on. Thanks.
Pork chops.
okay, now, I have been asked by our assistant, what is
Administrative
Kelly's
assistant.
administrative assistant, our administrative assistant, that we break now, take a break for lunch with the staff. It is ready, and we will reconvene at 1 o'clock. Across the hall. Call this Real Estate Commission meeting back into session. Next on our agenda, we're going to dispense with the legal report and go to this informal timeshare salesperson applicant, Brandon Grissom, and Pam Johnson, the principal broker. Haven't seen you in a while, Miss Johnson. Yeah, if you would, you two come on up here and sit in these 2 chairs on the end, and Miss Ryan will swear you two in.
Okay. And raise your right hands. Each of you raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Excuse me. Ms. Brandon Grissom is here today before the commission. She would like to get a timeshare license. She has taken the test. She's here with her principal broker, Pam Johnson, who has had no complaint decisions against her. Ms. Johnson was first licensed in December of 1984. She became a broker that same year, and she became a principal broker, I believe, in 1999. And Ms. Grissom has disclosed to the commission that she has had a couple of accounts against her that were misdemeanors, and they involved the theft of money, services, or property. The first was that she did not return 3 VHS tapes in May of 2000. The cost of these tapes, she was 18 years old, the cost of these tapes would have been $164.59. She also had 2 worthless checks in January of 2001. One was for $47.93, and one was for $50. For these offenses, these misdemeanor offenses, she had concurrent suspensions that ran for probations that ran for 11 months, 29 days, and she had to pay restitution for the checks and for the cost of the VHSs. She completed her probation in January of 2002. She has since been a dental assistant, is that correct? A dental assistant? An assistant property manager and a property manager and a server. And I believe that's, you can fill in any blanks that I might have left there.
Yes.
If you would, I would like to ask you, Ms. Grissom, if you'd pull that microphone down and just sort of lean and talk into it. Tell us why you want to get a timeshare license.
Mr. Chairman, in light of the hour, and especially in light of the offenses involved, not returning the VHS, who here hasn't failed to return a DVD? I'm certainly, or VHS. I move we approve this lady.
We have a motion by Commissioner Flitcroft and seconded by Commissioner Haynes. We approve this applicant's request and get her timeshare license. Any discussion on the motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries unanimously. Ms. Johnson, we'll see you at some point in the future.
I think we've had the opportunity to ask Ms. Johnson all the questions we need to in the past.
Pam, you did the right thing.
We always do the right thing.
We appreciate it. We wish everybody who was in this industry was as conscientious as you are.
I do too. I assure you.
Okay,
Thank you very
thank you.
much.
Good luck, Ms. Grissom.
Thank you.
Next, we'll go back to our legal report. Ms. Robin Ryan.
Okay, we're on number 2 and number 3, 2013-012691, 2013-012741. These are TRECO complaints based on information published on a news outlet that Respondent 1 pled guilty to wire fraud relating to Respondent 1's receipt of money via interstate wire from clients and converting said money to Respondent 1's own use. Respondent 2 was Respondent's principal broker at the time the news story was released, so a complaint was also opened against Respondent 2 regarding a potential supervision issue. Said complaints were open. A copy was sent to Respondent 1 at Respondent 1's home address on file with the Commission. Respondent 1 was broker released by Respondent 2 after news of this incident was published. But Respondent 1 did not respond to the complaint. Soon after, Respondent 1 was adjudicated guilty of wire fraud and sentenced. Respondent 1 had already paid restitution to the victims years prior to pleading guilty in the sentencing. Respondent 1 failed to report this plea conviction to TREC as required by TCA Section 6213.312F, which requires that whenever a licensee pleads guilty or is convicted of any offense enumerated in the chapter, licensee must notify TREC of the conviction within 60 days of that conviction. Without timely notification and request for hearing, the section provides a licensee's license shall be automatically revoked. TREC had no records of Respondent 1 ever notifying TREC of this guilty plea or conviction for wire fraud. Therefore, once 60 days passed from Respondent 1's adjudication of guilty, Respondent 1's license was automatically revoked pursuant to TCA 6213.312F, and notice was sent to Respondent 1 via certified mail. Therefore, there is no action necessary from the Commission with regard to Respondent 1. Respondent 2 submitted a response stating Respondent 2 did not know of Respondent 1's activity until seeing the news story either. Respondent 2 states that Respondent 2 was told by Respondent 1 that the underlying occurrences happened 7 years ago when Respondent 1 was the owner of and affiliated with another firm which is now closed. After speaking with Respondent 1, Respondent 2 released Respondent 1's license. Respondent 2 states that Respondent 1 has not had access to any funds at Respondent 2's firm since affiliating there. There does not appear to be any failure to supervise on the part of Respondent 2. Therefore, the recommendation is closed as Respondent 1 in light of license revocation and to dismiss as to Respondent 2.
Move to accept recommendation.
I have a motion by
Mr. Chairman,
Commissioner.
when it says close, that means close and tag, I take it.
Closed. Well, there is no license at this point. It's revoked. I don't know what they do when it's revoked, but it is on the record as having a revoked license.
So if she ever applied again, that
She has to start from beginning.
We have a motion by Commissioner McMullen to accept council's recommendation, and second by Commissioner Haynes. Any discussion? Hearing none, all in favor say aye. Opposed, no. Motion carries.
Next, number 4, 2013-013131. TREC opened complaint based on information submitted to TREC stating that Respondent, unlicensed individual, is engaged in unlicensed activity and asking TREC to investigate. Prior to opening the complaint, TREC was able to locate only a Facebook page for Respondent's business, which includes very little information, and a few postings with links which appear for property listings on other websites from 2011 or early 2012. The links are no longer good. A complaint was opened, and a copy of information was sent to Respondent at the address found on the Internet. Certified green card was not returned, and no response received by Respondent. Due to the nature of the complaint, and because there is no response to the complaint information, and legal counsel was unable to reach Respondent, the phone number found on the website, an investigation was requested regarding Respondent's activities and business. The investigator unsuccessfully attempted to contact Respondent at all telephone numbers on the website and attempted to locate other telephone numbers for Respondent, but was unable to do so. Further, the investigator visited the only known address for Respondent and found the business closed and a lease sign in the window.
Motion to adopt recommendation.
I have a motion by Commissioner McMullen to accept council's recommendation and seconded by Commissioner Haynes. Any discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. Number 5.
2013-013311. Complainant, a licensee, sent an email to TREC stating that complainant believed Respondent's principal broker website which advertise a buyer's rebate offering is a rule violation. Respondent offers a potential buyer's rebate of 1% of the sales price, and the program applies when the seller is paying a specified percent of the sales price to the selling agency and when the sales price meets a specified amount. It is stated that this rebate is either applied toward the buyer's closing costs or by way of a gift card or by going toward services relating to the purchase of the home. The website further states that the rebate cannot be cashed to the buyer and includes the Commission's rule regarding gifts and prizes. Respondent's website also states that if the selling agency is structured differently, the respondent may have to devise a rebate on a different formula, and this will be discussed and determined up front with those who engage respondent's firm. Respondent denies any violation and states that the terms of the offer are detailed with examples, and the site also includes the TREC rule regarding gifts and prizes. Respondent states that the site specifies that each home buyer and circumstance is unique, and respondent reserves the right to offer or decline to offer the buyer rebate, but this will be discussed and determined up front for parties who engage respondent's firm. Respondent states the program is unique to each potential buyer and can only be achieved through direct personal contact and conversation. Respondent further states no cash is given on the incentive, and the incentive is based on something done or used, like a gift card, which may be used for goods or services but not redeemed for cash. Respondent further states that the payment of closing costs are subject to lender approval. Respondent further states that before offering the program, respondent researched other programs in other states, the TREC manual, and by speaking with the TREC employees, one of which respondent states told respondent that it sounds like you're on top of it. Respondent states the website explicitly states cash is not allowed as an incentive and may be only be paid to a real estate licensee. Based on your legal counsel's review of the materials, it is your legal counsel's opinion this offer does not violate the rule regarding gifts and prizes. However, in light of the unorthodox content of the offer, it is recommended that the Commission discuss the issue. However, in preparing this matter for presentation to the Commission, and as late as December 2nd, 2013, respondent's firm's license is expired and has been expired since February 1st, 2013, leading to the recommendation below. That recommendation being consent order for $1,000 for failing to have an active firm license in violation of TCA Section 6213.312B14 and 6213.309A1A, plus attended by respondent at one entire regularly scheduled meeting of the Commission within 180 days of respondent's execution of the consent order.
Motion to approve council's recommendation.
Second.
Commissioner DeShara makes a motion, we accept council's recommendation. It's seconded by Commissioner Collins, and discussion on the motion.
So, by doing this, does that automatically cause the firm license to be active again?
And they still have to get an active license.
Does she have to start
It's the firm license. The
I
firm-
understand.
Okay.
So you can't just renew it at that point. She's going to get assigned a new license number. That's kind of,
I can't answer that question because it's the firm license versus the individual license. This is against the individual.
individual's license is still active.
Individual has an active license. The individual is to whom this was addressed, and it's at the individual who is being disciplined for the activity because the license firm had expired.
Activity or the recommendation is only for the expiration of the
That's
of
right.
the license.
That's right.
Well, what about the other? You go drop it too and forget it?
Drop what?
There's no violation.
There's no violation on the advertising issues, which is the reason the complaint was open. And during the investigation, it was determined the firm license has expired. And Ms. Kropp is suggesting that because of that, it is perhaps misrepresentation, which is the quote that she quoted to in the section of the code, because the firm license had expired.
So it is against the agent and not the firm?
It's against the agent.
Okay, so she's
TV.
she's misrepresenting because she doesn't really have a firm license.
That's right.
And that's, okay, gotcha.
Any other discussion on the motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. Number 6.
2013-013451. Complainant was the renter of a property. Respondent is the principal broker for the licensed firm, which was the management company for the subject property owner. Complainant states that complainant terminated the lease 3 months early with permission from the owner and respondent, so long as the property was re-rented prior to complainant's former release from the lease. Complainant states that the tenants took possession and complainant's last month's rent was prorated accordingly. Complainant states that despite requests, there was no final walkthrough report given to complainant and the deposit on the property was not returned. Respondent states that the lease specifically stated that the security deposit is forfeited if the tenant vacates the lease premises prior to the end of the lease term. Respondent further states the complainant was reminded of this provision and told that the deposit would be forfeited when complainant notified respondent the complainant was planning on terminating the lease early due to the purchase of a home. Complainant disputes this. Respondent states that respondent told complainant that respondent would ask the property owner to consider a partial refund depending on the length of vacancy, the property conditions, etc. Respondent further states that even though this lease specifically allowed the deposit would be forfeited if the tenant vacated the property prior to the end of the lease period, respondent did in fact send a refund with a damage recap. Respondent states that the property was not in the condition required by the lease and that some of the deposit was used to address those issues with the remaining amounts refunded. A copy of the analysis of tenant security deposit account and refund was provided along with invoice copies. The lease document does specify that the tenant will forfeit the security deposit if the tenant vacates early. Emails provided show communication regarding complainant's responsibilities if a tenant is secured but does not address the lease provision concerning the deposit. It appears that complainant's issues are those of a contractual nature, and from the information provided, it does not appear there is a violation of Trex laws and overrules by respondent, and therefore the recommendation was to dismiss.
So move.
Second.
Commissioner Flitcroft moves we take council's recommendation and dismiss, and seconded by Commissioner Haynes. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. Number 7 and 8 is next.
2013-013571, 2013-013581. Complainants were existing timeshare owners who state that Respondent 1, timeshare salesperson, Respondent 2 is Respondent 1's principal broker, met with complainants regarding changes to the current ownership. Complainants state that Respondent 1 told complainants that complainants could convert another timeshare that they own and add the points to the current points owned by complainants, and the complainants would only have to pay 1 yearly maintenance fee instead of 2 maintenance fees. Complainants state that based on this, they agreed to the purchase and were rushed through the signing papers due to the arrival of friends. Later, complainants state that they later received a bill for an additional yearly maintenance fee. Complainants state that complainants were not told that it was an additional agreement with an additional maintenance fee. Respondent 1 states the respondent explained Respondent 1 could help complainants get rid of their timeshare at another resort, which the complainant said had become expensive, and that a new deed would give complainants additional points to add to complainant's existing need. Respondent 1 states that Respondent 1 was asked several times about the maintenance fee at new timeshare, and Respondent 1 told complainants the maintenance fees for the new deed would be the same as maintenance fees for the complainant's current timeshare. Respondent 1 states complainant signed all paperwork. It was apparent that complainants were in a hurry with their friends arriving. Respondent 1 states that Respondent 1 was rushed out of the door when the friends of complainants arrived. A few days later, Respondent 1 states that one of the complainants called Respondent 1 at home and asked again about the maintenance fee for the new deed, and was again given the price of the maintenance fee for the new deed. Respondent 2 submitted
Motion to adopt council recommendation.
Second.
Motion by Commissioner McMullen to accept council's recommendation to dismiss, and seconded by Commissioner Haynes. Any discussion? All in favor say aye.
Aye.
Opposed, no. Motion carries. Number 9 and 10 is next.
2013-013591, 2013-013592. Complainant entered into, this is a long one, y'all, entered into a listing agreement with Respondent's firm for the sale of complainant's home. Respondent 1 is the principal broker. Respondent 2 is an affiliate broker. During that time, complainant stated there was one offer below list price and below what the bank was owed, and the bank would not authorize a short sale. Several months after the expiration of the listing agreement, complainant states the complainant decided to rent the home and informed Respondent 2 of this. Complainant states Respondent 2 said no, and complainant states the complainant informed Respondent 2 that Respondent 2 was fired and asked Respondent 2 to remove the yard sign, return the keys to neighbors, and not to give complainant's number to anyone who might want to see the home for sale. Complainant states the complainant then sent a notarized statement to Respondent 2 stating the Respondent's firm would no longer represent complainant and that the property was no longer for sale. Complainant states that Respondent 2 stated that because the notice was sent from a different state, Respondent 2 would not accept the notice. Complainant states that Respondent 2 and Respondent's firm refused to stop trying to sell the home after the contract expired, and after complainant's request, that Respondent 2 and Respondent's firm would not explain why they would not cancel the contract, and that Respondent 2 and Respondent's firm refused to remove the key box, yard sign, and return keys. Respondents each submitted responses to the complaint. Respondent 1 states that Respondent 2 had a signed listing agreement for the subject property with the complainant for a period, and then Respondent 2 had a listing agreement for the subject property with complainant's ex-wife for a period which began on the date following the expiration of the listing agreement with complainant. Respondent 1 states that Respondent 2 maintained communication with both complainant and the ex-wife and received an offer on the property, which became an accepted contract during the period of the listing agreement with the ex-wife. The transaction was a short sale that also had to be approved by complainant. complainant's lender. Respondent 1 states that after this purchase and sale contract was entered, Respondent 2 told Respondent 1 the complainant wanted to cancel the contract and rent the property. Respondent 1 said that Respondent 1 informed Respondent 2 the contract was a bilateral agreement, there must be mutual release. According to Respondent 1, the buyers were still interested and waiting on the lender's determination, so Respondent 1 told Respondent 2 to contact the buyer's agent regarding complainant's request. According to Respondent 1, the lender later gave complainant notification of foreclosure. Respondent 1 states that Respondent 2 did not obtain signatures from all ownership parties, and Respondent 1 has taken corrective action for that matter. Respondent 2 states that near the end of complainant's listing agreement period, complainant moved out of state. Respondent 2 states that Respondent 2 spoke to complainant's ex-wife, who was also in the deed for the house, and entered into a listing agreement with her for the sale of the property because complainant was going to let the home go into foreclosure, and complainant's ex-wife didn't want that to happen. Respondent 2 states that Respondent 2 explained the listing agreement with the ex-wife to complainant by phone, stating that the ex-wife signed the listing agreement because her attorney had informed her that complainant had not performed the divorce decree, which stated that the complainant must purchase the home. Respondent 2 states the complainant was aware of this, and text from ex-wife to Respondent 2 indicated that complainant was in agreement and that ex-wife could have any money from the house. Respondent 2 states that the complainant entered into purchase and sale agreement to sell the house with short sale after expiration of complainant's listing agreement, but during the listing agreement period with the ex-wife. Respondent 2 states that complainant was not happy with the offer but had accepted it. Respondent 2 states that the lender told Respondent 2 that complainant was wanting to cancel the short sale and do a loan modification, but this would not be possible. When Respondent 2 discussed with the complainant, Respondent 2 states that complainant fired Respondent 2, and Respondent 2 complained that there needed to be a mutual release to cancel the contract. Then Respondent 2 states complainant sent the affidavit canceling the representation, and Respondent 1 stated there could not be unilateral termination of the contract, not because the affidavit was prepared in another state. Respondent 2 states that Respondents 2 intend to help sell the property. Respondent 2 states that Respondents would have executed a release in the listing agreement with the ex-wife, but there was a contract and the potential buyer intended to purchase the home. Respondent 2 states the complainant sent a photo of an alleged declination letter from the lender, but states that the complainant then sent more documents to engage the short sale process. Upon following up with Respondent 2, it appears that after the complaint was filed and the responses submitted, complainant let the purchase and sale agreement expire in October 2013. Complainant submitted additional information asking why Respondent 2 would have contacted complainant's ex-wife regarding the home when Respondent 2 had a copy of the divorce decree. Complainant states that Respondent 2 contacted the ex-wife to alarm her about possible foreclosure. Based on a review of the divorce decree, it appears the subject property went to complainant as the decree specifies that the parties intended to sell the house, but until sold, the complainant was responsible for the mortgage payments and other costs associated with the home and would be entitled to any income tax deductions or credits. The divorce decree also specified that ex-wife would execute a quitclaim deed. Further, the decree states that neither party could reasonably withhold acceptance of a reasonable offer, and that after the sale, the proceeds would be applied to the mortgage remaining balances, to taxes and expenses associated with the sale, toward credit card debt, and any remaining equity or deficit to be assumed by the complainant. It would appear that in light of the divorce decree's provisions regarding who was responsible for stood to benefit from the subject property, the act of involving the ex-wife in the discussions and the sale of the subject property and signing a listing agreement with the ex-wife would constitute a failure to be loyal to the interests of the client, here the complainant, on the part of respondents. Therefore, recommendation was for both Respondent 1 and Respondent 2, consent order for $500 for failing to be loyal to the interests of the client in violation of TCA 6213-312B14 and 6213-4042, plus attendance by respondents at one entire regularly scheduled meeting of the Commission within 180 days of respondent's execution of the consent order.
Ms. Ryan, I may have missed something in here, but was the ex-wife on the mortgage?
The ex-wife was on the mortgage. The divorce decree, though, provided that her interest, and you have to remember, you have to look at this from the legal point of view, and this is the problem, I believe, with these two respondents, is that they made their own interpretation instead of getting a lawyer. The ex-wife's name is on the mortgage. That does not relieve her responsibility for debt, but her interest in the property was to go to him by quitclaim deed, which she did not execute. So she did not have interest after the divorce in the property itself.
You know, I've got to say, as a realtor, I would have contacted the ex-wife for her signature too, because she was on the deed.
She's the only one who signed the listing contract. He's the one that didn't sign it.
She was not on the listing contract at all. Initially, it was the complainant who was on the listing contract. When that listing contract expired, the respondent contacted the ex-wife. Now, I'm going to say to you, this is from an attorney's point of view, but if you have if you had, and they apparently had the divorce decree in front of them, they should not be interpreting that divorce decree without legal counsel. And if they act on it without doing that.
So do you think the respondents contacted the ex-wife after the listing agreement had expired with the complaint?
I think so,
Would there be an agency relationship at that point then?
Well, she had no interest in the home. Here's the bottom line. It is our opinion, this is legal counsel's opinion, that the interest concerning this home belonged to the complainant and complainant alone.
Could that property have closed without her signature?
If she had signed the quitclaim deed, it could have closed without her signature.
But she had not.
That's right.
So it could not have closed without her signature.
That's right. Her name would have been on the title still without signing the quitclaim deed, as she was ordered to do in the divorce. When you sign a quitclaim deed in a divorce, all your interest goes out of the title, but of course that's separate from the mortgage, and your responsibility can still be there in the mortgage, but that's not what they were discussing. They were talking about the interest in the property.
Robin, would you address the principal broker's involvement in this case?
Well, the principal
Or
broker.
lack of involvement?
That's right. Principal broker, let's see, let me find it here. Principal broker was respondent one. Principal broker said that that his respondent two had maintained communication with both the complainant and ex-wife, and states that after the purchase and sale contract was entered, respondent two told respondent one, that's the principal broker, that complainant wanted to cancel the contract and rent the property. Respondent one stated that he or she informed respondent two that the contract was a bilateral agreement. So respondent one, who is the principal broker, also didn't understand.
You got a motion?
No.
Well, I'm gonna make a motion that we accept council's recommendation, except the principal broker, the buck stops with the principal broker. He's uninformed, or he doesn't know what procedures, and I agree with you, Ms. Randy May apparently he needs to talk to an attorney, because if he doesn't know how to read a divorce decree and those things. So I'm not, my feeling is that he either needs to be fined about $2,000 and $500, because he's actually, he should have, it's the principal broker's responsibility. That's my recommendation, to fine be 2 and 5.
You state your motion for the record.
Stated it, but I'll state it again. I'm going to take council's recommendation except for the amounts of the fines, and the fines be $2,000 for the principal broker and $500 for the affiliate.
Is that outside the limit for that violation?
It's $1,000 per violation.
Well, what about the accumulation of the days?
You can do it per day. It on the record.
I'll still stay at 2. Take the accumulation days and you count them. If it's less than that, subtract it down to the days.
I can't tell you how many days it was. I have no idea.
Okay, but I think the motion now, respondent one, the principal broker, $2,000 civil penalty, and respondent two at $500. Did both of them attendance at a commission meeting?
Yes, that's if any time you have a consent order, that's
Automatically.
part of it. That's automatically part of it. Now, if you want to send them to school, you send them to give them some other classes if you want to.
You've heard the motion by Commissioner Alexander.
Second.
And the second by Commissioner Bloom, seconds that motion. Discussion on this motion.
See, I'm inclined to speak against the motion because it appears to me, and if I'm incorrect, Ms. Ryan, you let me know, that the contact with the ex-wife was after the listing agreement had expired. So in my opinion, there was no agency relationship past the expiration date of the initial listing.
Chairman Grease, I just want you to understand that the bottom line is the ex-wife had no interest in this property at all.
I'm sympathetic to agents who list properties and have people sign that don't have any authority to sign, I mean, which is your point you're making.
Actually, the point I'm making, and what legal counsel was making, is that there was a divorce decree, and it was specific about who had the interest, and that there was a cooperation requirement in that divorce decree, but that all right, title, and interest really was the complainant. And that by attempting to, my opinion is, by attempting then to communicate with the ex-wife and get her to sign, they were going against the interests of the first person who specifically said, I do not want you to sell my house anymore, and specifically asked for the return of the keys and the lockbox, et cetera, and instead right at the end of it, a new listing agreement was assigned with the ex-wife immediately.
I'd make the argument that he can't just unilaterally, as this respondent states, cancel that listing agreement.
Sorry?
The agency the owner cannot unilaterally cancel an active listing
You're right,
agreement.
and the argument was made for that, but during the second agreement, not the first. He wasn't attempting to unilaterally cancel the first. The first was expiring in its own terms, and he asked for return and said he wanted to sell it, but at the same time, the agent signed on the ex-wife. This was immediate. This was not a period of time or days, it was immediate.
I'm all in favor of the motion if you can tell me that prior to the expiration of that first agreement, the agent, or almost at the expiration, the agent went to the ex-wife and said, why don't you sign up so you don't lose this to the bank? That's the timing is what I'm interested in.
My understanding is, but I can look it up, but I think in reading this, and it could be very close, within days of the expiration, it was right on the, and as they said, they kept communication throughout the whole process. The ex-wife was living there at the home. She had a right to live there at the home. She had no interest in the home. And so he kept up the communication with ex-wife throughout he or she, I don't know which, throughout the entire process. When the term of the term of the contract expired, it was immediately signed on with the next person. He, being the complainant, says that the respondent contacted ex-wife to say, if you don't get it for sale, it's going to go into foreclosure. One number two said that the complainant said, although everybody was worried that if it wasn't sold, it was going to go into foreclosure. In any event, that's totally irrelevant to the interests involved. But it was right on top of each other. It was right on top of each other. The communication with the ex-wife was throughout the process, and then immediately at the end of the contract, that new contract was written with somebody who was not a party and not a part. And the issue is the complainant asked that it not be sold, all the keys returned, he wanted to rent it, and his interests were totally ignored. That's the issue.
Is that an agency issue, do you think?
Agency?
Yeah.
In what way?
Well, that's what the recommendation is based on, that we violated the client's interest.
The client's interest, yes, because they didn't put the client's interest first, yes.
Okay.
Any other discussion on the motion? Hearing none, all in favor say aye.
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 Opposed, no. Motion carries unanimously. Number 11 and 12 is next.
2013-013631, 2013-013661. Complainant, a licensee, states that complainant had a potential client who was interested in a commercial space, and when complainant called the number in the window, complainant states that complainant reached respondent 1, broker. Respondent 2 is respondent 1's principal broker, and made an appointment for complainant to show the property to complainant's client. Complainant states that Respondent 1 told complainant that Respondent 1 was a realtor, that Respondent 1's license was with Respondent 2's firm, that the subject property was unlisted, that Respondent also worked for the owner of the subject property as a property manager, leasing agent, and real estate salesman. Also, complainant states that the parties exchanged business cards from their licensed firms. There was a commission dispute relating to the lease of the property which caused a disagreement between complainant and Respondent 1. However, complainant states the complainant is not asking the commission to resolve the commission issue, but believes that Respondent 1's activities are in violation of TREC laws and/or rules. Respondent 1 submitted a response to the complaint stating that Respondent 1 has been a salaried employee of a LLC whose duties are to be the right-hand man of the chief manager and to be a real estate consultant for properties owned by the company. When the company built developments, Respondent 1 states the Respondent's licensed firm listed and marketed the lots and homes. Respondent 1 states that the LLC owns several commercial properties and the chief manager produces his own lease, rental rates, maintenance decisions, rent collections, and payouts. And Respondent 1's responsibility is to look after his properties. Respondent 1 states the LLC has not listed its commercial real estate, and those properties are advertised with the same LLC's name and the office number of the chief manager and the cell phone number of Respondent 1, and has not been listed or advertised with Respondent's firm. And so Respondent 1 will get many calls about lease term, lease rates, etc. Respondent 1 states that it was Respondent 1's duty to show the property in the chief manager's absence, and chief manager handles the money, escrow, and general bookkeeping. Respondent 1 states the party got in a very heated conversation about the commission dispute, and Respondent 1 states that it was Respondent 1's mistake of giving complaint Respondent 1's business card with his licensed firm and losing Respondent 1's temper at complainant. Respondent 2 also submitted a response to the complaint against Respondent 2 for failure to supervise Respondent 1. Respondent 2 states that Respondent 1 is affiliated with Respondent 2's licensed firm and also works on a salaried basis for an individual who is the owner of a considerable amount of rental properties. With regard to the subject transaction involving the complaint, Respondent 2 states that Respondent's licensed firm had no listing of the property, no sign or phone number posted on the property, and no involvement in the transaction, and that Respondent 1 acted solely in an employment capacity for the property owner. Based on the information included with the file, it appears that Respondent 1 is being compensated for the performance of acts specified within the Broker Act by someone other than Respondent 1's principal broker, and it appears Respondent 2 is aware of this. Therefore, the recommendation is, as to Respondent 1, a consent order for $1,000 for violation of TCA 6213-312B11, plus attendance by Respondent 1 at one entirely regular scheduled meeting of the Commission with 180 days of Respondent's execution of consent order. As to Respondent 2, a consent order for $500 for violation of 6213B15, plus attendance by Respondent 2 at least one entirely regulated scheduled meeting of the Commission within 180 days of Respondent 2's execution of consent order.
For the record, Robin, what is a violation of the Broker Act?
Read it to you. The first one is 6213-312B. Which says that you can issue disciplines against anyone who accepts the commission or any valuable consideration by an affiliate broker performance of any act specified in this chapter from any person except the licensed real estate broker with whom the licensee is affiliated. For 312B15, that is, in the case of a licensee failing to exercise adequate supervision of the activities of any licensed affiliate brokers within the scope of this chapter.
So in previous cases like this, have we not also included a cease and desist requirement?
Cease and desist what?
Well, he's collecting, he's managing property and collecting a fee from somebody other than his broker.
What he is doing is getting paid for activities from someone other than his broker.
Oh,
It's not a cease and desist.
so
It's
if the
just a
owner of this property
violation.
needs to pay his broker, and then his broker can pay him, and we're okay.
Probably. I can't answer that outright because
I mean, just conceptually.
conceptually.
We have a motion by Commissioner Grease to accept council's recommendation and seconded by Commissioner Collins. Any other questions or discussion on this motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. Number 13 is next.
0133941, complainants are timeshare owners who made an upgrade purchase in 2010 with Respondent, which is a timeshare registration. Complainants state that they were told the resort was new construction and one of Respondent's salespeople stated the unit was one of the last units available and the price was good for that day only. Complainants state that the purchase terms were not explained adequately, that the resorts complainants have visited are very congested, the check-ins were chaotic, confusing, and that there's also often a lack of availability of desirable newer units.
Motion to accept council's recommendation.
Second.
We have a motion to accept council's recommendation and dismiss, and it's seconded by Commissioner Grease. Discussion on the motion to dismiss. Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. Number 14 is next.
2013-013981. Complainant is the designation coordinator for a real estate organization where respondent, Principal Brooker, was formerly a member. Complainant states the respondent had formerly earned a designation through complainant's organization, but states that the respondent discontinued respondent's membership several years ago. Complainant states the respondent continues to use the designation and states the complainant has contacted respondent 3 times asking respondent to either discontinue using the designation or reinstate the membership. Complainant also provided copies of multiple written requests made by complainant to respondent, which were sent prior to filing this complaint and which notified respondent of respondent's expired designation and provided information regarding reinstating the membership or instructed respondent to stop using the designation if respondent chose to remain inactive. Complainant also attached screenshots from websites on which the designation was utilized while respondent's membership was expired. The screenshots note the designation along with respondent's name and other information. Respondent submitted no response to the complaint, which was sent to the firm address and filed with the commission and signed for by an individual there. Complainant later sent additional information stated that respondent contacted complainant, resolved the issue by reinstating the respondent's membership, so respondent is now entitled to utilize the designation. The recommendation is a consent order of $1,500 to fairly respond to complaint filed with the condition in violation of 6213-312B14 and 6213-313A2 and misleading or untruthful advertising in violation of TCA 6213B4 plus attendance by respondent at 1 entirely regularly scheduled meeting of the commission within 180 days of respondent's execution of the consent order.
Move to accept council's recommendation.
Second.
Motion by Commissioner Grease and seconded by Commissioner DeShar that we take council's recommendation. And any discussion on this motion?
Is that the maximum we can find?
It's $1,000 for violation and occurrence. We don't have the total occurrence on it. This was her recommendation based on the facts in this case and the fact that it had been resolved ultimately.
I think it's probably adequate. Any other comments or discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Number 15 and 16, 2013-014241, 2013-014242. Complainants attended a timeshare presentation given by respondent in 2011. Respondent 1 is a timeshare registration. Respondent 2 is a timeshare person. Number 3, 2013-014251. My apologies. And respondent 3 is respondent 2's principal broker. Complainant states the salespeople, especially respondent 2, made a number of verbal misrepresentations during the presentation concerning the product.
Move we approve council's recommendation.
Second.
We have a motion by Commissioner Flitcroft and seconded by Commissioner Haynes that we accept council's recommendation. And I want to point out for the record that this legal report has been sent to each commissioner, and they've had a chance to review these, and they're to familiarize themselves with it. And even though we don't read through the entire report that has been given to us and prepared by the staff, the legal staff of the commission, that's the reason sometimes we take action before the entire complaint is finished read by the attorney. But with that in mind, motion to dismiss, and Flitcroft made the motion to dismiss and Haynes seconded the motion. Any discussion or comment? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. Number 18 is next.
2013, this is 18, 19, 20, and 21. 2013-014261, 2013-014262, 2013-014263, 2013-014271. Complainants were existing timeshare owners who attended an update meeting with respondents 2 and 3. Respondent 1 is a timeshare registration. Respondent 2 and 3 are a timeshare salesperson. Respondent 4 is respondent 2 and 3's principal broker. During the meeting, which complainants state they did not realize was a sales meeting, complainants state that there were a number of misrepresentations made regarding the upgrade, including but not limited to, that complainants were told that an upgrade purchase would allow complainants to rent their timeshare for a significant profit without complainants having to do any work, that complainants would not lose points at the time.
Motion to approve council's recommendation to dismiss.
Second.
A motion by Commissioner DeShara and seconded by Commissioner Collins to accept council's recommendation and dismiss. Any discussion? All in favor say aye.
Aye.
Opposed, no. Motion carries. Next we have 22, 23, 24, 25, 26, and
That's it.
That's it.
2013-014-311, 2013-014-312, 2013-014-313, 2013-014-314, 2013-014-321. Complainants were existing timeshare owners who attended a timeshare meeting given by respondents in 2011. Respondent 1 is a timeshare registration. Respondents 2, 3, and 4 are timeshare salesperson. Respondent 4 was respondents 2, 3, and 4's principal broker at the time. During the presentation, complainants stated they were told that the company was getting rid of fixed week timeshares, and complainants had to purchase points package as an upgrade, which was not at the resort complainants thought, but was instead at resort where complainants had their previous timeshare. Complainants states they were told that with the point system, complainants could trade to vacation with other resorts for only exchange fee, but complainants later found out they didn't have enough points to do this. Complainants also state they were told the timeshare would be a financial investment.
Excuse me. Council, I'd like to move to accept your recommendation.
I'll second that.
Motion made by Commissioner Grease and seconded by Commissioner McMullen to accept council's recommendation in these 5 complaints read into the record. Any discussion on the motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. 27, 28, 29, and 30 is next.
2013-014-341, 2013-014-342, 2013-014-343, 2013-014-411. Complainants attended timeshare presentation given by respondents in 2012. Respondent 1 is timeshare registration. Respondents 2 and 3 are timeshare salesperson. Respondent 4 is respondent 2 and 3's principal broker. Complainants state the presentation lasted 9 hours and a number of misrepresentations were made during the presentation, including but not limited to that the timeshare was a financial investment, that the complainants could make money from the timeshare by renting it out, that the company would buy back the timeshare if complainants decide to sell it, and that complainants could vacation at other resorts by trading their timeshare without very much cost. Complainants state that the paperwork was not thoroughly reviewed with complainants at the presentation, and complainants were told to lie about their income and loan application, and complainants were not told of their cancellation right. Complainants would like the contract to be canceled. Respondents
Motion to accept recommendation.
Commissioner McMullen has made a motion to accept council's recommendation. It's been seconded by Commissioner Collins. Any discussion?
Was that a 9-hour presentation they said they sat through?
Yeah.
That's what they said.
They must have got food.
Imagine if they had to listen to the legal report.
Hearing no further comments or discussion, all in favor say aye.
Aye.
Opposed, no. Motion carries.
There was much fun had with drinking alcohol on that one.
31, 32, 33, and 34. 2013-014-451, 2013-014-452, 2013-014-453, 2013-014-481. Complainant attended timeshare presentation with respondents in 2012. Respondent 1 is a
Mr. Chairman, move we approve council's recommendation.
Second that.
Have a motion made by Commissioner Flitcroft and seconded by Commissioner McMullen to accept council's recommendation and dismiss. Any discussion? Hearing none, all in favor say aye. Opposed, no. Motion carries.
35, 2013-015-461. Complainant attended a timeshare presentation given by respondent in 2012, timeshare registration. Complainant states that the representatives made a number of verbal misrepresentations, including...
Motion to approve council's recommendation and dismiss.
Second.
Motion made by Commissioner DeShara to take council's recommendation and dismiss, and seconded by Commissioner McMullen. Any discussion on the motion? Hearing none, all in favor say aye. Opposed, no. Motion carries unanimously.
Number 36, 2013-015-971. Complainants state they attended a timeshare presentation in 2012 given by respondent, timeshare registration. Complainants allege that they were offered a gift to attend the meeting by 2 different people and were told they received both gifts by attending. When they were arriving at the meeting, complainants state they were told by some representatives that they could not receive both gifts for attending, but the sales manager then told them they would get everything complainants had been promised.
Excuse me, Counselor, I'd like to move we accept your office's recommendation.
Second.
Commissioner Grease makes a motion. We take council's recommendation and dismiss, and it's been seconded by Commissioner Haynes. Any questions, comments, or discussion?
Mr. Chairman,
Mr. Broom.
I really don't have any comment about this particular case, but every one of these have been some kind of misrepresentation in timeshare, and I don't know enough about it, but it does seem like some of this has to be, maybe we need to be taught about this or something, but I can't think that all these people are that wrong. They all hire an attorney.
May I address that somewhat?
Yes, Ms. Ryan, you have the floor.
Thank you. In most of the timeshare presentations, what happens is, in the documents that are provided to us, so you understand it's not just willy-nilly we look at it, almost every one of them also, after a presentation, sign a long document saying they've not been promised anything that's not in the contract. They are specifically do that in writing. Every one of the timeshares does that regularly. So
Well, I understand, and I think our position is correct, but I'm also thinking that we're missing something somewhere if all these people feel that they've been misrepresented.
I have a question about that, and I agree with you. Is it consumer complaints?
most of these complaints come from consumer complaints.
Oh, so they don't want to deal with them, they send them to us.
And the problem is we have no teeth, correct?
I think that is part of the problem, and legally, when it gets down to it, it is difficult, as I said, when all the documents show otherwise, because the documents win in court.
And in addition, Robin, the documentation provides a typically 3-day cooling off period.
That's exactly right.
And so if the people had wanted just to decision, they could have done it early.
That's generally true, too. That's by law. They have a
We've had complaints where there were allegations that they didn't honor the 3-day.
Yes, this commission should know that there have been, at least the time since I've been here, the times when various timeshare organizations have been penalized for not following the rules and laws.
I'm sorry, we need to vote.
Okay, the chair's asked that I take over. Apparently, he wanted to go talk to the timeshare principal broker outside. All right. Maybe it's an affiliate, that's correct. With that said, all those in favor of the motion to dismiss, please say aye.
Aye.
Those opposed, no. It's unanimous. Ms. Ryan, 37, 38, 39.
And these are the last for today, and I make a motion, and I have no power to do this, that you all have a Christmas lunch every month because you get through the legal report quicker. Anyway. Sorry.
I've been saying that for a year.
2013-018561, 2013-018571, 2013-08581. Complaints opened by TREC against respondents. Respondent with 1 or 2 affiliate brokers. Respondent 3 is their principal broker. Based on respondents' failure to satisfy agreed citations which were sent to respondents. Respondents were sent agreed citations which include civil penalties for Respondent 1 and 2 due to an advertising violation and for Respondent 3 for failure to supervise 1 and 2. Specifically, Respondents 1 and 2 names were featured in a larger size than the firm name on a yard sign. Because respondents had not signed and returned their agreed citations with payments, these matters were open and legal as complaints. Soon after this matter was open and legal, respondents submitted their executed agreed citations and paid the civil penalties included therein. Therefore, the recommendation is closed in satisfaction of the agreed citations.
To accept council's recommendation.
Second.
Just one quick question. So they didn't decide to pay until you filed, until a new complaint was opened up against them?
No, I think it was before that. After the complaints were opened, but before anything else had happened, they signed and paid.
It was in the paperwork process.
Yeah.
Any other discussion? The motion is to accept council's recommendation and close the complaints. All in favor, say aye.
Aye.
Those opposed, no. It's unanimous. That concludes this portion of Ms. Ryan's legal report.
Mr. Chairman, may I address the audience?
I wish you would, sir.
I've been on this commission for 7 years. When I came on the commission, we were hearing legal reports, and some of the complaints were 5 years old. Today, you've heard complaints, and if you look at the dates, they're August, September, and I'm amazed here in number 37, I understand what's going on. It was opened in November. It's amazing. Now, what I want you to do is to take home, and some of you may be principal brokers, but at least those are agents there. Tell your principal broker what went on at this legal report. Tell your principal broker that if they fail to supervise an agent, tell them to go talk to a lawyer or whatever. They're going to be in trouble themselves. And tell your brokers, look at the licenses on the wall, including the firm license. If they're expired, do something. I mean, it's a shame to penalize a principal broker for failure to renew a firm license. That's basic, folks. Thank you.
Thank you, Mr. Flitcroft. Let me say one other thing. These complaints have been brought to the staff of the Real Estate Commission, and the staff has presented to them those complaints to us anonymously. We don't know who the parties are. And at the end of each presentation of a complaint, there's a discussion, and we'll typically accept council's recommendation, but not always. At that point, the recommendation is sent in the form of a consent order to the licensee or to the principal broker, and they make a decision as to whether or not they will agree to the terms that we've imposed. If they don't agree, then they have every right to have a formal hearing on the complaint. Tomorrow morning, we have a formal hearing, I think still, right? Okay. We'll have an administrative law judge here, a court reporter. The state will be represented by Ms. Ryan, and the respondent, whoever that person is, we don't know until we get here tomorrow, will be represented by an attorney as well. That starts promptly at 9 o'clock. It's the culmination of this process. Most of the time, they settle, we dismiss. Tomorrow, you'll get to see this body act as a jury without any kind of private consultation. So please be here on time tomorrow. Be respectful of the court, because that's basically what we're in tomorrow morning. Back to you, Mr. Chairman.
Okay. What number are we
We're
on?
on consent order log.
Okay. Consent order log. You're in charge, Ms. Ryan.
All right, y'all got a copy of Ms. Crop's consent order log. I don't know if you have any questions, but you can see how many have been satisfied. You right now have very few that are in litigation that have been sent over to litigation. They'll all be set for next year. One of the ones on your first page, two of the ones on the first page were heard. One was continued. One is set for January. And then the others will be set for next year as far as litigation goes. Does anybody have any questions about any of the information in the consent order log?
Thank you much.
Next, we have draft rules and existing policies discussion.
Let me start with something very simple. There were
Please, you gonna break us in slowly?
Yeah, I got to break me in too. You were included. Julie nicely left me lots of nice notes, even though they're her notes. I can actually follow what's going on. She has identified two policies, and I think you have copies of those, that either need to be a rule utilized if they're going to be utilized, and I don't think either one of them have been utilized in a long period of time, or they need to be rid. And they are the Commission Policy Statement 95-CPS-003, and the other one is number 2000 CPS-001. They are on separate documents.
It's the very back of about 15.
Yeah, very back. Our notes on the first one, 95 CPS 003, is that if you are going to utilize this policy, then it needs to be in rule form, and that means that we'll have to put it in rule form at some point. Otherwise, probably it just should be. What's the process? They just remove the policies when they?
Right, they just vote to remove.
Just vote to remove the policy.
Rescind it, basically.
And she suggests that it appears to conflict with 6213-4037B, which contemplates referral fees. And the reason is that, I'm sorry?
This is if you disclose with written consent.
I'm sorry. Go ahead.
Just look at it.
Okay. If you want to look at that, it's 6213-403B, which says, It's 7B, that's right, 403-7B. I'm getting help on both sides here. That's okay, I agree. It's 7B that says, timely account for trust fund deposits? and all of-
Not recommended to any party to the transaction. It's 403.
Not recommended to any party of the transaction, the use of services of another individual, organization, or business entity in which the licensee has an interest, or from whom the licensee may receive a referral fee or other compensation for the referral, other than referrals to other licensees to provide real estate services without timely disclosing that person who receives the referral. So it seemed by statute that as long as there's disclosure, the referral is acceptable, and this policy says it's not acceptable, and I think Ms. Propp is right, because the issue, according to statute, of whether or not there's been being upfront about it, really. And this, as it stands, it basically finds it improper.
So we
that's what
just
she's-
need to delete that policy?
Well, she's suggesting that if you want to make it a rule, you have to clear it up and clean it up somehow, or get rid of the policy, because it does appear to be a conflict anyway, on top of it.
I make a motion, we delete policy number 95-CPS-003.
I second it.
Robin, do we need to go through the litany of?
This is policy, not rules.
We have a motion by Commissioner DeShara to delete Commission Policy Statement Number 95-CPS-003 dated April the 5th, 1995, and seconded by Commissioner Collins. Any discussion on the motion?
You know, I don't, to me, I'd be more inclined to defer it for 30 days and think about it. I mean, there must have been a good reason for this to have been created as a policy to start with. Maybe you guys with some history can tell me.
Ms. Ryan, could you
Well,
respond?
I can maybe respond to some of this. This statute seems to have gone into effect about the same time this rule did. This was 95, and it looks like the Acts of 95, Chapter 36 for Section 5, and Chapter 37 for 5 and 6. 7, I can't tell when 7 is. Let's see. Section. I, of course, was not here in 1995, although I was an adult at that time. But I would suggest, I'm not sure why this was the way it was, but I would suggest that it is in conflict here. And it might be that there was something going on where inspectors were getting referrals at the time. This is not an issue that comes up very often with any of us. I don't think, and no, it's not come up since I've been here at all.
Well, yeah, doesn't the Real Estate Settlement Procedures Act supersede all this? You can't get any referrals anyway on any circumstance except from another licensee.
Well, in commercial real estate, you can. Commercial lending, RESPA only applies to residential loans. Not that I think this is going on in the commercial field, but I can get a kickback from a lender, for instance, if I send a commercial loan to someone legally, which surprises the heck out of me.
Again, I think that if you even look at the law and this particular issue, the issue was for the third party out there, what is going on behind closed doors, and I think the statute is pretty clear about that, saying if there is a referral, it has to be disclosed, otherwise it's an absolute violation of the law. And I think that this actually might have been addressing issues that were going on at the time. That's my opinion. I don't know that for sure.
Commissioner Grease?
Well, I'm all about fewer policies. The fewer the better, as long as we're succinct in what we're trying to get done. If council's opinion is that this violates the statute, then at the very least we need to follow Janet's recommendation and remove the policy. And if it needs to be addressed in some other form, we can come up with a rule at that point.
Any other discussion or comments or questions on the motion? All in favor say aye.
Aye.
Opposed, no. Rule Commission Policy Statements 95 CPS 003 is deleted. What do you have next, Ms.
The next
Ryan?
one is the policy 2000-CPS-001. This is credit for post-license education taken in another jurisdiction prior to licensure in Tennessee. Her recommendation was to discuss this, that again, if you choose to go forward with this, it should be a rule, but she also suggests this appears to be already addressed via 6213-303H, which says, if I find it, within a period of 3 years from the date of issuance of original broker's license, the licensee shall, as a prerequisite for the reissuing of the license, furnish certification of satisfactory completion of an additional 120 classroom hours in real estate at any school, college, or university approved by the commission, regardless of where it is. And that it's also addressed in 6213 314B 3. B3, which states, any service of process or pleading shall be served on the executive director of the commission by what?
That's not B, it's just
Three, okay, well, 3. The commission may issue the appropriate license to such non-resident applicant if the applicant was qualified for the license held in the applicant's state of residence by written examination, the applicant meets or exceeds each of the qualifications for licensure in this state, the applicant certifies that the applicant had read the provision of this chapter and the rules and regulations promulgated thereunder, and the applicant's state of residence permits the issuance of license without written exam to the brokers, affiliate brokers, and timeshare salespersons, etc. So that's her recommendation. She says that this particular point seems to have been addressed already in the statute. So.
Steve, did you look at this at all? Do you see any reason why this shouldn't be removed? I'd move that the commission policy statement 2000 CPS 001 be removed from our manual.
A second.
Motion by Commissioner Grease to delete this policy 2000-001, and second by Commissioner DeShara. Any discussion? All in favor say aye. Opposed, no. Motion carries and policy is deleted.
Now we come to the rule amendment drafts for discussion. Ms. Crop, yes.
Before you get to that, what do we hope to accomplish today? Is this draft language that you'd like for us to approve, or is this conceptually what you're going to put into rule, or how?
Well, my understanding from Julie, she's worked on this very, very diligently. My understanding is she would like to get the notification, et cetera, for the rules out to the public so that this can start the rulemaking process in January. So that's my understanding, and these two know way more about it than I do, although I did help her go through some of this. So what her hope was to go through and make any changes he wanted to make or answer any questions and then go forward with it. If you all have read it.
I have, yeah. I'm ready to go forward with it. Let's go.
Do we want to take a short break or continue on?
Let's take a quick break.
Let's take a quick 5-minute break, run to the bathroom quick. Ready? Call this meeting back into session. Ms. Ryan?
Yes, let's talk about the proposed rule drafts for discussion, and let me sort of explain the process so you sort of know where Ms. Crop is. And first of all, rules take a long time. It's not something you put in or vote on one month and gets done the next. The next step after a discussion and decision about what has been proposed and going forward was that Ms. Crop hopes to have the hearing on the Regulatory Flexibility Act next month. Then there will be a 60-day, I think, period, is that right? Where there can be people and the public and all of you, giving their input, and then the final hearing on the rules probably wouldn't be until March. So we are talking a long period of time trying to get this done. So what Ms. Crop had hoped to do this morning.
In addition, once you have it approved by this commission, it then can spend and languish with the Secretary of State for
a while. They do try to get them done so that the proposals would be, I think.
They go to the AG's office first.
Yeah, they go to the AG's office, and then they have to look at it. It's a long process with a lot of people given opportunity, which they should, to give their input. Everybody, these are important things. These are not statute changes, mind you. These are rules, and the rules interpret your statutes or put things into place that are in parallel in keeping with the statute, which is the issue we had of getting rid of the policies beforehand. Rules are something you can do in connection with a stated statute in fleshing it out a bit further. For instance, you can make a definition of a term from a statute or going further, including some areas, and you'll see in the proposals, there are proposals on what is a misleading advertising, about things that could be misleading and not limited to, just to give an idea to the people out there what they can and cannot do. Everything in this outline that is underlined are proposed changes based on discussions this year, based on issues that have come up. The biggest changes, of course, are the ones that you are anticipating, the ones doing with advertising. And they are outlined, and that's in Rule 1260-02-12. And then the other one that is starting new, the couple things here are 126001-18, that's about firm names. Then there are issues about penalties, about civil penalties that are being proposed, reinstatement of expired license. Everything underlined are changes to what is there, or in addition, or entirely. My understanding is that you all have had time to review this before today, and that this particular portion of the meeting was to give an opportunity for you all to ask questions, make recommendations for changes, et cetera, and then the hope is to put this going forward so that this could be part of the hearing on the Regulatory Flexibility Act for this January, coming up.
Mr. Chairman.
Commissioner McMullen.
I'm concerned about some of the advertising rules on pages 4 through 5, I guess, maybe 6 too. Particularly where it talks about having to include the entire name of the real estate firm as licensed with the commission. I think that's an excessive requirement. For example, if you have a firm that's listed with the commission as M.Y.P.D. LLC DBA Exit Select Realty, they're going to have to put that entire name on their sign, and that's going to be quite a burden to put on licensees who already have signs, and to require this change. And many of those signs are not misleading as they currently are. I think that one consideration may be to change this to include maybe a definition of firm name or something like that in here that would provide that the firm name could either be the legal name of the company as registered with the Secretary of State, or the DBA or assumed name as listed with the Secretary of State. That if you did either one of those, that would be sufficient. It's just my recommendation, but I think as it is, that's an excessive requirement that doesn't serve any real purpose of preventing consumer confusion or anything like that.
Commissioner McMullen, if you don't mind, I'm going to ask Commissioner DeShara, since her firm name's probably the longest of any of us up here. Give us your thoughts on this.
Well, and John and I talked about this a little bit earlier too. You know, in the past, we've always assumed that the DBA is registered with the Real Estate Commission has been sufficient. So you're talking, and I have a small firm, but even in my firm, signs alone would cost probably in excess of $5,000 to have new signs printed. In a larger firm, you're probably talking, you know, $20,000 for some of these firms that have a tremendous amount of signs. I just think the company name that you use and is recognized by the commission is the one that needs to be used. However, Ms. Maxwell and I talked about it a little bit earlier. Some of the state registered names really should be what they're going by, and the similarity rule comes into play when we've got all the offices that their DBA is the same company. Keller Williams being the one that comes to mind, because they'll be like the Dream Team, DBA Keller Williams Realty, so just putting Keller Williams Realty on it doesn't identify it.
And that might go back to the staff when they allow a name to be used. We have a policy that says it can't be similar to another name in a geographic area. I'm paraphrasing terribly, but it's something to that effect. Is that right? Even is it something that?
There is. It says that you can't have a name that's deceptively similar within a 50-mile radius, and that's also, you know, covered in these new proposed rules.
So back since Keller Williams was brought up, there could be 4 or 5 different companies all called Keller Williams in Knoxville. And I'm not sure if that's a policy, a rule issue, or if it's simply a matter of when these people bring their franchise to town, that the real estate commission staff say you can't just use Keller Williams, you've got to use something else. Even though the franchise may allow it, our policy as it's written right now really doesn't.
Well, that's where the either or would come into place, because obviously different companies want to do it different ways, and I don't know how, and if you're a company that's franchised across the United States.
Well, it depends on the franchise, but Century 21 is going to require every franchisee to have a separate lowercase name.
And my franchise does too.
But Keller Williams, for instance, does not. They let all their franchises all just be called Keller Williams.
Well, that's why.
That's the confusion.
For what Commissioner McMullen said, the either or would take care of that, wouldn't it?
Not in the Keller Williams case, because
They all take Keller Williams.
Well,
they
if
all are Keller Williams.
If they all said Dream, if they went with the first part of the name, which was like Dream Team Franklin LLC, that would be fine. But if they all just use Keller Williams, then maybe that creates an issue.
It does create, I think it does. I think it's part of the,
Robin, one thing that is good about having the name as registered with the commission exactly is it's able to identify who a complaint's about. If we use what Mr. McMillan is offering, and I think it's appropriate, would there be difficulty in identifying who the complaint's about or not?
If that entity is not the entity having the license, I think there could be difficulty, couldn't it be?
Yeah, there is, if you go on the internet and try to pick up the DBA, it doesn't always show up. Under our new system, it will always reflect the DBA. You'll be able to cross-reference those.
Well, what he was suggesting, though, if the name that is listed with the Secretary of State is not the name that's listed with the commission, you couldn't necessarily find that name. In other words, it could be an LLC or a corporation, but the business name is what was registered, and it's not the same.
Well, if you are registered Secretary of State, we get your paperwork. But and then if you've got a DBA, we get that paperwork as well. And the Secretary of State approves. They seem to approve all the DBAs that
I got a
come their
question.
way.
Why couldn't we just use?
Pull your microphone down.
In this situation, why couldn't we just start using a firm number under a name? I always put the firm number on there, and it would readily identify to Eve or whoever complained what firm number you need to complain to.
That's what auctioneers do.
That's right.
And the commission's talked about that before. Some of the commissioners have been here. You haven't done it while I've been here really in earnest, but I think that it's been brought up.
That was identifying the agent.
No,
Talked about identifying the firm. I think it's been talked about in the past. As I say, someone who's got some history, like back might know a little more about, why what was the problem using the firm number.
I think the
as
problem
well.
with that is, licensees who are part of a franchise pay a lot of money for that name, and they don't pay a lot of money to get license number 260228 on their signs. I think that's the problem. They want to put Keller Williams or Exit or Century 21 or whatever on their signs.
If you put like Keller Williams Realty and number, is that what you were talking about, Grover? Like put the name and say
Right.
you're going to use the DBA, it was Keller Williams
An
Realty.
abbreviated name, but
And
the
then
firm
you put
number.
the number, then I would be able to go to
You know
that. I don't
exactly
know.
who it was.
Well, I don't know that that's going to help the public any, because if they get ready to file a complaint, and you go, well, did you get the number off the sign? They're going, oh, yeah, it's 731-554-3948. They're not going to know what number you're talking about.
Going 80 mile an hour down the interstate's hard to get a number off too.
Yeah, that's what I'm saying. I don't think the
Or
numbers.
name either.
How many
I know it's
how many
just a
consumers do we think are unable to file complaints because they don't know who to file it against? Do you all ever hear from people? Does the staff ever hear from people who say, I'm really ticked off about such and such, and I just don't know who to actually file this complaint against? Is that ever really a problem?
They just file, they file it against
Joe
whomever.
Blow.
Yeah, normally the individuals, yeah, it's
Yeah.
whomever they did business with, and some people don't even have a firm, they just don't put a firm name down. But, I mean,
Are you all usually then able, based on the information you receive, to figure out which licensee they're talking about?
if they have a person's name, we can usually, if there's an address to, we can usually back into that, even if there's a number of people by that same name. Because really, the people seem to identify with the person with whom they dealt as opposed to the firm. Because that's why sometimes they'll just write a team name, because that's what they perceive to be the firm name.
I guess I'm just wondering, how big is the problem? You know, if it's not a big problem that we have these licensees who are doing all these evil things that we're not able to figure out who they are,
Right.
because the name is somehow confusing or something, if that's just not something that we're seeing come up very often, then I don't know that we ought to spend, you know, a ton of time coming up with some rule to make sure there's no confusion when there already is really no confusion.
I think really the licensees want some guidance on what to do, I think, in that.
Well, I think the issue of the similarities in names is more of an issue than whether you use your LLC or your company name. I think most people are going to use the company name, like Austin said, that they paid for. If you're a franchise, you paid big money for that company name, so you're certainly going to put it on the sign. But I think the similarity in names is where the problem comes in.
And I don't know, and Austin may know the answer to this. If the Secretary of State approves a name and a DBA, then would we be able to say that we would not approve it? Because they check for similarity as well. I mean, that's one of the things that's what I was looking for, because I have all their trade name stuff in here, but I can't seem to find it right now. Because that's one thing I don't know, so that if it was approved there, because we asked for their paperwork from the Secretary of State. I don't know the answer to that question.
I mean, you could end up with, I mean, it certainly would become an issue if somebody says, well, I've got my certificate of authority or my assumed name license or whatever from the Secretary of State, but you're not going to give me a license in that name. You know, I'm really excited about this name. That's the one I
Yeah.
want. You know, and so.
And I don't know that. I mean, I don't know. I don't know. What
Secretary of State is pretty strict.
Well, but they've all got all the same name.
Mr. Chairman,
Commissioner Alexander.
it seems to me that Commissioner Grease has spent considerable time since last meeting. It might be appropriate to hear what his recommendation is and what he's done before we go all the way around the world.
Thank you, Commissioner Alexander. Commissioner Grease, you have the floor.
Well, for me to stay organized, Mr. Chairman, let's talk about everything but advertising and get that off the table so we can at least get that done. What do you say? I read, like, on page 1 of these rule amendment drafts for discussion, I see no problem with the addition of number 5 under 1260-01-.01 and move that we recommend that language continue forward.
I'll second that.
Motion that we adopt paragraph 5, 1260-01-.01, application for examinations. Have a motion by Commissioner Grease and second by Commissioner DeShara. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. The language is adopted.
Mr. Chairman, I see no problem with additions underlined on 1260-02.02 and recommend and move that those move forward.
Second.
That's the bottom of page 1.
That is all of them, all the changes that are
Right,
proposed?
and then going into page 2 at the top.
And renumbering.
Commissioner Grease's motion is to adopt these and move forward, and have a second by Commissioner DeShara. Any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I'll move that all additions and deletions suggested by council on 1260-02.09 be adopted and recommend they move forward.
Commissioner Grease has made a motion. You've heard the motion, 1260-02-.09, seconded by Commissioner DeShara. We adopt these and move forward. Any discussion on this motion
I have one thing.
pertaining to managing escrow or trustee accounts? Yes, Commissioner Alexander.
How many folks use a trust account? What is the need for a trust?
And I've got that question
Trust
too.
account and escrow account are essentially very similar, if not the same, but they are often called trust accounts. The issue is making sure that the trust account or escrow account, the rules apply, period.
I can use either one. I don't have to use them both.
You don't have to use them both, no.
But I've just been through this and went to the bank, and they are very confused. An escrow account is what we use to put earnest monies in, et cetera. Where a trust account, if you're a trustee for, say,
true.
a child that can't make decisions for themselves or whatever.
Or
they're-
you can be the trustee of accounts also when it comes to
There's-
real estate
there's-
sales.
You can, but in general, those trust accounts, and then they have certain rules and regulations and the banking industry for trust accounts that they don't have for escrow accounts because they traditionally use them in another manner.
It's true, except for 6213-321, and this is where this rule is relating to, says escrow or trustee account of deposited funds. So I don't think you can eliminate the trust because it's in
Okay.
your
Call for
statute,
the
so
question.
that's why the
Okay,
definition.
I got you.
Call for the
I'll go with
question,
you
Mr.
on that.
Question's been called. All in favor, say aye. Opposed, no. Motion carries.
Mr. Chairman, related to 1260-01-.01, application for exams, I believe the additions are appropriate and recommend they be moved forward.
Motion by Commissioner Grease to move forward 1260-01-.01, application for examinations.
We just did. That's a duplicate of the ones we just did. Pages 1 and 2 are in there twice.
You're right, they are.
Or page 1 is in there twice.
I feel so strongly about it, I'd like to recommend it twice.
Commissioner Grease has withdrawn his motion.
So we're still on managing escrow accounts.
Oh, we've
already
handled that.
passed that.
No,
No, it
because
goes on, you're right.
It goes on page 3. We hadn't passed it.
Well, but he
I mean, there's still
recommended
more
that
on
we
page-
accept all the
We have to
changes.
pull out one again, but it goes on page 3 that I just
We
haven't
got,
read it yet.
we got two, my
Two
packet
page
has
threes.
2 threes.
But that's still the escrow account.
Yep, and my recommendation, I think that we voted on, was to accept the additions and deletions in total.
That is, and we passed
Well,
it
there's
and
2
it's done.
threes in here too.
I know,
Advertise.
if you got duplicates, tear them out, throw them away.
I can't tear them out of my iPad.
Do what? Commissioner
It's
Mc,
hard
oh,
to time
excuse me.
and tear it out of this
Okay,
iPad.
well, some of us over here have a
All you
hard copy.
antiques.
All these
If-
dinosaurs
If you
over
are
here.
skipping advertisement, the next one is 1260-01.18, if you are skipping advertising.
And let's, so if you go to page 6, members of the commission to page 6, there is a recommended rule from council titled 1260-01-.18 at the top of page 6, duplicate or confusingly similar firm names. And if you haven't looked at this, we might want to, since we've been discussing it already, take a look at it.
Well, I did look at that. I don't know why you'd have 100 miles, if 50 miles an hour, why do you have 100 miles? I mean, if the name of the firm is a name that's established in Tennessee, you ought not to be able to use it.
I agree.
I think more so now since you've got those franchises that are all across the state. I agree with you. It'd be the state of Tennessee.
That's what I believe.
Do we have anything else to look at besides advertising?
We'll come back, this is, not to be confused with advertising. I'm trying to get everything else out of the way. So
Well, I think that's all there is.
No, there are other.
Page 6 has, 7 and 8 have other.
Okay,
Right.
so this brings us back to how we address the Keller Williams particularly, because theirs is like the dream team.
That, Mr. Chairman, if I might, let's save this for a minute. Let's get the ones
Okay.
out of the way. If it's all right with the chair.
I was getting ready to say, Commissioner Grease, you are doing a marvelous job. You continue on.
All right, with
Page 7.
well, page 6 still, 1260 in the
Informal
center.
appearances.
1260-01-.19, informal appearances before the commission. That language seems appropriate to me, and I recommend that move forward.
It's on page what?
Page
Second.
6.
The middle of page 6.
Oh, okay, okay.
We've got a motion by Commissioner Grease and seconded by Commissioner Shara that we adopt the language in 1260-01-.19 and move forward. All
Wait a minute.
discussion.
We've had that come up before, and it seemed like a good thing. Ought to be a rule.
That's a motion.
That's a motion.
Motion.
And a second. Any discussion? Comments or questions? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, on page 6, at the bottom of page 6, there's a new rule proposed, 1260-01-.20 regarding military applicants. I believe it's appropriate and recommend that it be included and move forward.
Second. 1260-01-.20 military applicants, motion's been made to approve and move forward, and it's seconded by Commissioner Alexander. Any discussion?
Discussion on the top of page 7. I see.
Speak to the microphone here.
Mr. Chairman, I don't see any detail after 1. Payment of, I see a colon there where it says payment of late fees and other penalties, but I don't see any text.
Well, the line above it says that they can reapply without payment of late fees or other penalties.
Okay.
If they're on active duty. We're waiving that for them.
I'm satisfied.
Call for the question.
All in favor say aye. Opposed, no. Motion carries about military applicants.
Mr. Chairman, on page 7, halfway down, there's a new rule proposed, caption 1260-01.21, reinstatement of an expired license. I think it's an appropriate rule. Language is correct in my opinion. It reflects what we've dealt with in the past, and move that it move forward.
Motion made by Commissioner Grease and seconded by Commissioner Haynes that we adopt the reinstatement of expired license language in 1260-01-.21. Any questions? Discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries, and we're moving forward.
And as just a quick note, most of these are cases that have come before us that weren't identified or weren't handled by statute or rule, and so this is an effort to try to get some of those where we can actually point to a document and say it applies. On page 8, commissions earned by affiliate licensees, 1260-02.39. Again, this is an area we've talked about before. It seems very appropriate, and I move that it be approved to move forward.
Second.
Commissioner Grease makes a motion that we adopt the language in 1260-02-.39, commission earned by affiliate affiliate licensees, and seconded by Commissioner DeShara. Do I hear any discussion or comments? Hearing none, all in favor say aye. Opposed, no. Motion carries.
Mr. Chairman, at the bottom of the very bottom of page 8, there's a proposed rule related to electronic records, 1260-02-.40. It follows on page 9. Once again, this is a rule that I think is appropriate, that reflects our effort to keep up with the times, and I move that it move forward.
Second.
Motion made by Commissioner Grease and seconded by Commissioner DeShara pertaining to electronic records, 1260-02-.40. We adopt this language and move forward. Any discussion or comments? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, on page 9, a rule that maybe is appropriate to postpone, but we can at least talk about it here for a second. It deals with teams. And the more I think about this, which is an issue we've all discussed, I'm not necessarily, I think, I don't want to define teams statutorily or in a rule necessarily, but I would maybe refer everybody back just for a second to page 4, talking about advertising. And at the very bottom of page 4, letter F, number 3, you see it starts off teams and or team members. And my recommendation at this point, after thinking about this for a while, is that language be changed somewhat to say something like this: individual licensees who hold themselves out as a team or some other similar entity. So we don't get, I don't want to necessarily do anything that says we're sanctioning teams. But we need to address the issue that there are licensees who are holding themselves out as teams. And so if on this number 3 right here, my recommendation would be licensed individuals who hold themselves out as a team or some other,
A group other than a firm.
a group other than the firm they're affiliated with. Yeah, I like that. That's my point. Now, thank you, Austin.
Are you saying then, other than the firm that they're affiliated with, that gives them an opportunity to be a team other than the firm?
Other than the firm they're affiliated with.
Well, see, that's sort of confusing the way you just said it.
Well, all I'm,
If what you're saying is licensees who hold themselves out as a team other than the firm.
No, that's
no.
not what he said.
Okay, so say it
Austin's
again.
got it. Austin's got it.
As a group other than the firm.
As a group other than the firm. Okay, that still could be
Or you could
confusing.
say team or group other than the firm, something like that.
Yeah, that sounds better.
Leave the team in there.
Team
Here's what's
slash
gonna
or-
happen if you don't do what you're saying.
Licensed
They'll drop
individuals
the
will-
team and it'll come with another,
Right.
Yeah.
another
It'd
tag.
be-
And I'd put those little quotation marks around
Platoon
whatever
or
we're talking
something.
about, just because I don't want to get us pigeonholed into sanctioning a certain subgroup of a firm, for lack of a better term.
And they may change that, to get around it. Somebody else may call them something else.
So you're suggesting the language, I'm just trying to get this down. Licensees who held themselves out as a team or a group other than the firm they are licensed with. Is that what you're saying?
I'm trying not to define team.
Yes, I understand that.
Okay.
But I'm just trying to get the language down you said so that I can give it to her.
I'm gonna,
Licensees who hold themselves out as a team
Huh?
or group
Uh-huh.
other than the firm.
That's what I said.
and I might put or similar entity. I mean, I don't want to box us into team or group.
Licensees who hold themselves out as a team or a group or similar entity other than the firm they are licensed with. Well,
How about
with whom
within,
they are licensed is something else.
how about within the firm they're licensed with?
Okay. That's what I was suggesting. And within the firm they are licensed.
With,
Under the definition of team, you've got group, squad, company, party, crew, troop, bands, side lineup, and more. I mean, all these are teams.
He's just getting started.
so, Robin, would you read back what you have, just so we're all on the same page?
Well, let's see. Licensees who hold themselves out as a team or a group or similar group other than, what?
A similar entity.
Or similar entity other than the group
Within the firm?
within the firm, other than the name of the, well, I didn't have name, other than the group, other than the firm they are licensed with.
Within, I'd say within the firm they're licensed. You don't have to go past that, I
Within
don't
the
think.
firm. Licensees hold themselves out as a team, a group, or other similar entity within the firm they are licensed.
Perfect.
Okay.
Does that work for this commission?
Yeah.
Yes.
Okay, then I would suggest, if you're comfortable with that language, you go back to page 9 for just a
And
second.
do the same thing.
And just get rid of that.
Well,
No, just.
I think that the caption, at
Add that same
1260-02-.41, instead of saying teams, it would be the same language we just wrote down.
Teams
Or other
or
similar
group
entities.
or similar entity. Where licensees hold license.
Within the firm, they're, within their
Well,
firm.
Within licensee's firm.
Right.
Okay.
Okay, now if you buy that, then if you, members of the commission would look at numbers 1 through 5 at this point with that as the caption and see if you're okay with that language. Hey, Kelly.
Do you still want the Chris Burns?
I might.
You're saying every time they use the word team, use that whole.
Yeah, we're not singling it out just as
Right.
teams.
I like that.
And
What
say
about
that all the
5,
way
John?
through there?
1 through
Yeah,
5, he said.
Yeah, I think you're right, Wendell and Grover. We also need to modify number 5, neither the team.
Well, then, what you're suggesting is then it would read, all licensed teams or group or similar entities within the firm where within licensee's firm must be affiliated with the same licensed firm and must, I think that's,
Could you not say the leader of said team, group, or similar entity?
you can on one of it, but what do you do for one? All licensed
Members.
blank members.
All licensed members of
Okay,
the team, group, or similar entity
okay,
Or all
must be
licensees.
affiliated
okay,
with the same
licensees,
firm.
yeah.
okay.
What about, but, I mean, substantively, with respect to this number one, do we require currently that all real estate activities be conducted from the physical location of record of the firm? I mean, does that mean you can't make a phone call except for from the office, or when you're out showing the property? Isn't that a real estate activity? What, I don't understand. Is real estate activity defined somewhere?
It only, as it would be defined in the definition of broker, so it's not defined as, real estate activity per se, no.
The intent is the team or related group can't be housed at a separate address.
Like have a branch office that's the.
That's the intent.
Yeah,
I'm
that's
not
the
sure if that's what it
intent,
says.
yeah, but as I see it, you
Yeah.
could interpret that pretty broadly and.
But there's
I mean, real
several
estate
people who never
activities-
come
Yeah,
to the
we-
office.
There's a
They
lot of
operate
stuff.
out of their
Yeah.
house.
We're headed to virtual offices, definitely. Yeah.
Okay, now, may I ask?
Oh, yeah.
When you are,
Listen,
number two, for instance, when you said the
Yeah, we
licensee is
should.
principal broker, not the team leader, how are you going to define that leader?
What if the team leader is the principal broker?
Well, my point is, team leader. I'm trying to get beyond that
That's,
term.
that
But why
says
don't, what
team.
isn't there a statute that says the
leader.
principal broker has to pay everybody? There is. Why don't you just
Well-
track that language?
That's not, that language is not very.
Yeah, it's not.
Just leave out, not the team leader.
Well, what you
Just-
can say is only
in
principal
312.
brokers can
What
pay
is it?
members
Yeah.
of any group,
Can
team,
pay each
or.
licensee of the team
Because
or
it's
group.
not that clear. Only principal broker can pay members of group, of the team. groups,
Licensees.
Licensees, well, of the-
Licensees of team or group.
of licensees of team, group, or other similar entities.
Mr. Chairman, I think John's heading this. I'm thinking that you'd have teams, and the teams are certainly going to have licensees, but teams that are successful are probably going to have non-licensed personnel that do what's permitted there. But in all of Section 41 teams, it seems to be referencing only to licensees. So, for instance, at the end of 2, must pay every licensee. Are we concerned that the broker also be responsible for paying a secretary?
Because they can
No.
pay for unlicensed activity.
Yeah.
They can pay for clerical staff.
I think the
You're saying
intent.
licensees can pay for, excuse me.
Yeah, you can pay clerical staff.
I
It's just
think the intention
312.
was to make sure that, as she pointed out here, that it isn't a team leader paying commissions or anybody but the principal broker paying the licensees. That make sure that it's clear that if you have a team or group, it is still subject to the supervision and the payment of the monies through the principal broker. I don't think it was intended, and I don't see it that. I don't think she intended to make any other statement, because of course you can pay unlicensed persons who are acting in unlicensed
A
areas.
licensee, someone other than the principal broker
Right.
can pay secretarial staff,
Yeah,
absolutely,
somebody that licks
Yes.
envelopes.
absolutely.
that's right. According to your statutes, you can.
Good.
I mean, we're all independent contractors, so we can hire help.
On number 3, Robin, are you clear on that
I'm
one?
there. It's in principle not to negate his supervisor's responsibility to, I would say, any member of the team, group, or other, whatever you
Entity.
called it,
Right.
period.
As the principal broker remains ultimately responsible for
Right.
oversight of,
Right.
and I might at that point say something like,
Individual
all the
license.
licenses that claim to be affiliated with the team, group, or other entity.
Group or other entity.
Well, I don't know if we're going to talk about that one. I'm not sure that can.
Mr. Chairman, Can I ask the
Mr. Bloom.
Can I ask the vice chairman a question?
Yes, you may.
Available.
Well, here is what we're trying to do, is avoid recognizing teams, and we are, as a commission, creating a separate rule entitled teams.
Change that title.
Well, I know, but I don't know why well, can't we take the terminology in 41 and somehow interact it into 1260-02-12 and eliminate that whole paragraph? Which, however we couch it, we're identifying teams.
Well, the only, my discussion with you is that this, 12 is related to advertising, and we're basically in this section, as much as anything, talking about the management of loosely affiliated licenses within a firm, not necessarily an advertising component of it. That's the distinction I see.
Mr. Chairman,
Commissioner McMullen.
could I respond to Mr. Bloom's comment and
Yes,
Mr.
you-
Grease's response? It seems to me that each of the points that are here under this rule are really already out there in the statute in one way or another, and you're just collecting them in one place and explaining how they result or how they're applied to this concept of teams. So I don't know that, I mean, I think it may be beneficial to have this explained to people, but I mean, by putting it in a rule, I don't know that you're really you're not changing anything that doesn't already exist, and you are, if you're concerned about recognizing teams, you are sort of implicitly recognizing teams, as Commissioner Bloom said.
Well,
If I could respond, Mr. Allen. So part of the issue we're trying to deal with is a confusion within the real estate industry about this entity that's out there, whether we describe it or define it or not. And so as clarity for people who are trying to do it the right way and want to understand exactly what they can get away with, I think it's appropriate to have this rule. It's going to be floated and presented in front of a whole lot of bodies before we ever get to actually being a rule, and I think we'll get some pretty significant comment on this portion of it that I think would be appropriate.
I think that if you don't do this, you'll have it introduced anyway. It's coming.
Well, I've had question asked to me, and this goes back to this and the advertising, is if we're going to have something on the Trek 1 form, for instance, so that they can register their team name because they want to advertise on their signs as a team name. And I mean, we're telling them that they've got to advertise as they're registered with the Real Estate Commission, and they want to advertise as their team name, so.
They need to open their own firm at that point.
They need a firm license.
They need to get them a broker and open their own firm.
Yep. That's my response to that, and this response I hear from industry people across the state. I understand what they want to do, but our job is to protect the public, not.
Well, I mean, that's a question that's been asked to me, so.
And that'll be asked as we go through this rule process. I suspect this may be one of the most discussed areas we'll have to deal with. But it's an issue that's in front of the trade association, it's in front of the staff, it's in front of the public, and there are real estate brokers and agents across the state who want clarity, and this is the intent.
So at this juncture, we're saying no, they're not going to be able to register that team name.
We don't. I think statutorily they've got to have a firm license.
I think the nationwide concept
be
is
by
to
statute.
go with teams, and we're have this forced upon us, and all we've got to do is stick to our rules. We don't need to create a new instrument. It's there. We're just flip-flopping and afraid to make a decision, but the rule's already there.
Well, it is and it isn't. There wouldn't be confusion if the rule was already there.
It is there, but we're not interpreting it. We're letting everybody float because they're a big firm. We want them to have a team. The rule is already there. They're supposed to advertise the way they are with the commission, period.
But within that firm, and I think we're saying the same thing, Grover, within that firm, there are mutations of what's traditional real estate. And it's these affiliates within
But
the
who's
firm.
let it mutate? We have.
Or the brokers have, or the law is unclear. The
We've
rules are
looked the
unclear.
other way for 2 years about it.
Well, we're making progress, so wouldn't you agree?
I agree.
All right,
You're
good.
looking at right straight in the eye
Yeah,
today.
we're trying to get it right.
Oh, where are you?
Okay, on number 4,
We already talked about neither the
okay.
team group, you already
okay.
got that.
Number 5, this goes back to a point that Mr. Alexander brought up earlier today. We can refine the words, but the team leader shall not designate team members as designated firm agents, as this remains the responsibility of the licensed firm principal broker. That's redundant. We know that's already the case. Mr. Alexander brought up this issue of within a team, if we even recognize a team, can there be one agent, one licensee representing the seller in a transaction and one representing the buyer in the transaction? My response would be company policy starts the discussion. And if that's allowed, it's still not up to the team leader to make those appointments, but the principal broker could, I suspect. And that's for discussion purposes.
Well, my opinion would be that if we look at each person as an individual licensee, then that's has to carry across to agency and all across the board. And that if you work together as a team, then you've got one that can be the buyer's agent and you've got one that can be a seller's agent if you practice designated agency within your company.
As long as the broker agrees.
Yeah, that's what I'm saying. I mean, because that's still a broker decision.
I disagree with both of you. If you're gonna,
there.
if you're gonna let them do it, the principal broker has got to designate which one is the buyer represented.
what we said.
And no, you didn't. You said that they could do it themselves within a team, but the principal
Oh.
broker, well, let me finish what I got in my mind, then we'll.
Get it off your chest.
Yeah, that's
Let's
right.
go. Let's hear it.
That the principal broker will designate which individual represents the buyer and which individual represents the seller. Now, if you've got 6 folks in the team, you're gonna let 3 on one side and 3 on the other?
No, you're gonna let the broker designate which one's represents the buyer and which one represents the seller.
But Janet, these folks that are operate these teams, the way I understand it, I don't have a team. I got a one-man team. When you even got them paying themselves and dishing the money out according to what you did, how can you represent the buyer and the seller?
If you practice dual agency, perhaps you can, Wendell, but not many people are doing that. So,
Or
I
be
thi-
a facilitator.
so here's well, then you're not practicing
Then
any
you're
agency.
you're not representing anybody.
So if I go to Craigslist today and I see under real estate services and somebody's advertising that John Grease team is looking for a buyer's agent, that can't happen, can it? Because I'm not the principal broker.
You're not the principal broker.
Right. So this is designed to clarify who's in charge. I mean, that's the point of all this, really, is to say who's in charge. That we're not delegating or allowing anything that passed from the principal broker down to so-called teams or other groups.
But I can run an ad that says Exit Select Realty is looking for buyer's
If
agents.
you're a PB, you can do it.
As a PB, I can do that.
And that's the point of this number
And,
5.
and so if I want to appoint certain people in my firm as buyer's agents and certain people as seller's agents, I can do that.
You have to do it. I mean, sure,
And,
responsibility.
and it doesn't matter if they're on the team or not on the team.
Okay, then why not make them show proof that the principal broker designated those 2 agents, or those agents?
So how are you gonna do that?
Well, you're gonna sign a form. That'll be part of the designation.
So that means if you're a buyer's agent, you can't.
Nothing.
I'm gonna suggest that we'll continue to get
I'm confused.
we'll continue to get all kinds of comments about this little rule addition as we go through the process. Are there other comments in general, or are you okay conceptually with what we've talked about? So
I don't understand how you plan to change number 5.
we don't.
Okay.
There's no plans to change number 5.
Okay, so you're except for the terminology as team leader.
Right.
Right.
Okay.
We still want the message is the
I thought we
broker,
changed it.
PB makes the decision, not a
Okay.
team leader.
So all you want to change in number 5 is the team, group, or similar entity, okay.
Commissioner Alexander, if you were to go that TAR contract, you'd find all this.
That's what I was gonna say. Anyway, you want to say it. I was gonna let it slide.
Mr.
Yeah,
Chairman.
we were thinking there was already forms in place for that.
Commissioner Grease.
Mr. Chairman, with those changes noted after our discussion, I move that 1260-02-.41 continue forward in the rulemaking process.
As amended, as discussed, and as we all agree that we want to adopt, and it's seconded by Commissioner DeShara. Any other comments? Hearing none. All in favor say aye. Aye. Opposed, no.
No.
Let's let the record show it's 8-1.
Mr. Chairman, on page 4, 1260-02-.12, advertising. We've already made one change to this down. Letter F, number 3, now reads, licensees within a firm hold themselves out as a group, team, or other similar entity. With that with that change made, look at number 4 at the top of page 5. That I would suggest that where it says any team, that be modified.
May I suggest that throughout this advertising rule where the word team is used, you might want to consider your language as already approved?
That's a good idea.
Any
Thank
problem
you.
with that?
We don't need to have to find team everywhere it's written.
Chairman Grease?
Yes, sir.
Can we go back and address Austin's comment about the name of the firm?
Yes, I'm kind of saving that to last.
Oh,
And-
okay, I'm sorry.
And we're almost there.
Okay.
I'm just,
Okay,
that's
I
all,
just-
I
okay.
think we can get an agreement on most of everything else. As I look through this, members of the commission, there's a discussion on the web page or internet advertising. It's number 4 on page 5. Now, each of the captions, like on number 3 above, it says advertising for franchise or cooperative group, advertising groups. I'm not sure what the headline of number 4 will be. Got 5 guarantees, claims, and offers, but there ought to be some description of what's in the body of number 4. And I'm not sure
Digital?
I'm not sure why Julie struck internet. It's
Well,
really not-
I think she actually just clarified it. In addition to the other advertising that's already listed.
Yeah, but she took out the title, internet advertising.
Yes, and she's just saying, in addition to it, then the following requirements also apply to the internet. So I think she was just trying to be clear that this is not just the only thing that has to be done in internet advertising. It's internet advertising has to include everything talked about, and this in
I
addition.
think they would like the title put back in there,
Can we
though.
not put the title back in, is the question.
Like internet advertising, period, space, in addition.
Yeah.
Now, what I did not see in here, and maybe it's included in that, is anything that relates to social media. For instance, is Facebook and internet advertising?
What if we said digital advertising?
Oh,
That's a digital photo.
I think, do you know, to answer your question, do you know how Facebook can be accessed other than through the internet? Do you know how?
Own app.
Well, but that's still internet. You still have to go through the internet.
Some would make the argument that's not advertising, that's social media. And I disagree with that argument, but I'd like to make this clear that if somebody goes in there and I'm affiliated with a company and I put John Grease, the John Grease Group, and have my own Facebook page that says John Grease Group and never mentions the company I'm affiliated with, is that okay or not?
Well, maybe that should say internet advertising and social media. Or like Michelle said, digital marketing.
So you'd like it, if we're going with what Michelle said, in addition, other advertising guidelines within the rule, the following requirements shall also apply with respect to digital advertising?
Well, I just know my techie.
I'm just asking.
That's what
yeah.
they called, so I don't know.
Well, and the thing about it is, today we have Facebook, and we have Twitter, and we have LinkedIn, and tomorrow we may have Fly the Coop. Who knows? I mean, we're just going to continue to get more and more digital marketing out there, so I don't think you can specifically name.
So would you like to change it to number 4, digital advertising, and then where it says internet digital advertising?
And I'll get back with my people that are in digital industry and ask them, but that's the terminology I keep hearing them use to be all encompassed.
Rather than advertising, are we talking about digital communication?
Oh, but this is applying to advertising, period. Any advertising you would do digitally, or on the internet.
But he's saying, is it advertising if you just, like, if you just have Facebook and put something on there, that's not, someone's gonna say that's not advertising, so that's why, that's, I think, what.
Why you'd say what?
Communication, or something that would broaden it.
Digital
So that-
marketing?
Or something that would be.
Digital marketing or communication?
I think at the very least, based on what I'm hearing, it should be internet advertising, including digital marketing, or something along
Or
those lines.
online is also used, I'm looking it up on my phone, is the online advertising, digital advertising, internet advertising, those are the three
Well,
terms
but
that are
I see what they're
interchangeable.
saying. It's not, it may not be considered an advertisement, but rather marketing.
Marketing, but those are the, online, digital, or internet are the three, and, yeah.
And I,
What, Robin? Go ahead.
well, I was just going to suggest, I'm not certain you can come up with a term that won't be not relevant in a year or two.
Well, that's why I'm going to Wikipedia.
Well, so this may be another one of those topics, if we get at least in the rulemaking process, we'll get comments on that'll help clear
Push it
this
out
up.
further.
So if we took internet advertising, digital advertising, and other internet advertising or something, I don't know how you do it, but I want to make sure it's encompassing and not just considered internet advertising, because I can make the case that my personal Facebook page where I never identify the real estate company I'm with, it's not advertising.
If you say internet advertising and other advertising through the digital process,
That's great for starters. We just need something.
Well, Wikipedia, online advertising, also called internet advertising, uses the internet to deliver promotional marketing messages to consumers. It includes, and then if you could, we might be able to just go to Wikipedia and get a definition. And include social media marketing, any types of display advertising, include web banner advertising and mobile advertising, like other advertising media. Online advertising frequently involves both publisher, and then it goes on other descriptions. But that's the internet's description of what we're talking about. So I don't know how we should put it.
Well, the commission just want, they want a title, you all want a title that's broad enough to cover.
They've got it under online advertising.
Right.
Why don't you let staff come up with that and we can doctor that
Yeah.
before we go back?
Well, get up here and talk in that microphone.
And it's not hard to look on the internet and figure it out.
you're suggesting, Mr., is that here?
Mr. Vice Chairman,
Yes, sir.
I think that Facebook, and I don't know how to do it, but that doesn't matter, that's going to become one of the biggest means of marketing that there is. And what needs to happen, in my opinion, is you need to use the same terminology that you've used all the way through about teams, whether it be teams or whether it be a principal broker. Anytime you're there, you're subject to this commission.
Right, well, this section really applies to every licensee.
And I'm going to give you an example. YouTube is the #2 digital format for search engine right now. Google's #1, YouTube is #2. So the younger generation, and I don't know how we're going to work this into our industry, but we probably are. I mean, so where does YouTube come under?
Oh, they're already YouTubing
Yeah, I know.
virtual tours and everything
and I know
else.
they are. That's why it needs to be included in this, and that's why we probably need to take a standard term from
So what Mr.
the
Alexander
industry.
had suggested that may be a way to go is accept the terms and come up with a name to be presented at the next meeting that might be given more thought.
And I was just happening to think,
That gives Commissioner McMullen time to come up with the proper name.
think about it. The average age up here, if you average us all together, is probably about 60. Commissioner McMullen, his younger generation, you're in charge of this.
Down the average.
You're bringing the average
I resent being lumped in with you old people.
I don't want to.
That's 65
So,
like you.
Robin,
would
I don't
too.
want to do anything to slow this.
Social Security.
To slow this down.
We got a lot to do. Me and you. I'd say just come back with
No,
something
I don't
and
want-
let us think about
I
it.
don't want you to come back with it. I want you to start the rule process, and then if we have to modify the caption at some point,
Me
we
too.
should have that latitude
So
to do
leave
that.
it at internet advertising and
Or-
modifying
Or expand it, whichever.
As Eve did point out, you must understand that the very first number one, it says all advertising regardless of its nature and the medium.
Right, and all I'm suggesting
So-
is some would say Facebook is not advertising.
All,
Others would argue that it's misleading to the public if you have a Facebook page and you don't list your company's name on it.
I'd be willing to argue that.
And I would argue that too.
so what do you want to do?
I think we'll leave it, why don't we, if we leave it at internet advertising, and when this comes back to us in March, or whenever it comes back to us, we've decided it's internet advertising and social media, or whatever we decide, we can modify it at that point and not slow the process down. Is that correct?
You all will have it, like, once these changes that you say today, then Julie will bring these back next month and hope to do the regulatory, what's it called, the Flexibility Act. So you'll have a chance next month to say, oh, okay, well, you know, can we change this to whatever it is? I mean, not make major changes, but, you know, to make smaller changes. And then I really think probably would be April, because we have to have SB 57 days that it has to be publicly out there. So I think probably you're talking about April by the time you'll be able to get the rules up and ready to.
So she could come back with, after discussion, another proposed set of names or.
Perfect. Is that,
Yeah, it won't hold it up. She just.
that's what I'll make sure of.
I'd like to give the floor to Commissioner DeShara, who has some interesting information.
I was watching somebody think out loud, and I thought I got his point, and he was saying World Wide Web, and we could say that. Anything on the World Wide Web, this is the rules for it.
We have standard definitions already on the internet. Let's just go to the internet, and according to the FCC and according to the federal standards 10037.3C, I mean, they've already got standard definitions that describe what we're talking about.
But what Robin's saying, and what I agree with, is that by the time this rule gets through the process, it's going to be different.
No, but what I'm saying, they've already got standard federal definitions for what we're talking about.
Well, in the effort to keep us moving forward, conceptually, are we okay asking this rule to move forward?
Sure.
And with understanding we can modify the title if we need to in the future.
Yeah, we can
Mr.
modify
Chairman,
the title, and we can all, yeah.
I'll incorporate that in the motion entirely on advertising. I think the last contentious point might be about the name of the company that we've talked about, and I'd like to open that back up. And I want to make one statement, Austin. Part of what, and anybody else on the commission for that matter, so let's go to Keller Williams for a minute. And if every branch of Keller Williams is called Keller Williams on the sign, that's one thing. But if they put on the sign KW Homes or KW Commercial, and they're not licensed either as Secretary of State or the DBA, then that's a violation. Would you agree? We're clear on that, I think.
Where are you, what section
Well,
of discussion?
we're just talking conceptually for a second. Then I'm going to go to Mr. Bloom, who's.
Are you also talking about the duplicate or confusingly similar firm names under?
Yeah, it all kind of falls in that. This is just kind of a overall general concept about the signage.
From an we're still in advertising. I think we've kind of handled the duplicate or confusing. Oh, no, we didn't.
No, you didn't.
We asked to move that
No, we
until the end.
skipped that.
I don't know if that's currently a violation, but it probably ought to be.
Use a name you're not licensed with?
Because right now you got 6213.310B. It talks about licensees putting their name larger than the firm's name, but it doesn't talk about other names being larger than the firm name.
Like I'll see occasionally a Caldwell Banker sign that says Caldwell Banker International Homes. Well, they're not licensed by that. It's just a marketing tool. So part of the effort is to get the right name on the sign, whatever that is. I don't know if there's any dispute about that being an issue.
What had been proposed is that the name of the real estate firm as listed with the commission, that's what you have proposed, has to be the prominent entity featured within the advertising.
That either or, was that your, either the registered name or the DBA?
So you're saying the name of the as licensed with the commission or Or
Know
what?
that it can be the DBA or the,
Okay, sorry, I'm just trying to get this clear for Julie since I'm not doing this. It's the name, okay, for, under number one, it's the name, what? What name? The firm name, what, as licensed with the commission or as with the Secretary of State or what?
I think it could either be the firm name as licensed with the commission would be fine,
Okay,
or the, I'm not sure exactly what they call it at the Secretary of State. But the
over the name registered with the Secretary of State.
the corporate name registered with the Secretary of State,
Okay,
or the DBA name registered with the Secretary of State.
Then
and that is the one that must be the prominent entity featured,
yes.
One of those.
okay?
So would you think that the person would need to make a choice, or could they use signs that have either one?
Or all three, depending on where the sign is for what it is. Like we heard earlier, property management.
I think they kind of need to make a decision and stick with one.
My
I mean,
personal,
I don't, it doesn't matter to me. I mean, I don't know why we ought to tell them. As long as it's one of those three, then at least it's not confusing or misleading. I don't know that it's our place to pick what they ought to put on there.
But if they do it, they use only one.
They only have to use one.
Mr. Bloom?
here's what I think the commission's job is, to protect the public. And Austin has said, we're protecting the public. It's what you told the state or what you told the real estate commission is how you're functioning. Is there anything confusing about that?
And that was what I was asking Eve about earlier. I mean, we're not aware of a situation in which somebody has wanted to file a complaint and not been able to because the staff here couldn't figure out who the complaint was going to be against.
And then I don't think it's my call to tell Jim which sign to use, as long as the state said it's okay. And as long as I can track Jim's activities from that sign, either at the state or at the real estate commission.
I think they just need to be allowed to use either or and not have to put all that stuff on the sign.
Oh, no, I don't think
Yeah.
they put all three on the sign, but I think Michelle said, depending upon the circumstance, you might use sign A or sign B, as long as they're all approved.
My concern was, as I was looking at the rule, it said they were required to conspicuously list the entire name of the real estate firm as licensed with the commission. And that can be a really long name. That's NYPD LLC DBA Exit Select Realty.
Would you agree that whichever name they pick, they use it continuously and not flip it? One of the three.
I don't see why we ought to require that. It's my opinion.
Well,
I mean, the fact is, most people probably are going to stick with one. I mean, that's what you try to do. You try to create a brand, and so you probably are going to stick with one, but I don't know that why I would have to tell them that's what they have to do.
But my point, the reason I asked this, raise this question is that if I get to flipping from one to the other, if I got a billboard with one thing on it, I've got a sign with another on it, and I've got a letterhead with another, how am I gonna know which is which and who is who?
Well, if Janet started advertising as NYPD LLC, the state would be able to know who that is because it's in the records. It's not difficult to figure that out. She probably would not do that because she paid a lot of money, I assume, to use Exit Select Realty.
Well,
But she could if she wanted to.
I agree with that, but when you get back to KP and you got to the initials and all, and you're not, and it's the franchise is Austin where it is, and you're not being able to determine which company you're dealing with. In fact, if I had one, I'd want some kind of designation where people know who I was, except just to Keller Williams, because if you got the other guys are a bad apple, you're gonna get credit for it. Now, are you protecting the public that way?
Well, and I think that's back to the similarity rule over here, which we need to figure out some way to make that where people know which office it belongs to.
But we haven't heard instances in which the Trek staff is confused about which Keller Williams we're talking about.
Well, but Austin, John brought several examples, and if any of you work for Keller Williams, we're not just picking on Keller Williams. This is just one that's really confusing. A lot of them advertise KW, and that's all that's on their sign. You see a K and a W, and that's it. The public doesn't know what KW is, and they don't know how to connect that if there is not a name writer on the sign that has my name on it.
I agree, and I mean that if the licensee's name is on there, then the firm's name has to be on there in letters at least as big.
But what I'm saying is reverse of that. They take my yard sign and put it out there, and all it has on it's KW.
That's automatically a violation if it's not registered.
That should automatically be a violation, but we're seeing them all over the state. All they got on them's KW. It doesn't have the agent's name on it. Okay. It's just got KW and a phone number. To me, that's very deceptive to the community.
Maybe. Is that currently a violation of our statute, though?
Yes.
Yeah. So
Which section is that a violation of?
Well, you
can't advertise.
All advertising has to be in the firm name,
Yeah.
that section? Okay.
Yeah, because KW is not the firm name.
But if they added doing business as and set up a KW LLC, it could be, but
Well, if they do, then they're registered at least.
then they're
at that point.
registered.
On this advertising rule, the additions and deletions, I need to, I want to see if we're comfortable with the firm name, what name they can advertise under. Gary and Austin, are you comfortable, or do we need to make sure to spell it out before we send this on? I want to make sure we get that handled so that it's clear.
Well, if we go on with number one like it is right now, Janet, aren't you in violation?
Yes.
So I don't think we ought to do that.
Okay, so do you have a recommendation, or?
Austin, what Austin said.
Where do you
Whatever is approved by the state or whatever the entity is, the LLC.
Where would you like that to fall in this advertising?
I'll defer to, Ms.
I think-
Crop or Ms. Maxwell or Robin. That
Thank you.
If it's somewhere in there,
I
you
think-
could just say, you probably could have another section in here that just says, as used herein, firm name means.
Yeah, you could have that.
Does that fall under general principles?
It's under general principles.
Okay, that's where I'd
so-
place it, somewhere under general
So
principles.
you could call firm, what then, and Mr. McMullen is right, you can have a section, firm name means the name listed the commission.
Perfect.
Or the corporate name is registered with the Secretary of State, or the doing DBA as registered with the Secretary of State. That's
And
what you-
Ms. Maxwell, does that help or hurt?
So the Secretary, I've found my information from the Secretary of State. The question I asked her earlier enough was if the Secretary of State approved it and approved the name and the DBA, do we have the authority, or could we say, no, that's similar or too similar? Because the Secretary of State's information says that they will in fact approve names that are similar if an existing business consents to it. I mean, so they have a whole different set of guidelines that they use.
But if that existing company consents to it.
Well, there are 6 of those little
Yeah.
kind of exceptions that apply.
I want to be sure that I know where this was going. We were still in 12 advertising. We haven't gone to duplicate or confusingly similar firm names,
No,
right?
we're still in.
I'd put it number 2G. Under general principles. There is no G, it'd just be an addition.
Oh, I see, make it in G.
Yeah.
Well, actually, I think you're probably going to have to do firm name up at the top.
Yeah, I think so too, and just read,
Smooth
number
everything down.
everything else.
Ms. Crop will put it in the appropriate place.
I'm not worried.
Which firm name means, and that's what we're going to put in there, right? In advertising, correct? That's where it
Correct.
is? Okay, I'm just making sure.
We've got time to talk about it.
You hope what?
We're not opening up a can of worms.
I don't
with
mean
all-
today.
I hope you don't mean
I mean,
today.
I could see
That-
3 different names for one company and the
We may
confusion with the
revise this,
public,
yeah.
it
We've
would be
got-
very confusing. But
I think just
let's
putting it
look
on
at
the table and see what
Put
kind
it
of
on the
response we
table. I
get.
agree, I agree.
Now, is there, what else do you want to?
1 second.
Well, John, is that going to address inside that then people putting like Exit Select Realty Commercial Division?
Well, divisions we haven't really spoken about yet. We're making progress.
Okay, so we're
All right.
gonna get into that before we go to the,
Perhaps. I don't know yet. Based on our discussion, I'm going to make a motion that 1260-02-.12, as amended through our discussions, proceed on the rulemaking process.
Second.
Have a motion by Commissioner Grease and seconded by Commissioner Alexander that the things that we discussed and staff has noted will be amended, and we'll have a copy in January, according to advertising, be adopted and amended to move forward.
On page 6, we have one last proposed rule from council, duplicate or confusingly similar firm names.
do we need to vote?
We're going to vote on this motion?
Oh, I'm sorry, excuse me. That's
All in favor, say aye.
Aye.
Opposed, no.
Who seconded John's motion?
Commissioner Alexander.
Okay.
Okay, top of page 6, duplicate or confusingly similar firm names. Mr. Alexander, Mr. Bloom,
Yes, sir. I'd like to suggest that we put a period after issued and eliminate within a 100-mile radius.
I second that.
Any comments or
the
questions?
effect of that would be that Volunteer Realty Company in Knoxville there couldn't be another Volunteer Realty Company in Memphis.
Well, what it says is that the commission has the right, in order to protect the public, if it's confusingly similar, not to allow that.
All about it. I just want to make sure
Yeah.
we're thinking the same thing. Numbers 2, 3, and 4, any comments from commissioners on the procedure?
Hey, I second his motion.
I'm with you. I'm ready.
Call for question.
I'm not ready to call for it yet. I think we can get this all done in one motion.
Oh,
Yeah, we're
If
we're
there-
dealing on 1260-01-.18. We'll do it in its entirety.
Okay, as a friendly amendment from Commissioner Bloom, seconded by Commissioner Collins, now to the full 1260-01-18 as amended, I'll move that this proceed forward in the rulemaking process.
Well, I still have a question there, John, on how we're going to address all the ones who are using the same name currently.
I need a second, probably my
I'm going to
motion.
second it for this.
Okay.
Second for discussion.
Commissioner Grease has made a motion that we adopt 1260-01-.18, duplicate or confusingly similar firm names, with the deletion of within a 100-mile radius. That's been deleted from number 1, and is seconded by Commissioner Alexander. Discussion on the motion.
Well, to answer your question, Jan, I don't think we can go backwards. I doubt if we could go back and tell companies they have to change their name because it's.
That's correct. You can't retrospectively apply the rule. However, for continuing advertising going there forward, it would apply.
Well, and it's not them changing their name. It's the name that they choose to use.
But as far as this particular duplicate rule change, is that if there's already entities out there that would be right now in violation, you couldn't come back and punish them for it, but once this was in effect, then they would have to make the changes to comply with the rule.
You ever heard of grandfathering?
Yeah, bad thing. Don't even get me started.
So your concern, and frankly, this can continue if they register as Keller Williams Realty with the Secretary of State. They can advertise that. I mean, we've already said that's a possible way to do it, right?
Well, that's why we're addressing it in the similarity names.
They can register as KB too, that's what I get that while ago.
Right.
You're gonna wind up with three different, you can conceivably have three different, one company can have three different names. KB, Keller Williams,
But we don't have to accept it.
and DBA.
Is that correct? We don't have to accept it if it has a similar name. Under this rule, we wouldn't have to.
Well, and that's what, I mean, under this, we don't, what I don't know is whether we can, if it's been accepted by the Secretary of State, I mean, I don't know whether we can overrule that, but I mean, if we can, then we could turn them down because of that. But I think Commissioner Alexander's point is that if you could advertise in your whole name as registered with us and in the DBA, either or, and the DBA, or in the first name, then you could conceivably have three names. I mean.
So how is this gonna clean up the problem we're having?
It's just gonna create one.
Well, I don't think so. You can advertise right now in two names in your company. You can have a property management company and your real estate company. As long as I know who I'm dealing with, if I'm a member of the general public and I know who I'm dealing with, that's all our concern is. Are we protecting the public?
And I don't know that we have much of a problem right now.
Well, we said we don't.
Well, we do in the respect of the franchise, all the franchises are using the same name when there may be 6 in the same town.
They bought the
where's the
right to
problem?
do that.
Well, but
They
that
bought
was-
the right to do that.
That's one of the problems we're trying to address here is how does the consumer know which company they're dealing with?
Eve said she hadn't had any complaints on that.
I said that.
Oh, she didn't say that.
I just said we haven't had anyone call up and say they didn't know who to file a complaint against. I mean, they just they just send it in against usually a person just because they don't, lots of people just don't name a firm because they don't know the firm.
I'd suggest to the commission that these are all good questions and reasons and issues and topics you ought to think about over the next 30 days, but if we can at least get this moving forward and give people time to consider it and let other people give us our opinions, it may clear up a lot for us as well. So, since
I made a motion, I'm gonna call for the question.
you seconded my motion at the time, Mr. Alexander, and I appreciate that. By the way, here's a short abbreviation. Chairman Stevenson is thinking about changing his name to BS Realty for some reason. I'm not sure.
I think it's very appropriate.
All those
All in favor say aye. All,
Aye, BS Realty and Auction Company.
all opposed, no. Motion carries.
I think that could be confusingly similar to some others.
Hey, Kelly, do you know that slide I asked you to put up? Can we do that just for a second, then I'll be done with this? Okay. How long?
Couple of minutes. My iPad's going dead.
Let's,
I think it should be explained that the B in BS would be bear and not bull.
hey, so forget it, Kelly, if it's going to take that long, because I've got to let Robin get out of here.
Yeah, we were trying to get her out of here early and.
Let me mention one thing we haven't discussed today that we've discussed previously, and I don't know how you want to, if you want to address this in a rule. I don't think it's in here anywhere. We've talked about this notion of divisions within a firm. For instance, a company saying they've got a commercial division.
Property management.
Or property management or new homes division.
Yeah.
Is there any appetite to try to reduce our thoughts to a rule related to divisions? Does a division have to have a separate license, a separate broker, or separate location? Any thoughts at all about that, or shall we just let that go at this point?
Mr. Grease, when you approve that you can use 3 different names, I can put one in KB, I can put one in Keller, and I can put one in the other. If the rule passes, not anything you can do about it. I can make one of them the commercial division, I can make one the other division, and you go right down the road. Then you
So let me give you an example.
But those all have to be registered with the state.
That's right. But if
And they
you
have
got
to be
all-
licensed too.
Yeah,
Yeah,
yeah.
they have
But
to
you-
be licensed and registered.
And one of the three is just the combination of the other two. So it's really not three different because.
I agree. The only one I disagree with is the one with the Secretary of State. The others, I don't have any problem with that.
Well,
Otherwise, we're going to require Janet to go out and buy all new signs that
I don't
say,
do that.
you know,
we don't.
She can get her writer and paste it on there, you know.
MYPD LLC
just do like I did.
DBAX and Select Realty.
Second-
Just like these other
Let's
folks
put
who were
it
up here talking earlier who were asking us that question. You mean I'm going to have to go get signs that say?
Well, one thing about it, when most people open a company, they'll research if there are other companies' names out there before they name their company. And if they're not, they're not being prudent.
So back to my question, and we can let it go if you, is there any interest? For instance, I can refer you to a company in Knoxville. It's a company, and when somebody lists a commercial property, they put the name of the company, commercial division. Well, there's no commercial division, no broker for the commercial division. They just say that they're in a commercial division because it's a commercial property.
Can you ever
I
have
think
commercial
I
agent?
think, to be honest with you, this sounds remarkably similar to one of the issues you had today.
Robin,
in the
can you
legal
come
report.
closer to that microphone,
I'm
please?
sorry, it sounds remarkably similar to one of the issues you had in today's legal report and whether or not that entity had to be licensed. And if it has to be licensed, then of course it has to have a broker attached to it. Isn't that what you all decided earlier?
Yeah, and I think with what we did today, that says that they've got to have that registered with the state and with the real estate commission that it's a commercial division.
But it was totally different. It wasn't the same name. It wasn't Smith Realty Commercial Division, Smith Realty Residential Division. It was Smith Realty, and it was Jones Jones
We don't
Property
know that.
Management. But that's what she.
Oh, it was the same.
It was the same.
It was the same.
It was the same.
It was the exact same name.
That's not-
Okay, well then I totally misunderstood.
That's not correct.
Okay.
They had different names, slightly different registered names with the Secretary of State.
Chairman
It's
Grease?
John Smith Realtors, John Smith Property Management.
Different companies, different
Well,
entities. That's, I
and
think,
You're right.
that the second is licensed, the first is not. My example is, say, a Realty Executive franchise, same ownership, everybody's in the same tent, but people advertise in a certain division when it's convenient to do so.
Chairman.
Even though there's not a division.
Commissioner McMullen.
Chairman, wouldn't that be covered under this 1260-02.12 advertising rule that we just have been talking about under section 2F3?
What page are you on, Austin?
4, the bottom.
I hope it's covered.
Page 4 or 4 page?
Come on, smarty pants. F3, it's a false or misleading advertisement if you have a team or team members advertising itself using terms which would lead the public to believe that the team is offering real estate brokerage services independent of the firm and principal broker. So if you put up there Realty Associates Commercial Division, isn't that leading the public to believe that there is a Realty Associates Commercial Division that's offering real estate brokerage services independent of Realty Associates?
That's fine with me. I just want to, I want to see if there's an appetite to address it, and if the commission thinks it's included in there, that's fine. I'm happy to work with it.
I think so. I think that would address it, but and I want to make sure it's addressed too, but also I don't want us to close ourselves into a pen.
Well, forget the commercial division, but there could be a new homes division, short sales
Oh, I
division.
agree. None of that should be advertised unless that's false and misleading advertising.
And maybe it's already covered at some point somewhere else, and we're kicking the wrong.
Well, you do say
That
in the
misleading.
advertising teams, licensing holding themselves as a group or within the same firm,
How is that
no matter what they're
misleading?
called.
I'll give you an example. So, this is a true example.
Okay.
A person called the broker of a realty executive's office and said, I want to talk to the commercial division's managing broker. She said, there is no managing broker for the commercial division. You can talk to me.
Right.
Now, this agent was in one branch office. This company might have 6 branch offices, and there are people in each of those 6 branch offices who say they're in the commercial division. Who's responsible for them?
That's a
the
company policy.
I don't think so.
It's a,
Oh, no, well, the broker is responsible for them, But it's a company policy who answers the phone call.
You think the public thinks that there's a designated commercial division at Realty Executives based on that advertising?
I would think that there would,
Well, what about the company that does have a designated commercial division, a
No problem.
designated?
That's okay.
I mean, you have property management, I mean, somebody else has new homes. I mean, you
but
have-
if they have it registered with the state, that's not a problem. We're not saying that's a problem. We're saying these people who just get up tomorrow and go out and have a sign made that says commercial division
They have a
because
commercial
they
listing.
got one piece of commercial property, now they've got a division.
I see what you're saying, but how are we gonna, how are we gonna
I'll buy
follow
into,
that?
I'll buy into what Austin said.
It's misleading advertising.
I mean, that's good enough for me at this point. I'm done. That's all.
Robin, would you agree that that's misleading advertising?
Would agree that as proposed in your new rule, that is something that could be considered misleading advertising.
That's what
Like a
we're
true
going by,
lawyer.
is this new rule here.
Mr. Chairman, that concludes my report.
Okay.
Mr. Chairman,
Yes, Miss Ryan.
yes, that is my name.
Yes, Miss Ryan.
May I be excused?
Yes, you may.
Thank you.
Thank you. Thank you for tolerating us this afternoon.
Be on time in the morning.
Say what?
Be on time in the morning.
Yes, sir.
Mr. Chairman,
With a smile.
Commissioner Collins.
Mr. Grease has done such an outstanding job on this. I think he ought to write an article and put it on our webpage to explain.
You'd like to know what I think you should do, Mr. Collins?
I don't think we need that on the record.
We don't need to go there.
Austin suggested.
We're almost, we got two things left on our agenda. First one is
Education.
Ms. Maxwell's report, and the second one is education. Now, which one of y'all want to go first? We don't
Mr.
care.
Mr. McDonald's first on the agenda.
Well, we'll take him first then. Mr. McDonald, you're next with your education report.
Hey,
And my iPad's going dead, so y'all
you,
need to
Chairman.
make it quick.
I have plenty of battery power if you need mine as well.
mine.
There are 30 courses on this month's report that I've reviewed and have no issue for discussion, but there are two that I'd like to bring before you. But if you want to go through the first 30.
I'd like to pull out D1 just for comment.
Yes,
Thank you.
absolutely.
There's an instructor that appears to me to be somewhat suspect. I'm not sure how that
I got it.
name got in there.
Oh, you need to.
I understand. I had that discussion with him, and he promised that he was on the straight and narrow.
He's
now.
just there to get people to show up. He's not going to actually be instructing. Is that?
I need an informal appearance.
I'll move it 1 through 30 be approved.
Second.
I have a motion by Commissioner Grease that we approve these courses 1 through 30, or D through 30.
D1 through D30.
D1 through D30. And it's been seconded by Commissioner Collins, I think. And is there any discussion on any of these courses? Hearing none, all in favor say aye.
Aye.
Opposed, no. Courses are approved.
Mr. Chairman, I abstain on D1.
Let the record show that Commissioner McMullen, since he's one of the principal instructors, that's D1, isn't it?
D1.
On D1, that he has abstained from the vote.
Okay, Chairman. Commissioners, if you look at the courses requiring discussion, if we'll start with the first one, C.G. Dagnan is a provider and also an agent in East Tennessee. Her provider number is 1543. She currently has a course approved, and that's course number 7311. It was approved for 4 hours based on the classes that she has given, and you can read my comment. She is coming to the commission to request for an increase in the hours. She has sent in the supplemental information on her course. I have gone through it, and it does match the increase in hours, but it is up to you, and I did advise her that I would put this before you for your consideration of that increase.
Do you have a recommendation?
I recommend going up in hours. She's taught the class enough to get a balance on both sides of whether it's going to run long or not.
Motion to approve.
Second.
We have a motion by Commissioner Collins to approve course D31 and second by Commissioner Flitcroft. Any discussion? All in favor say aye.
Aye.
Opposed, no. Motion carries.
I want to interject something right in the middle here, and it's just a request.
Okay.
On the Tennessee Attorney General's site. They have a whole site and 2 designated folks that are, specialty is predatory lending. Predatory lending does include, or can include, lots of different things, including reverse mortgages. Apparently, the Attorney General, these 2 people are very versed on what's going on in the state. They know what's happening, who is taking advantage of who. They also had federal money that comes from, that is helping them help people that have lost their houses. And I would like to maybe combine our efforts and their efforts, or at least talk with them and see if they've got information that could help us in the future. Because, I mean, we're taking people's licenses away, and then they're also going after folks too. And that, it's all about mortgages. It also includes payday and several other things, but it's all about mortgages. And apparently they have a huge influx of predatory lending in the state of Tennessee. In fact, our Attorney General went to D.C. and talked about predatory lending before the Congress recently. So I'd just like to have those, talk to them, find out what they have, information that we should know, and what we should know that's going on, because they're the ones that are prosecuting folks in predatory lending that really affects our business.
Michelle, I move that we invite them to talk to us at their next convenience.
And they said that they would like to do that, so.
Is that a second?
That's a second.
We have a motion by Commissioner Flitcroft that we invite who?
I can get you names at the Attorney General's office, the 2 that were given me. That,
All
in fact,
some-
it's on the website.
Some representatives from the Attorney General's office come, and Ms. Maxwell, if you can stick them on the agenda somewhere next month, let them come and visit with us. And I'm seconded by
when's
Commissioner.
convenient, so.
Seconded by Commissioner Haynes. Any discussion? Hearing none. All in favor say aye.
Aye.
Opposed, no. Motion carries.
Is there a motion with respect to disposition of D32?
Nope, nothing's been done.
Oh.
Could I ask a question?
I didn't, I just kind of interjected it right
Okay.
there. I'm sorry. I should have waited to the end, maybe.
Steve, at our last meeting, didn't we decide to defer this and ask that the material include?
Right, this is actually a different provider that has come before us.
Okay.
The folks, Commissioner McMullen, that you're speaking of, they still have not sent in that material.
Okay. So
The
do we?
other course, best of my memory, was voted down, not to approve it.
No, we asked him for more information.
We asked them to provide for you to review a section that included risk reduction before you even considered going forward with it. And at this time, they still have not submitted.
What was my motion?
Do we know if this particular course includes materials on the risks of reverse mortgages as well as whatever benefits there may be?
Yes, sir. I don't remember the day. I did scan the copy. It's page 5, 6, and 7 from those of you that have taken paper pencil courses. Dearborn Kaplan puts together these as a correspondence course. So if I explained it as kind of the one that's got the red, usually red flag courses look like this. There was only 3 pages that explained the risk involved with reverse mortgages, and I didn't know if you had the opportunity to review what was provided in that course.
My concern is that we're giving a stamp of, I think we all ought to know what they're about, obviously, and there are definitely some good aspects to it as well as predatory aspects.
I'm going to tell you that we voted. Bear Stevenson, like 10% being for how he wanted to vote, and I said, I believe I can, and then we moved to deny that course.
This is a different course.
I know it's a different course, but one was on the agenda last month, got denied.
Well, I would like to just hear from the Attorney General before we approve any further courses and see if there is a concern. They may come before us and say there is no concern, this is being done, across the state very, and I just like to, I just hate for them to be out there prosecuting something that we have put a stamp of approval on.
Chairman, I move that this course be deferred until we hear from the Attorney General.
I have a motion by Commissioner Alexander and a second by Commissioner Flitcroft that we defer this course until we can hear next month from representatives from the Attorney General's office. Any discussion on the motion? Hearing none. All in favor say aye.
Aye.
Opposed, no. Motion carries, and we'll defer this course. What else you have?
All right, my last part of material is the request for instructor approval. Mandy Green of Randall Isaacson, that's how he is approved. It's ServPro, provider 1366. Requests for approval of Dan E. Luttrell to teach Understanding Mold Restoration. That's approved course 4227. Mr. Luttrell has 30 years plus of restoration service experience. He's a certified instructor for continuing education in 5 states. Mr. Luttrell earned his bachelor's degree and serves as a volunteer on his local community emergency response team. Mr. Luttrell holds a fire and smoke restoration, water damage, smoke odor control certifications. Based on the experience and the qualifications submitted for this type of course within this industry, he's qualified to teach this course.
Move approval.
Second.
Commissioner Flitcroft makes a motion that we approve Mandy Green of Randall Isaacson ServPro to be instructor, and it's seconded by Commissioner Bloom. Any discussion? Hearing none. All in favor say aye. Opposed, no. Motion carries.
I recuse myself.
And I abstain.
I'm opposed to mold personally.
I mean, it's not that I'm against it, but I recuse myself.
Okay, we got to let the record show that we had 7 voting aye and 1 recused and 1 abstention.
That's all that I officially have on my report. The 2014 Trek seminars are scheduled. They're posted on our website. I can send you an invitation again, which is the schedule. I'd love to see you at either one or all of those next year. Okay.
Good report. Thank you, sir. Next, we have Eve Maxwell's report.
And the first, okay. I can do it. Well, what time is it? The first matter is the complaint report, and it's on the iPads. It shows that we have 124 open complaints currently. We received 23 complaints this past month, November of 2013. This time last year, we had received 28 complaints. They sort of come and go, it seems like, in fluxes. And so the next one is the complaints, the amount of monies that we've received. In November, our civil penalties that we received was $16,776. For the fiscal year that began in July the 1st of 2013, we've received $119,006. Of the November, we got no E&O money this November. We still have had we've still just had 8 people that have paid the $500 penalty fee pursuant to the E&O, new E&O statute. And I'll get into an E&O report, but while we were looking at the monies received. The next page is the open and closed complaints, and we've so far this fiscal year closed 141 complaints. 116 have been closed with no action. 6 have been closed with a letter of warning or instruction. 14 with a consent order, and there were 3 revocations. 2 of those revocations were pursuant to 312G. There were people that did not notify us within 60 days that they had a felony conviction that fell within the definitions in 312. And the last page you have is the disciplinary action report. We tried to put a little bit more description in there to make it maybe more beneficial for principal brokers who would like to use it for their firm meetings. And if there are any questions about that, I can answer it. The pie chart has the percentage of unlicensed activities, like 16% of our complaints. Misconduct is 25%. Advertising is 8%, supervision 14%, escrow 12%, agency 19%, and misrepresentation is 6%. These designations are given to the complaints when they come in. So as the complaints go through the process, something that might have looked like misrepresentation might not end up to be that at all. So these are just the designations that are given to it when they're taken in by our complaint coordinator, Mr. Connell House, whose name is familiar to Mr. Stevenson.
You had to remind me of that.
That's right. Well, since you had brought it up at lunch, I just thought I would.
The list of suspensions, those are state mandated suspensions at the end?
Yes, they are, the ones on the disciplinary action report, because we've already put we put the big list of the E&O suspensions, and then these are the ones that are the state mandated ones. The next, we have the child support comes out quarterly, so that's why at some points it sort of swells. The Tennessee Student Assistant Corporation sends them to us weekly. So, they just have a couple a week, but the quarterly one from the child support, we had 28 on it, I think, this last time, or 20. So it just is, it's a much larger grouping of people. The next thing on your iPads is the licensing statistics. And you can see that the number of licensees that we have active people was up by 51 this past month. We have 24,087 active licensees, 907 inactive. That number was down by 42. We have 8,264 retired licensees. That was up 7. We have 24 additional in broker release to bring it to 171. So our grand total of active and inactive retired and broker release individuals is 33,429. If you go to the next, well, actually, if you go over a couple of pages, you'll see the number of people that we have in suspension. If you go to additional statistics, you'll see the number of people that we have in suspension. And so that, where we would normally have a large number in broker release, those people now are in suspended status. We have 511 people currently in suspended status. The largest majority of those people are in E&O suspended status. And so that number, sort of skews the broker release, which would normally be a much larger number. I don't know if there are any questions about any of that. The additional statistics show that, will show the difference between what we had in the last 4 years. Like in 2008, we had 32,604 active licensees, and today we have this was on 12/2, we have 24,080 active licensees. So we have a decrease, but our decrease is getting smaller and smaller with each month, our overall decrease. If you look at the exams that were taken this month, we had 344 exams that were taken this month, and we received 244 applications that were approved this month. That was up over last year's counts. Our year-to-date exams taken is 4,256, and this time last year it was 2,855. So the number of exams taken has certainly increased. Our applications this year are 3,079, and in 2012 there were 2,394 applications approved at this point in time in the calendar year. So as I say, our number of applications, people taking exams, the activity has certainly picked up to some extent so far this year.
Mr. Chairman, can I have just a general comment?
Yes, you may, Commissioner Flitcroft.
On the legal reports, number 37, 38, 39, albeit an unusual situation because they paid the money, but it was filed on November the 8th, 2013, and today is December the 4th, 2013. It's 27 days. I think that belongs in the book of records.
That was a citation, right?
Well, the people paid their money and it was dismissed.
But
But 27 days is pretty fast.
It is pretty fast. The citations, they are usually paid faster than the consent orders. That's our hope, at least.
27 days is still
That
pretty
is
good.
fast. That's a real fast turnaround, definitely.
He wants you to check with the records department to see if that qualifies.
If that's
or not,
correct.
yeah.
I'll see if that.
If we've beaten any speed records or
I bet I could probably pull that up on RBS pretty easily. I'll check into that. Our license renewal percentage is at 11%, which is pretty good because at some points in time earlier this year, it was this percentage of licenses not renewed. It was as high as 18 and 19%. So now we only have 11% who are not renewing at the end of that 60-day period that you have. So that's a dramatic increase as far as percentage of licenses renewed. I also have in here the number of active licensees by status. We have 16,135 affiliate brokers, 3,393 brokers, 3,783 principal brokers, and 766 timeshare salespeople. And those are active licensees that just sort of give you an idea of what our numbers break down to. Are there any questions about any of that? If not, we move to the E&O update. And we have no people who are uninsured. So that's good. Of course, the flip side of that is
There's
we
500 something of them in
we have 511 people are in suspension. And but the interesting thing is, of that, 457 of those suspended are in broker release status. So those people probably are just going to let their license expire. This has if you see the update on the E&O suspensions, there are 210 affiliate brokers suspended, 17 brokers, the same 20 principal brokers that have been suspended almost since July the 1st. So those, we've tried to get in touch with them innumerable times. Most of their mail comes back. I mean, I just don't think they're going to do anything one way or the other. None of them have any affiliated licensees, and all their firms are in problem status. So there's not much else we can do for them, except that after a year, we'll be able to revoke them pursuant to the new statute. And that's the way they'll ultimately roll off if they don't contact us prior to that time.
Personally, I think that is absolutely amazing compared to where we were when I first came on the commission.
Well, it really is. And, I mean, the real telling thing will be on, 1/1 or maybe 1/30 of 15 to see how it shakes out. But it really is, like with the broker release people, I think we probably expect them, by and large, if they've been broker released before E&O came up, they haven't in the past gotten E&O. So that's not really that much of a surprise. But it is an amazing decrease. Yeah, I mean, so it has been effective so far. And so that about covers the E&O, unless someone has any questions about the E&O.
Give us an update on fingerprinting.
Fingerprinting, yes. I've got the letter of instruction written, and I'm waiting for the identifying number from the TBI. Once I get that, that's what has to go on your form. The fingerprinting is done through L1 Morpho USA, which is the state contractor. They have kiosks all about the state that are within 50 miles of every person's location, kind of like the lottery tickets. They're in all kinds of random sort of places. The fingerprints will be submitted electronically beginning January the 1st. And what they'll come into our office once they're processed by the TBI and the FBI, and we'll get a report that looks like that report that you all see from time to time that has it'll have the charge, and it'll say disposition unknown sometimes, and sometimes it'll say disposition dismissed or convicted. So we'll get a report like that. Some will come back with no hits, and then others will come back with hits. So it'll be interesting to see how that compares to what we've been told all along. But as soon as we get the OR numbers, I say the letter is ready to go onto the internet, and then it's really a matter of the individuals will contact the fingerprinting agency themselves. The price for the armed and unarmed security guards is $42 that you pay directly to the fingerprinting vendor. Whether ours will be exactly that or not, I don't know. It's all done pursuant to a large state contract, and you can't get on the site, obviously, right now and see what ours will be, but we imagine it's going to be about $42 because that's about what, that seems to be kind of standard for the regulatory boards right now that do fingerprinting. and hopefully it'll go smoothly. It's usually taking 7 to 10 days to get the fingerprints back, so it's not, it usually take 5, 6, 7 weeks. So it's really improved with the electronics where it can go to the TBI and the FBI at the same time. So hopefully it'll go smoothly, and, we'll see how many we really get and what turns out to be what turns out to be our final numbers with that. But we did have funding in the legislation to hire a person to do that. The real question is, do we need someone to do that full-time, or just, that we could have do something besides that? And that, we just have no idea how many hits we'll get. I guess it'll depend on how honest people have been in the past, whether that's indicative.
As well, our instructors that are teaching, are the preparatory courses for becoming a realtor, are they aware of this?
They are. I mean, they are
They're
aware of
included
the.
in their curriculum, like. we're gonna
They
take
will,
the
and they've
fingerprint.
asked some questions about it, and until I get the number from the TBI, that number's mandatory. It has to be placed on the information. You can't even do you can't get your fingerprints without it. So there's, until we get that, we can't really give them a whole lot of information. But as I say, it'll be a process where the person contacts them just like they do the testing vendor right now.
I think it'd have a sort of a chilling, sobering effect on somebody that was considering the real estate as a profession, to say, I gotta get my fingerprint, they're gonna cross-match it and find out my history.
Well, that's right, and that's what, as I say, that'll be the interesting thing, is to see whether or not people have been honest all along. I mean, or if our numbers just go up enormously. We, have hundreds of felons apply, because when we went back and looked historically, the people that we have, had come before the commission because they didn't answer question 5 honestly, we only had in the 3-year period I looked at, we'd only had maybe 10 people that came back before the commission because they didn't answer question 5 honestly. So whether or not that turns out to be the case, it'll be interesting to see how that works out. But hopefully it'll be a smooth process. One other thing, and I handed this out to all the commissioners. We have our subject matter expert meeting to talk about PSI Tuesday, and I handed out a list of the individuals that we asked. And you'll see, check the answers I got back. The other answers have gone to PS. I mean, once I finished the process of sending out the initial information, PSI took it over. And so, anyway, that'll be an all-day process that Steve and Julie and I will attend, along with the individuals that you see listed there, and the 1 or 2 representatives from PSI. Are there any questions about any of that?
Why did some of these people that are leaders in this not respond?
Well, they hadn't. They might have responded when PSI sent out some information, but when I sent out the information, those are the people that responded to me. And actually, most people have copied me that responded. Like Pug, for instance, is going to be. He had a conflict with that day. And then some of the other people, I don't know whether it was just not convenient for them to travel at that time. Steve was, I couldn't get a good email address on Steve Champion. I tried 3 or 4 different. Well, yeah, that, as I say, I had the email that I was given and tried another couple ones, and I couldn't get anything to go through to him. Because he, in the past, he had expressed interest in doing it. Jewel, I think, had a conflict as well that day. So hopefully, I feel like we'll have a good group of individuals with.
Do you need more, or did you get
No,
enough?
if you have too many, because you've done it, if you have too many, it becomes not workable. So I think that we have, PSI thought that we had plenty of
Okay, good.
people, so we stuck with that number.
Okay, what else do you have for us?
That's all I think that that's all, I think that's all that I was going to discuss at this point.
Good report. Thank you, Ms. Maxwell. Does anybody else have anything before this day of commission meeting?
I'd just like to remind commissioners that Chairman Stevenson fronted the money for the luncheon today, and if you expect or plan to participate in the cost of that, the pro rata share is $96.09, say $100 each, payable to Mayor Stevenson, and he'll feel better about it. He might buy you a beer or
I
something.
thought he was buying all of it, John.
Thank you for doing it. I think the staff
I'll
really
tell you
enjoyed it. I think it
earlier
was a
today.
great opportunity to talk to, have everyone meet everyone.
He wanted something back?
All you attendees, I hope this has been a formative educational day for you, even though regardless of why you're here, those of you who require continuing education, you're getting 8 hours of continuing education by being here today and tomorrow. Y'all be back here in the morning at 9 o'clock. We've got a formal hearing, and have a safe evening, and we'll see you in the morning. Sign out. Be sure you sign out back there as you leave. And we'll see you in the morning.
We are recessed.
We're recessed until in. Some of us are good. I call this meeting of the Tennessee Real Estate Commission into session, and at this time, I'm going to turn it over to Judge Johnson, who is going to be in charge of the deliberations today.
Good morning. I have a few opening instructions, and then we'll proceed with the proof. Today is December 5th, 2013. This hearing has been convened before the Tennessee Real Estate Commission to consider the case of Frank Cowden, docket number 12.18-122-530A. As Mr. Stevenson said, I am Ann Johnson. I have been assigned by the Secretary of State to preside over this hearing, and in that role, I will not participate in the decision on the merits, since that decision will be made by the Commission. However, I will make all rulings of law, evidence, and procedure under the authority of the Administrative Procedures Act. I would ask that, I know everyone here has a cell phone, so I would ask that you either turn it off or put it on silent so that our hearing will not be interrupted by unexpected calls. At this time, I would like to ask the commission members to introduce themselves for the record.
Commissioner Bloom, you start.
Gary Bloom.
Dave Flickroff.
Michelle Haynes.
Wendell Alexander.
John Grease.
Bear Stevenson.
Janet DeChara.
Grover Collins.
Thank you, commission members. Chairman Stevenson, do we have a quorum today?
Yes, Your Honor, we do.
All right. The parties, I believe, are all present. Ms. Robin Lynn Ryan represents the state in this matter, who is the petitioner. Mr. William A. Harris is an attorney who represents Mr. Cowden. Mr. Cowden is also present. Ms. Ryan, is Ms. Maxwell going to be your party representative today?
She is.
Okay. All right. So Ms. Maxwell, although not present right at this moment, can participate in that role. Now, members of the commission, I know you've heard this many times before, but for the record, I need to go over it again. First, the Open Meetings Act. You are reminded that this hearing must comply with the Tennessee Sunshine Law. Can you hear me? Am I? Okay.
Yes, ma'am.
Let me know if you can't. Which means that all discussions and deliberations must be public and must take place before all parties to this proceeding. During the hearing, the commission sits as a jury and must consider only evidence introduced at the hearing and placed on the record. During these proceedings, no commission member should discuss anything concerning this case with other commission members or anyone else except on the record during the hearing. Be especially careful during breaks and other recesses, because failure to comply with this requirement could result in a reversal of the commission's case if the case is appealed. Decision if the case is appealed. Now I need to discuss conflict of interest and ex parte communications. If a commission member has received any ex parte communications, which means any communication about this case outside this hearing, or if you have any other outside knowledge of any aspect of this case, that member is required to disclose such communication on the record. I know you haven't seen the notice of charges yet, so this will be a continuing instruction. After you see the notice of hearing and charges, then please stop me at any time if you feel that you have received outside communication or have outside knowledge of this matter. If you know right now that you do, I would ask that you respond by answering yes. All right? Hearing no affirmative answers, I'll explain a little bit about the procedure to the board. The state has the burden of proof. That means in order to prevail, the state must show that by a preponderance of the evidence. And if you have questions about what a preponderance of the evidence means, then you're welcome to ask me and I'll give additional instructions of that. Do not confuse preponderance of the evidence with a higher criminal standard of burden of proof. So, as I say, if you have questions about that, please let me know. The state will present its proof first, present all of its witnesses. At the conclusion of each witness, Mr. Harris may have questions for that witness, and then we'll stop and give the board members, commission members, an opportunity to ask questions of each witness. I would ask that you please reserve any expressions of opinion regarding this case until the deliberative process begins at the conclusion of all the proof. Now I need to designate the technical record. This consists of the notice of hearing and charges, the state's witness and exhibit list, a motion to continue on behalf of the respondent, an order of continuance, subpoenas submitted by the respondent, a procedural order from my office, and then finally the respondent's witness and exhibit list. If there are documents that I have not listed or named, or if there are any objections to including any of these in the technical record, I would like the parties to tell me at this time. No objections?
I'm sorry.
Technical record?
No objections.
No objections.
All right, thank you. At this time, I'd like to swear in the witnesses, if the witnesses are present. If there are witnesses who are not present, I would ask the attorneys to remind me when the witness is called to testify that this witness needs to be sworn in. Right, so Mr. Faulkner, Ms. Maxwell, and Mr. Cowden. All right, will you please raise your right hand? Do you solemnly swear or affirm that the testimony you provide in this hearing will be the complete truth? Yes. Thank you. Now I need to ask if either party wishes to request to invoke the rule of sequestration.
Yes.
All right. Now, I'll tell you that what this means is that any witness must not be present during the testimony of the other witnesses. However, the parties themselves, Ms. Maxwell and Mr. Cowden, as parties, can remain throughout the entire proceeding. Mr. I'm sorry, I forgot your name? Faulkner. Mr. Faulkner, unless you're going to be the first witness, I would ask you to be excused at this time, and you should not discuss your testimony with any other witnesses or anyone else until after this hearing is over, and then, of course, you're free to discuss it. So if you won't mind sitting out in the hall, we will call you as soon as the party calls you to testify. Are there any preliminary matters before we publish the charges? Okay, then at this time, I think what would be expedient is to publish the charges, the notice of hearing and charges to the commission members. We'll give them a few minutes to look over that and read it, and then we'll proceed with opening statements after the commission is finished reading the notice. Please. I do not. Chairman Stevenson, if you'll let me know when the commission is ready to proceed.
When you finish reading what has been handed to you, look at the judge, if you would, and you'll know, Judge, to proceed.
I have to watch carefully then. Attorneys, I would also caution you, we have people coming in and out. If you see any of your witnesses come in before they're called to testify, please make sure that you ask them to leave so that, since the rule has been invoked.
I think we're ready to proceed, Your Honor.
All right, thank you. Then I suppose we're ready for opening statements. Ms. Ryan?
Morning. We are here today regarding matters, as you see from the notice of hearing, that occurred in 2011. Specifically, at that time and today, this respondent was the principal broker of Regent Properties. And in 2011, a man named Zachary Faulkner negotiated a sale of property as an agency and as an agent and licensee. And on the documents to this negotiation of sale, you will see that Mr. Faulkner names Regent Properties as the selling company, the company for holding the earnest money, and Mr. Frank Cowden, the respondent here today, has signed as the person on some of these documents as well. The problem is that at these documents were executed, Mr. Faulkner was not licensed with Regent Properties firm, as he had been broker released and no firm had picked him up, so therefore he was not entitled to be acting as a licensee at that time. You will further learn the sales documents on which were signed by Mr. Cowden and Mr. Faulkner as a principal broker were on Sentinel Commercial Property forms. And you will also learn that Sentinel Commercial Properties was not and is not a part of Regent Properties. You will hear that in response to this complaint, Mr. Cowden, concerning the failure to supervise, which is the issue we have today, the response was that Mr. Faulkner was working as an assistant and not as an active agent, even though Mr. Faulkner signed on those documents as a licensee. You will learn that Mr. Faulkner had left another agency and that Mr. Cowden states that when he found out he had been terminated and that the contract had been written on with the previous broker, Mr. Cowden then took over. Yet, the proof will show you today that only Regent Properties and Mr. Faulkner and Mr. Cowden are the persons on the documents in question. Again, you will find that all the documents presented by these persons are on Sentinel forms with Regent Properties, Mr. Cowden, and Mr. Faulkner as the particular companies involved. We believe that this is a serious failure to supervise as the principal broker. We believe that Mr. Cowden has the obligation to be certain that anyone under his supervision signing documents as a licensee has a license. And part of that requirement is that person needs to be, as we know, on a Trek 1 form with the state showing he is with that firm. We believe that he has an obligation to be certain that the forms used are correct and that his represents his agency correctly. And it is requested by the state today that after considering all the proof, that this commission find that Mr. Cowden is in violation of 6213 3-12B in that he failed to exercise sufficient supervision over this particular licensee affiliate, violation of 6213 3-12B20, any conduct that is considered improper, fraudulent, or dishonest dealings, and number 14, violation of any provision of 312, and in this case, any provision of 6213, in this case 6213-302, as it is unlawful to employ or compensate any person who is not a licensee affiliate for doing any act of a licensee. We ask that after consideration of all these facts and all the testimony today, that this commission issue a civil penalty and require Mr. Cowden to pay all the court costs.
Thank you, Ms. Ryan. Mr. Harris, would you like to make an opening statement now, or would you prefer to reserve that until your proof? Go ahead.
The proof in this matter will show that this was a number of sequences that occurred involving initial bad actors, frankly. It gets to the point where Mr. Faulkner is involved with Regent Properties. Prior to that, a number of groups, including one potential individual who might not have even been a licensed broker, another broker refused to turn in paperwork and represented that paperwork had been submitted. Representations were repeatedly made to Mr. Faulkner that this had occurred. The responsibility that is being pushed and the potential punishment requested to be levied upon Mr. Cowden is the result of someone who said, I have sent in this form. The license will be coming back. The form has been submitted. Mr. Cowden moves forward. Mr. Faulkner moves forward immediately upon being informed that instead this person released Mr. Faulkner, contrary to all representations. He was removed from the file. Mr. Cowden immediately stepped in and took over as he determined would be his responsibility. Misrepresentations were made. It had an impact both on Mr. Cowden and on Mr. Faulkner. Mr. Faulkner received no compensation from this as he was removed from the file. He received no commission from this sale. He received no commission from Regent Properties. It was determined that he was not licensed due to the actions of the prior broker. He received no commission. And when it comes to the Sentinel Properties letterhead, these forms were obtained by Mr. Faulkner from the TAR database. Mr. Cowden is a commercial broker. He does not use these TAR forms in his business dealings. The Sentinel Properties is at the top, but review of these documents, it is clear throughout, it states the broker is Regent. The complainant, Ms. Fuqua, who did not appear today, has been through the training. Everyone who looks at these documents, including the parties, should understand that the broker is who is listed as the broker throughout the document. A mistake on the heading due to a computer glitch arising from a prior agent is not something that Mr. Cowden should be held responsible for when the document clearly states that Regent is the broker. Now, as one of the issues raised in the complaint by Ms. Fuqua is that no notice was provided that Mr. Faulkner was not licensed, and that there was a transition from Mr. Faulkner upon the determination to Mr. Cowden. A notification was sent directly to her. Mr. Cowden's client signed off on this. He understood what was going on. She was informed of what was going on. Instead of raising any questions, a complaint was brought before this board. Every effort was made to cure problems arising from misrepresentations made by prior parties. And so we asked that that be considered and that be really the factor in determining how this is handled. And since he took every step that could be made to remedy a problem when he was notified of it, and to remedy a problem based on others' misrepresentations, we asked that this be dismissed. He was supervising. He was demanding someone go and get copies of the license, which misrepresentations were made as to whether this was going to be provided. He did not compensate Mr. Faulkner upon learning of this. Reasonable time, he was observing what was going on and acting reasonably to make this take place. And when it comes to a fraudulent action, it appears I assume really the claim is dishonest dealings. That can only, in my mind, be based on the letterhead when the documents clearly say Region. Again, we ask that this be dismissed, but appreciate the time of this board to hear the evidence in this case.
Thank you, sir. Ms. Ryan, would you like to call your first witness?
I'll Eve Maxwell. Maxwell, you've already been sworn, right?
That's correct.
Would you please state your full name?
Eve M. Maxwell.
And your position with the state of Tennessee?
I'm the Executive Director of the Tennessee Real Estate Commission.
And as the Executive Director, are you familiar with both the license file and the complaint files of Mr. Frank Cowden?
Oh, yes, I am.
Does he have a current and active license?
Mr. Faulkner?
No, Mr. Cowden.
Mr. Cowden? The RBS, our computer records at the Tennessee Real Estate Commission show that Mr. Frank E. Cowden III holds a license, a broker license for Tennessee, license number 254266. He is an active principal broker of the firm Regent Properties, LLC. He was first licensed May the 2nd of 1994, and his current expiry date is 3/19 of 2015.
And you said he's the principal broker of what firm?
Regent Properties.
Does it show how long?
LLC.
Does it show how long he's been principal broker at Regent Properties?
He's been principal broker of Regent Properties, LLC since 9/30 of 2003. It appears he started the firm.
You know, and what, well, yeah, I know you know. What is the reason this complaint was filed in the first place?
The complaint was filed by another licensee who was involved in a transaction with Mr. Cowden and Mr. Faulkner. And there were allegations in the complaint that there were negotiations ongoing. Mr. Faulkner had represented that he worked for one company, and then when the documents came through, there was some, Mr. Faulkner allegedly was involved with loan process as well. And then when the documents were sent back to the title, they went to the title company in one form with one name on them, that being Mr. Faulkner's. And then when they were returned from the title company, they had Mr. Cowden's name. So there were 2 page 9s, I believe, that had different names on them.
And what was the status of Mr. Faulkner? Is this Zachary Faulkner? What was the status of his license at the time of these documents?
At the time the documents were signed, Mr. Faulkner was in a broker release. He was broker released from American Elite Realty LLC on 7/22/2011. The TREC records do not show that he ever affiliated with another firm, and his license expired on 4/27 of 2012.
And was a complaint opened against Mr. Faulkner as a result of all this?
Yes, it was.
And what was the result of that complaint?
That complaint was, sorry, I've got a lot of papers here. That complaint was closed and flagged in case Mr. Faulkner ever returned to the real estate business and applied for a license at the Tennessee Real Estate Commission.
And the reason it was closed and flagged?
Because at the time that the complaint was heard, his license had expired.
Now, you had said that he was broker released, and your records show that it took effect at least in 7/22 of 2011? Is that what you said?
That is correct.
Did he have a listed agency with he was working in, let's say, August, September, or October 2011?
No, the track records do not show that he ever affiliated with another firm. Again, his license expired in 2012.
So when a licensee has no firm with whom they are listed with you, what is actually the status of their license?
They're in a broker release status, which is not a status in which you can engage in activities that are defined in the act that require a license under TCA 6213-102 4A, B.
So a licensee in a broker release status cannot sign as an agent or a licensee on a contract?
No, they cannot, but they do not have an active license, which is what's required to engage in real estate activities.
I'm going to show you a document and ask if you can identify it for me.
This is a Trek 1 form, and that's the transfer, release, and change of status form that a licensee would fill out to transfer, to retire, to go inactive, to upgrade to a principal broker, to change their firm name. It has basically 11 functions. And this is one that has Mr. Zach Daniel Faulkner's as the licensee's name. His firm at that point was American Elite Realty, LLC, which was firm number 259555. It is a broker release. Box L is checked, and that box L reads Principal Broker Release of Affiliated Licensee. Licensee is placed in a problem status, but we have a broker release status, so they're placed in broker release status. This Trek 1 form is signed by the principal broker of American Elite Realty at the time, and that was Vicki Sane.
And the second page of that document?
The second page of that document is a letter that is generated by the Trek computer system when we enter in the broker release information, and it's dated July 22nd of 2011. It's addressed to Mr. Zach Daniel Faulkner at 1924 Presswood Drive in Hickson, Tennessee, 37343, license number 317135. And it says, Dear licensee, as of 7/22/2011, you have been broker released. This office has received documentation from your principal broker of record, Vicki Janine Sane, releasing you as an affiliated agent with American Elite Realty, LLC. You have 10 days from the date of this letter to either inactivate, retire your license, or transfer to another firm. And then it goes, do you want me to read the rest of it?
No.
Okay.
And this was sent to Mr. Faulkner, is that correct?
That is correct.
Court, please, may I pass out copies of these for the commission to review?
Any objection, Mr. Harris?
No objection.
All right. We'll mark this document as Exhibit 1.
Thank you,
ma'am.
You have to.
Hold on, Ms. Ryan. If you want me to mark those off. Go ahead.
Thank you. Do the records reflect that Mr. Faulkner was ever affiliated with another firm?
No, they do not reflect that he was ever affiliated with another firm. There's no money listed on his file that shows that he ever paid any money, actually, again, after that first renewal.
What is the responsibility of a principal broker, both for the old firm and new firm, when it comes to licensees that work for them?
Well, as far as releasing them, is accepting them, or?
That's correct, as far as releasing them and accepting them.
If a principal broker would like to release an affiliated licensee, by and large, all licensees are independent contractors. A principal broker can fill out a Trek 1 form, sign it, much as you see this one was the one that's been entered as an exhibit was done, and can fax that or mail that to the Tennessee Real Estate Commission. At that point, upon receipt, the Tennessee Real Estate Commission will release that individual from the firm so that the principal broker is no longer responsible for that licensee. The rule and the statute say that an individual can neither take properties or listings when they leave without the permission of the broker. So if you broker release someone, unless you've got an arrangement with the broker, you cannot take any properties or listings with you. Once a person's been broker released, they've got 10 days to affiliate with another firm, or they can retire their license, apply and fill out a Trek 1 form. In some instances, if you know that you're going to transfer to another form, a licensee will get the principal broker who's releasing them to sign the Trek 1 form, and then they will take that Trek 1 form to their new principal broker, who will likewise sign on that, so that you have both signatures on one form, and then you'll turn that into Trek and pay a $25 transfer fee. And at that point in time, we would then do the transaction all at once. We would take you off your old firm and then affiliate you with the new firm that the principal broker has signed the Trek 1 form on. If, in fact, you have a situation where your principal broker refuses to sign a Trek 1 and you as a licensee would like to leave that firm, there is a form on the Trek website that allows the licensee to fill out basically an affidavit that says, my principal broker refuses to sign the Trek 1 form, or he's deceased, or whatever the situation is, and the licensee themselves can turn that in so that they don't get caught up with a firm that they would like to leave and maybe the principal broker's not there. So that option is available to the licensee as well. Until Trek receives a Trek 1 form transferring the individual, we can't transfer the individual, and so our records would reflect the status as in this instance, as a broker release status.
What about the new principal broker of a new firm? Can that principal broker, without the original document, file also a Trek form to show that this licensee is now in that firm?
Yes, they can. As I said, the principal broker, as in this instance with Mr. Faulkner, can release a situation where they would release the licensee, and then maybe within that 10-day period, an individual finds a new firm. That new principal broker then would just fill out the Trek 1 form, signing where he would sign, accepting that individual. And so the individual would have been released from the old firm upon receipt of the form signed only by the releasing broker, and when we received the form from the new broker, they would then be placed with that and affiliated with that firm on the Trek records.
So in July of 2011, Mr. Cowden and Mr. Faulkner could have submitted their own Trek 1 form to show that now he was in this new firm.
That is correct.
And was that done?
No, that was not done.
Now I'm going to show you a copy of some documents and ask them if you could please identify them for me.
These are copies of documents that were submitted with the complaint.
Okay, and are they contracts or what are they?
Well, they're notifications and contracts. They're on Sentinel commercial property forms. There's information from the mortgage company, their purchase and sale agreement on the Sentinel commercial properties form, and their notifications to the buyer and seller.
And these were submitted with the complaint?
Yes.
Your Honor, if the court please, I would like to pass this out so the commission can be reviewing them while we're talking about them.
Action?
The only request I would make is just because I have my own copies to know specifically what.
I'll refer to them.
So I'm not submitting them to.
Do you want me to read through?
I will identify them individually as we go. Is that?
Or do you want me to read through all the titles now? Or
do you want her to read through all the titles now?
However you want to.
No, we have copies, thank you. How about if I refer them individually as in the pile, and you have a copy that I gave to you?
I did.
Okay. Meg?
Okay, so are we doing a collective exhibit here, or?
Collective exhibit, but before I enter the exhibit, we're going to go over each of the documents so he knows what we're talking about.
Okay, but you have no objection? Okay, all right, then.
Thank you.
This is the whole bundle.
This is the whole bundle.
Okay, so we'll mark this as Collective Exhibit 2, and then you will identify them for the record
I will.
individually.
Individually.
Okay?
On the documents I just sent you, the first document is, in the pile is what?
It's a notification, it's on some Sentinel Commercial Properties. It's a notification from the buyer to the seller, and it says buyer has made application, there's box 3 is checked. It says buyer has made application for loan and is notifying seller and/or seller's representative of the name and contact information of the lender. Buyer has also instructed lender to order appraisal and credit report. Lender's name and contact information is Larry Wood Allied Home Mortgage, and it lists the phone numbers and the email address. And box 5 is checked that says buyer has paid any required fees necessary to complete full loan processing and approval.
How many pages is that document?
It is 2 pages, and it's signed by Mr. Thomas, Alan W. Thomas, the notifying party, which is the buyer, and it's signed on 8/10 of 2011 at 7:20 p.m.
And what kind of form is this?
It's a notification that the buyer has applied for a loan.
And what is the name on the top of the form?
Sentinel Commercial Properties Notification.
Thank you. Page 3 of the documentation.
Is a revised notification, also with Sentinel Commercial Properties at the top. It's a notification from the buyer to the seller involving the property located at 915 Lenox Cove Place, Hickson, Tennessee. Box 3 is checked on that. It says buyer's made application for loan and is notifying seller and/or seller's representative of the name and contact information of the lender. Buyer has also instructed lender to order appraisal and credit report. Lender's name and contact information is, and handwritten is, mortgage loan officer has been reassigned to Zachary Faulkner, and real estate transaction has been assigned to Frank Cowden. Number 4 is checked, and that says buyer has changed lenders and is notifying seller that the new lender's name and contact information is, this is likewise handwritten. Information has been discovered regarding license status of Zach Faulkner through the file has been taken over by broker Frank Cowden, and Zach is now the loan officer. And number 5 is checked, which says buyer has paid any required fees necessary to complete the full loan processing and approval. It's 2 pages long, and it's signed on 8/26, I believe that's 26, of 2011 at 5:35 p.m. by Alan W. Thomas.
And the third document?
The third document is it appears to be a letter or notice from Allied Home Mortgage located at 8319 Ellie Plaza Place, Suite B, Hickson, Tennessee 37343. And it says notice to underwriting / processing / compliance / and closing. Please be aware that some changes have taken place to this file. The original loan officer that was on this file has decided to pass this loan off to Zach Faulkner, NMLS 172240. Zach Faulkner was originally anticipating on acting as the realtor on this transaction, and thus to avoid any conflict, he was going to allow another LO to originate the mortgage. However, through various circumstances, Zach has chosen not to act as the realtor and instead will take over the origination of this file. In no way will this affect any terms or changes in paperwork other than a few docs where we will change the origination assignment. Thank you for your understanding and attention to this. If there are any further questions regarding this or other documents needed to make this assignment guideline compliant, please advise and we will act accordingly. Sincerely, Zachary D. Faulkner, new loan officer, Larry R. Wood, former loan officer, and there's not a date nor salutation addressing it to a person.
And that notification that says no date, is that something you wrote in or somebody else wrote in?
Someone else wrote that in.
Now, the next document?
And that was just a single page, that document.
Okay.
The next document is the purchase and sale agreement, and it's on the letterhead or the heading of Sentinel Commercial Properties. And it is a purchase and sale agreement where Alan Thomas agrees to buy, and the undersigned seller, the estate of Ruby Smith, agrees to sell the land known as 915 Lenox Cove Place, Hickson, Tennessee, 37343, Hamilton County, Deed Book 88, page 27, and then it says it's further described, but there's not a description in the box.
Can you go to page 3 of that document? Line 131, what does that say?
On 131's earnest money, buyer has paid or will pay within 3 days after the binding date to Regent Properties located at, there's no address, an earnest money deposit of $500 by check.
Okay, and can you go to line number 309 of that document?
Line 309, home protection plan?
That's correct.
That's number 13, home protection plan. Not a substitution for a home inspection. Exclusions to coverage may apply. It says select the appropriate box. Items not selected are not a part of the agreement. Home protection plan is checked, which is the first one. Seller to pay $500 for the purchase of a limited protection plan to be funded at closing. Plan provider, American Home Shields, ordered by Regent Properties.
Thank you. And on the last page, these would be lines 433, and then below that, below 449.
433
Yes.
Says buyer hereby makes this offer, and it's signed by Alan Thomas, and the offer date is 8/10/11 at 7:20 p.m.
And at the bottom, who is listed as the selling company?
The selling company is listed as Regent Properties, Zachary D. Faulkner, and it's initialed by him, by Mr. Faulkner.
Thank you. Could you go to the document later in this documentation that's back in the back? It's confirmation of agency status. It's toward
Okay. Confirmation of agency status.
And who is listed as a licensing name at the top? To the right, under Alan Thomas?
This is a confirmation of agency status for the property at 915 Lenox Cove Place, Hickson, Tennessee. The buyer's name is Alan Thomas. The licensee agent for Mr. Thomas is listed as Zachary D. Faulkner, and the box that says designated agent for the buyer is checked under the buyer name and licensee name of Zachary D. Faulkner.
And whose sign is the selling licensee and the selling company in that matter?
The seller name is Marlita Carmichael, and the licensee's name is Cheryl Fuqua, and under that, the seller name and the licensee name is check the box designated agent for the seller.
And what about at the bottom, whose sign is the buyer's signature?
The buyer's signature is signed by Mr. Alan Thomas, Alan W. Thomas, and it's signed on 8/10/11. And then the selling licensee, Zachary D. Faulkner, on 8/10/2011. Selling company is Regent Properties.
And that was the date, I'm sorry, say that again?
8/10/2011.
Thank you. Now, the very last two pages of this document?
The package, the
Yes.
document package. The counteroffer.
Yes.
This is a counteroffer number 2 on the letterhead, the heading of Sentinel Commercial Properties. It's a counteroffer from the buyer to the seller. And it says the undersigned agree in and accept the purchase and sale agreement with an offer date of 8/10/11 for the purchase of the property at 915 Lenox Cove Place, Hickson, Tennessee, with the following exceptions.
You don't have to read the
Okay.
exceptions. If you, and the date the buyer signed that document?
8/17/2011.
Now, if you go down to the binding agreement paragraph, can you read that for us?
The binding agreement says, "This instrument shall become a binding agreement on the date, binding agreement date, the last offeror or licensee of offeror receives notice of offeree's acceptance. Notice of acceptance of the final offer was provided on the 17th day of August, 2011, at 11 p.m. by Frank Cowden."
And on the next page, are there document signatures as well?
There are, it says, on line 433 says, "Buyer hereby makes this offer," and it's signed by Alan Thomas on 8/10/11 at 7:20 p.m. And it says, "Seller hereby counters this offer subject to the attached counter." That's the counter, I mean, that's the information we'd seen earlier, I believe. And it's signed by Marlita Carmichael, 8/12/11 at 8:00 p.m.
And down at the bottom, who signed as the independent licensee?
Frank Cowden at Selling Companies Regent Properties.
Okay. At the date, I do, but I sent you a copy in email, but I'll send, here, you can have another one.
Mr. Harris, could you please make sure you speak into the microphone so that we can hear what's going on?
Yes, I will. I apologize.
Now, at the time all of these documents were signed, what was Mr. Faulkner's status as a licensee?
He was in a broker release status, which means he did not have an active license and could not engage in activities that require a license under the Tennessee Broker
So,
Act.
in reality, he was doing licensee work, and that is against the law?
That's a violation of the Broker Act.
Okay. And again, you don't have any documentation to show he was ever transferred or ever made a part of Regent Properties?
No, not in the records of TREC.
And what does the law provide concerning when an affiliate can work under a new broker?
There are several provisions that deal with termination of affiliation and affiliation with another firm. And 6213.310 says the affiliate broker, this is A, when the contractual relationship between a broker and affiliate broker is terminated, the present broker shall sign and date the change of affiliation form prescribed by the commission. The affiliate broker may act under a contract with another broker upon completion and transmittal to the commission of such form accompanied by the fee established pursuant to 6213.308. Such affiliate broker shall assure the completed form and fee are properly transmitted, and the affiliate broker's license is displayed in the new broker's place of business. And then there is a rule, let's see, rule, do you want me to go and read all these?
Let's go ahead.
Okay.
Mhm.
Ms. Maxwell?
Yes.
We've had a request that you maybe slow down a little bit.
Okay,
if you're
sorry.
reading. Our poor court reporter over here is.
Sorry, when I start reading, I just
Cramped
sort of get on a roll. I'll slow down. There's a Rule 1260-1-.04 that says, number one, no principal broker shall permit a broker, affiliate broker, or timeshare salesperson under his supervision to engage in the real estate business unless the broker, affiliate broker, or timeshare salesperson has been issued a valid license and is covered by E&O.
Thank you. Now, at the time of this, in August of 2011, you already stated Mr. Faulkner was not listed with any real estate firm.
That is correct.
What should Mr. Cowden, or what could he have done on finding this information? Or
He could
finding
have broker released him if he'd had him, but he wasn't there. And so he could have filled out, if he wanted him to be affiliated with his firm, then he could have filled out a TREC 1 form. He could have signed it, and Mr. Faulkner could have signed it, paid the $25 fee, and sent it to Trek, and it would have been processed, and he would have been transferred on the Trek records into Mr. Cowden's firm.
So was it a situation that relied solely on the actions of the previous broker?
No, it did not. I mean, the Trek One form requires that the new accepting broker sign the form so that Trek knows that the new principal broker realizes that this individual is planning on affiliating with his firm.
Hey, Miss Maxwell, do you know who a Richard Sharp is?
Mr. Sharp is a licensee. I'll find that paper here. I don't know. I mean, I don't know Mr. Sharp, but this morning I did look up his record, and there is a Mr. Sharp and a Richard P. Sharp. He's a principal broker. He has broker license number 269433. He's located at 1709 Tazewell Pike, Suite C, Coreytown, Tennessee, and he's the principal broker of a firm called American Elite Realty of Knoxville, LLC, that was first licensed on 5/11 of 2011.
5/11/2011?
Yes.
Okay, do your records reflect at any time that Mr. Zachary Faulkner ever worked for American Elite in Knoxville?
No, they do not, nor did they ever, no, and they never reflect that Mr. Sharp ever lived in Chattanooga or that area.
Oh, so could Mr. Faulkner have lived in Chattanooga and worked for this brokerage in Knoxville?
We have a 50-mile rule, and you can't work, the individual can't live further than 50 miles from his office. So I believe that would probably be more than 50 miles away. But our records don't show that he was ever affiliated with that firm.
Do your records show any relationship between Sentinel Properties, the letterhead in the documents, and Region Properties? Was that a division of Region Properties?
No, it was not a division. We don't show any relationship between the firms themselves. The two men apparently had, Mr. Cowden and Mr. Broomfield had apparently worked together.
So the documents provided weren't really a part of then?
No,
Region?
we have Sentinel Properties listed as a totally separate firm with its own identifying license number.
Now, let me go back to the complaint a minute. Did Mr., and I'm going to give you a copy, did Mr. Cowden get a copy of the complaint at the time?
Yes, he did.
Did he file a response?
Yes, he did.
If you could find the response, or if you can't, I'll find it for you.
Let's see. Will I need these again?
Yeah.
Okay.
Can you?
I have a copy of the response.
How does Mr. Cowden address the issue of the unlicensed person doing all this unlicensed activity?
Mr. Cowden in his response states that Zach Faulkner works as my assistant. He is not an active agent. He was previously an agent with American Elite, Mr. Richard Sharp. Mr. Sharp, in the presence of GCAR employees, that's, I think, Greater Chattanooga Area, Chattanooga Association of Realtors, employees, had agreed to transfer Mr. Faulkner's license to my firm prior to this contract being written. Zach has been to GCAR several times to try to sort out his status.
Let me stop a minute.
Okay.
What is GCAR?
I believe that it stands for the Greater Chattanooga Association of Realtors, which is a trade association that some of the licensees belong to.
What would that have to do with his license status with the state?
It doesn't have anything to do with his license status as a state, only with the state. Only about 80% of the licensees are members of the trade associations.
So just trying to sort it out with GCAR, would that have affected at all his license status or the broker relationship between Mr. Cowden and Mr. Faulkner?
No, and at any time you could go on the Trek website or call the Trek office and find out the status of a person's license, whether it's yours or some other person's license.
Go on and read the rest of that response, please.
Yes. However, Zach's agency status with American Elite was unbeknown to him, Zach, terminated. Upon finding out his agency status had been terminated as the broker the contract was written under, I took over the contract, relieving him of his responsibility as I understood I should.
Martin, stop just a minute, please. And are any of the documents that you looked at today show anybody besides Region Properties and Region as the broker on those documents?
Other than the top says Sentinel, but no.
Okay.
All the line signage is for company listing is Regent.
And that's including as early as August 10th of 2000?
That is correct.
Okay. Could you go on, please?
Once I relieved Zach of the real estate contract responsibility, he completed the loan process in his stead of his employee, Mr. Wood, with the same lending institution, Allied Home Mortgage. His actions pressing the deal forward was to complete the loan so his borrower, my buyer, would meet the rate lock expiration date and not have to pay any extra fees. Tad Broomfield with Sentinel Properties used to work with me several years ago. The confusion with the logo on the forms goes back to when he was leaving my company to start his own. We have tried unsuccessfully several times to get it fixed through the local association of realtors. As you can see by the attachment, we have found the person to assist us and rectify the situation.
Hey, hold on just a moment. Those forms, are they forms that are accessed by anybody at all that can use them at any time?
The Tennessee Real Estate Commission doesn't have any forms. We don't have access to any forms at all. We don't write forms ourselves.
Okay, so your records reflect at any time when Sentinel was a part of Regent Properties?
Sentinel was, according to the Trek records, never a part of Regent Properties. Sentinel was first licensed on 9/30 of 2009, and the only principal broker, according to the Trek records, it ever had was Mr. Broomfield.
So how would documents be available to anybody at Regent with Sentinel's name on it, if you know?
I don't know, since the Tennessee Real Estate Commission doesn't endorse forms or have forms.
Thank you. Could you go on and read the rest of the letter?
Robin with Pioneer Title is very professional and effective. She and I had a previous personal relationship. I knew Zach was going to be at the closing as the lender, so I asked him to pick up my commission check, which he promptly delivered. I did not want to cause any extra stress at the closing.
Hold on a minute. So he did apparently get paid a commission in this transaction?
I don't know whether he was paid a commission, but Mr. Cowden was paid a commission.
That's what I'm saying. Mr. Cotton was paid a commission.
Well, from his answer, it appears that he
Okay.
did. Do you want me to go on?
Please.
It is noteworthy that the seller is satisfied with the transaction, the buyer is satisfied with both his purchase and his loan. If you have further questions, please correspond or call me directly. I hope I've explained the situation satisfactorily, respectively, Frank E. Cowden III. And this answer was received on November the 8th of 2011.
And the rest of the documents in this particular form, are these the rest of the complaint file that was opened in this matter?
The package that you
Yes,
handed out?
Yes.
I believe that they were.
Okay, and included in that, just so that we be clear, are some documents, and I'm not going to ask you any particulars about them, are documents that somehow are named Supra? What is Supra, if you know?
You found the document, and I'll see if, is it before the purchase and sale, after the purchase and sale agreement?
No, not in those documents.
Oh, not in those documents, okay, sorry. I thought we were on that package. Oh, sorry.
That's okay.
The new matter transmittal?
That's the complaint file, is that?
That is correct.
Excuse me, before you go on, did you intend to make this response an exhibit, and do you want to, or you're going to do it later?
It is a part of
Okay.
this document, so I wanted to
Okay.
clarify it
All right.
before I got it, so that there was no confusion on it. Is that the complaint file and part of the complaint file that was a part of opening of this matter in legal? This was
Yes, this has my initial comments and then my review once we got an answer.
Gotcha. And in that document itself, you turn the next page, that's the complaint itself?
It is, and it's, do you want me to read the heading?
No.
Oh, okay.
And then the next page?
Next page is just the affidavit of complaints, which is blank. The person typed it up
And this, the next
individually.
following page, is that the complaint that was filed by Ms. Fuqua?
Yes, it is. It
And I'm not
says-
going to have you
okay.
read that.
Okay.
Next page, that's the documents I'm questioning. What is Supra?
Oh, it appears to, it says it's Supra Web Management website, and it appears to list the individuals who went in and out of the house
At that property.
at that property.
And if you keep on going, do you find Mr. Cowden's response in that?
Yes.
And the date of his response?
The date of his response is November the 3rd, and as I say, it was received by the Tennessee Real Estate Commission on November the 8th of 2011.
And all of these documents were sent to Mr. Cowden for him to prepare and file his answer?
That is correct.
If the court please, I'd like to ask, then I'd be able to have this complaint filed, reviewed by the commission, and entered as my next exhibit.
Objection, Mr. Harris? No objection. All right. So are we going to mark this as Collective Exhibit 3?
That's correct.
Thank you. That's granted.
Thank you. Thank you.
Has there been any other contacts or considerations by Mr. Cowden to what happened here, to the commission?
Not to my knowledge.
Okay, so his sole response was that response saying that he was acting as an assistant?
I
Mr.
believe
Faulkner?
until the consent order was sent out. And I assume he responded to that because we're at a formal hearing, but not to me.
Not to you, okay. I have nothing further for this witness at this moment.
Thank you. Mr. Harris?
Can I have a quick 5-minute break? The reason I ask that is because of the discussions that have taken. I have evidence available pertaining to that on my phone, pertaining to that. Obviously, I didn't know that was going to be an issue in this manner. Even business cards, but I would like to, if possible, get the webpage, someone to print that for me. If at all possible.
I don't have an objection to that, but I want this commission and you all to know it's not because I didn't reveal it. Sharp was brought up by Mr. Harris, and this morning we did more further investigation, and he had asked for the complaint file of Mr. Sharp that we don't have, and she did a further investigation first thing this morning. So it's not like I'm withholding anything from him.
Well,
It's
I
just
don't
that it
think
was-
that's the challenge here. I just think he's asking for a little bit of time and some cooperation to print off the webpage so that he
I
could
agree.
respond.
I don't have
I'm
a problem.
suggesting it was withheld.
No, I
I'm
just
not
wanted that to be
suggesting
clear, that this was not from oversight or trying to withhold anything. I have no objection to him.
We're ready. Commission members, how long do you want? 10 minutes?
10 minutes,
All right,
no longer, 10 minutes.
all right.
Referencing
Yes, sir.
Are we on the record, Steve? Okay, go ahead, Mr. Harris.
And please, be sure you speak into your microphone, because I think
Yes, Your Honor.
it's
I
kind of hard to
will.
pick up your voice sometimes.
I'll attempt to. Previously, you were referencing 6213-310, the
Yes.
statute pertaining to transfers from
Yes.
one broker to another. In reviewing that statute, doesn't it state that the present broker shall immediately sign and date the change of affiliation form prescribed by the commission? So that would be the broker that Mr. Faulkner had at that time was required by law to sign the transfer form.
To release him, but to affiliate with another firm, the accepting new principal broker has to sign the Trek One form as well.
They're required to sign something.
They're required
upon
to sign-
request, they're required to sign a document.
Trek One form, the same form that the releasing broker would sign, but they can be signed as separate documents, as separate forms. And you have to pay a $25 transfer fee as
All right,
well.
and immediately upon that being sent, the agent can go ahead and move forward with handling of marketing of homes. Is that correct?
No, that is not correct. Immediately upon our receipt of a release, because there's no money involved in that transaction, you will be released from your former firm immediately, and that relieves that principal broker of any further liability in regard to you as an affiliated licensee. In order to be processed into the new firm, you have to send in the $25 fee with the transfer form, and then it has to be processed by the cashier's office, come to us, and then we enter the information into the computer system. So there's usually about a 3-day, maybe a 3-day lag, depending on at what point it's received. And at that point, we always tell people to call and check to make sure that their information has been processed into our system before they start work. They don't have to have the physical license to.
So is it the principal, is it normally handled by agents that upon transferring from one broker to another, they remove all MLS listings until such time as that 3-day period passes?
We don't have anything to do with MLS. We are not affiliated with MLS at all. That is, it's a private company, so I don't know what they do in regard to the MLS. I know that we have the official records of the Tennessee Real Estate Commission, and that's the official record of someone's license, what's in our files, not what's in the association's files.
All right, so if they keep up listings during this 3-day period, are they violating the rules of the commission?
Yes, you would have to transfer your listings to another person, but the listings, unless the principal broker has allowed you to take them, stay with the principal broker in the firm, because that's the statute provides that they belong to them.
I'm specifically referring to the 3-day period you
Well, it's not
discussed.
necessarily a 3-day period. I just it could be a 5-day period. It's just that the money has to come to the cashier's office, it has to be processed, and then it comes to Trex. So, just there is a time frame, and we try to get it done as quickly as possible.
But during that time period, any agent who is showing any homes is breaching the rules of the commission.
That is correct. Now you can transfer online, and that's immediate. And so some individuals today are effectuating the transfers online.
You referenced, though, that in the event that a broker is not cooperating,
right,
an affidavit can be sent in by the new broker as well as the agent for that transfer to take place.
If the old agent would not release an affiliated licensee who wanted to transfer for whatever reasons, then there is an affidavit that the affiliated licensee can sign that that's on the Trek website, and you can have that if the broker won't release you, or say he's deceased, or he's gone in the cover of darkness, or he just won't sign it.
So they would have to refuse to sign it. To use that form under this affidavit, you would have to submit an affidavit that says they refuse to sign this document for the transfer to occur.
The affidavit just says that he was unavailable to sign it. We don't ever ask, did he absolutely refuse to sign it? If a licensee wanted to leave a firm and sent that document into our office, not to go to a new firm because it has to be signed by the new principal broker to go to a new firm, but if you just wanted to leave your old firm and you couldn't take any listings with you, if you just wanted to, physically, you just wanted to leave that firm, then if you send in an affidavit that says, I want to terminate my affiliation with this firm, then we would terminate that affiliation with that firm based on the representations that were made by the licensee.
But the licensee would have to say that that individual is unwilling to sign or is unavailable.
Right.
So if the broker is instead saying, I'm willing to sign and I have signed it, can you submit that affidavit?
Well, if the I don't understand your question.
If the initial broker says, I have signed this document and have agreed to sign it, can a licensee then submit an affidavit saying, I need to terminate my relationship because they refuse to sign?
Well, if your principal broker has signed the TREC 1 form, I don't know why they wouldn't send it in. It relieves them of liability. So
But if they don't, what can the agent do? If they don't, isn't the agent left high and dry because they can't submit an affidavit?
No, they
Because-
could, if for whatever reasons your principal broker wouldn't send the TREC 1 form in, then if you wanted to transfer somewhere else, you could sign the affidavit, and then you could get your new principal broker to sign the TREC 1 form accepting you to transfer into his or her firm.
But if the broker, under the law, the broker is required to sign it, how is an agent able, it appears you're having trouble determining what a criteria would be for this agent to move forward and submit something when the broker is saying they have but not submitting it. Now, if an agent goes to the broker and they said they have submitted it but never do, when they say we have sent it, can you then submit an affidavit saying, I need this transferred or terminated or be released because it has not been received by the state?
I'm sorry, I mean, I know what criteria we use. It's that I can't imagine that sort of a situation. So if your principal broker, it's the licensee can go online at any time and find out what the status of their license is, or they can call us. So if your principal broker said that they had signed it and sent it in, and you're talking about the release, you're just talking about the releasing principal broker who said, I've signed it and sent it in, but he really didn't, or it got lost in the mail, whatever happened to it. And then say the licensee called and said, I want to transfer to a new firm, and have you got my release from my old firm? And if we said no, then if he didn't want to call his old principal broker, he could fill out the form and send it in to us.
I'm not saying this makes sense. I'm not saying this makes logical sense for this to occur. But if he goes back to the broker and the broker again says, I'll send it in, can he submit an affidavit saying they're refusing to cooperate, so I need to be released?
If the Tennessee Real Estate Commission continues to not receive the form, then the individual can submit the affidavit and say that the person represented that he or she was going to send in, and it never got here. But as I say, we have to have it signed by the accepting new broker.
Where is the cutoff point for this agent, though, for the licensee? You say they can go forward if they refuse to send it in. Well, if it's been 1 month, can they submit an affidavit?
They can submit an affidavit if your principal broker tells you that he sent it in and doesn't, or it doesn't get here, and as I say, you don't want to call him and ask him if he has sent it, then you can send it in immediately. I mean, that's...
But if you do call him, I'm not saying you're not willing to call him. If you do call him and they say, we have or will send it, they're required to by law. What you have testified to is under the law. He can't submit that under an affidavit because this broker is saying they're going to cooperate or have sent it.
If the affiliated licensee believes that the principal broker is not cooperating because he has not sent it as he said he would, then the licensee can fill out an affidavit and send it in, and we'll broker release him. And then if he wants to affiliate with a new firm, it would have to be signed by that new principal broker, and the fee would have to be paid.
How long if it's 60 days and the licensee submits an affidavit, where is this line where a licensee would be able to come to you and say they're not signing it and I need to do something. I mean, whereas at some point there is obviously a break where you know they're uncooperative. There are other times you think they're being cooperative, just not putting it in the mail. How is a licensee, what is the criteria for the licensee to make that determination?
If the licensee, I mean, we haven't had a situation where the licensee, that I can recall, where the licensee said the person over and over and over represented they would send it, and they didn't. But if a licensee was ready, willing and able to go to another place and was just waiting for the release from the principal broker, if maybe that kind of a situation, if the licensee is anxiously awaiting going to the new place and the principal broker didn't release him, he could do it immediately and say that he didn't send it in. I mean, then if it came in, we would have we'd have the release from the principal broker and we'd have the affidavit from the licensee.
But you would understand why a licensee would wait when a broker is saying, I am sending in this form. You understand why a licensee would do that, don't you?
Normally what happens is the principal broker sends in the release or gives it to the licensee who says, I'm going to go transfer or I'm going to retire, and the licensee doesn't send it back in.
And I understand normally this isn't what happens. And I understand you said this has never happened before.
No, I don't know if it's ever happened before. I haven't seen it happen.
That's the evidence we're putting on. This is the case we've got. So if a licensee, if the broker says, I'm mailing something in, but refuses to do so for a prolonged period of time, in 30 days, is it proper for the licensee to go and submit that?
The licensee could do it in 24 hours or 48 hours. If he called direct and we didn't have it, then, I mean, he could do it that afternoon if he didn't think the principal broker was really going to send that in.
But if he thought they would?
But if he thought they would, and 24 hours goes by and 48 hours goes by, he can send it in at any time. I mean, he can send it in at any time.
Under the law, the broker's required to sign it. So it's your testimony that a licensee should not worry about the broker signing it, essentially. He should go ahead and submit an affidavit immediately.
No, that is not my testimony. My testimony is that the principal broker, you go ask the principal broker to sign it, or sometimes the principal broker will sign it without your asking them, and broker release people who don't renew their licenses or don't have E&O. There's a number of reasons why people might do that. And if the principal broker, if then the licensee feels like the principal broker won't sign it, doesn't intend to sign it, said he signed it, wasn't going to send it in, or some other set of circumstances, then one can fill out the affidavit.
But if they believe they are going to submit it, and believe they have submitted it, isn't that a completely different situation in which you just said when they haven't submitted it, refuse to submit it, or the licensee believes they might not? I mean, a licensee, it would be logical for a licensee to think, they say they've submitted it, so they have, or they say they will submit it, so they will. In that circumstance, should an affidavit be submitted when it is understood and believed that the broker will be submitting this release as required under the law?
Well, we can't give legal advice or opinion, so I don't know what goes through a broker's mind. I don't know whether it's an acrimonious relationship, so I really don't. I couldn't speak to a situation because I don't really know what the situation between the parties is. So whatever determination that licensee makes, whether it's in 24 hours, whether it's in 6 hours, whether it's in 48 hours, if they feel like that they are not going to get the release and they have a place they need to go, then they need to take whatever steps they believe are necessary, and if that's filling out the affidavit and sending it into TREC, then that would be what they would need to do. But, we don't know what a given situation is or what goes through someone's mind when they're faced with a desire to leave and someone won't let them leave. And I know that someone doesn't want to file a complaint and wait for it to happen. They want to leave and be able to go to work, and that's certainly what we want them to do, is to be able to find a new firm if that's what they want to do and go to work.
I understand you see these as hypotheticals. I understand that. But, I mean, this is a situation where if there are consistent representations made that are believable. That are believable. Under your affidavit, it doesn't sound like there are grounds for submission. If they are believable.
I don't know what's believable because that would be the perception of the individual who's hearing it. It would be based on their relationship, past and present. And those are determinations that I can't make sitting here in this office or sitting in this room. I mean, I don't know. That would be the person's perception who wanted to fill out the form. I mean, if we get the form, we'll take it and we'll broker release the person. And that's, that's what our policy is. And, most people fill out a Truck One form unless the principal broker is deceased or otherwise unavailable to sign or in jail or some other thing like that that's come up.
And those are the situations you usually see this type of problem where an affidavit is necessary.
We don't see many affidavits at all, quite frankly. Normally, as I say, the principal broker faxes in a broker release, releasing the individual for whatever reasons, as I say, if they have an expired license or don't have E&O or don't have their education that's required. That would be the more typical situation, is for that to come in.
Walk through in detail a number of the documents from this closing. Throughout those documents, when referring to the broker, it states Regent Properties as the broker, does it not?
Yes, it does.
Is the only reason you think that this might not be Regent Properties is because of the caption on the top of this document?
The only reason I think that Mr. Faulkner wasn't affiliated with Regent Properties.
I'm referring to the involvement, to the suggestions and the allegations before this commission that this was not potentially a Regent property closing. And that was based on these documents, the Sentinel Commercial Properties logo on the top. So is it these documents, based on your review, throughout them refer to the broker as Regent Properties, correct?
That's correct.
So the sole basis for your opinion that having Sentinel, that there is any question that this is a Regent document is this caption on the top?
And Mr. Faulkner was not a licensee with Regent Properties, and he signed on here. Mr. Faulkner was affiliated with he wasn't affiliated at all during this interim, and prior to that, he was affiliated with a totally separate firm, never transferred to this firm.
But there are
Nor
a
do we
number
have
of
any
different
proof that
allegations and claims before this court.
Excuse me?
There are a number of different allegations of wrongdoing before the commission. One of those is a claim of dishonesty. Much has been made of this logo on the top of these forms.
Correct.
Correct. Reading through the actual documents, isn't it clear that this is a Regent property transaction?
I don't know that it would be clear to the average consumer who was looking at these documents and saw one name at the top and one name at the bottom, because the average individual doesn't really know what these firms' relation may or may not be. So it would be misleading to the average consumer, and it would be a violation of 312, a potential violation of 312.
But when you read this document, when you read these documents, you understood that this was a Regent transaction, not a Sentinel Commercial Properties transaction.
I didn't know. I mean, I was reading the documents for what they were. I didn't know whether it was one or the other. I mean, I know the representation, it had Sentinel at the top, and it had Regent at the bottom, and it has Keller Williams on it as well.
It's my understanding you're a lawyer, correct? Is that correct? Or
I'm an attorney.
Legally, don't the terms of the contract?
Objection, Your Honor. Ms. Maxwell is not here as an attorney and does not represent the commission as an attorney or review things as an attorney. It just her legal knowledge and experience is not something that, I am talking into it. Okay, her legal experience is not something that could or should be considered because she doesn't give legal advice to the commission and can't use her legal advice with the commission in her job. She's a director.
Ms. Maxwell, are you currently licensed and up to date as an attorney?
I'm licensed, I have an active license in the state of Tennessee and a retired license in the state of Colorado, but I don't practice as an attorney for the state. I'm an executive director and not listed as an attorney for the state.
Right.
I mean,
well,
that capacity.
I don't want to go too far down this line, but I'm going to overrule that objection at least right now. And you can certainly renew it if he wants legal advice. But he's asked her, as director and attorney, what's her interpretation of these documents, and I think that's reasonable for him to do that. So that's overruled. Go ahead.
Yes, the question again, please.
When you read the body of these documents, ignore this logo, when you read the body of these documents, do you understand that this is a Regent property transaction?
When I get the complaint, any complaint in, I read it from the standpoint of an average individual and what the situation is with the complaint that's been filed.
I'm asking for your understanding, not the average consumer. You're the one that made the analysis of the complaint. And I'm not going to go any further down this road. I'm not. I just want to answer this one question. When you read the body of these documents, did you understand that this was a Regent Properties transaction? Disregarding this logo, when you read the actual contracts, did you understand this was a Regent Properties transaction?
I saw Regent Properties as a selling company, but I also look up to see when any complaints filed, whether licensees are licensed and with whom they're licensed and affiliated. So I do that when we get a complaint in as well.
Mr. Harris, I realize you're not getting a direct answer to your question. However, I'm not exactly sure it's a fair question when you say, forget about the logo on the top, look just at the document itself. How can that happen? I'm not sure that's a fair question. But, Ms. Maxwell, I will give you one more chance just for a straight answer. If you didn't see the logo, now, I mean, this is so hypothetical because the logo is there at the top. But I think what he's asked is, if you didn't see that and you read through the body of the document, would you believe it was a Regent transaction? Yes or no?
I don't know if I could really answer that yes or no. If I just looked at the writing on the paper, the selling company is listed as Regent Properties. So if you were to take it at total face value with all the other information whited out and just look at the selling company, you would believe that the selling company was Regent Properties, but then you'd have to look at the licensees as well.
Okay, all right. I think that we're going to stop right there.
Previously presented was actually exclusive. Have you seen today an exclusive buyer representation agreement? Was that presented to you?
So it was in this large,
It's not in that.
I don't think I saw it today.
I do not have a copy of that either.
If I could ask everybody involved in this matter to be cognizant of your proximity to the microphone closest to you and the volume of your voice, because we need to have a record of this and everybody needs to be heard for the record.
I apologize. I know I'm the guilty culprit here. I'll try a little harder.
Oh, it may be me as well.
Being an auctioneer, I'm very cognizant of microphones and voice. So just speak as loudly as you can reasonably speak, closest to the microphone.
Thank you, sir. May I approach the witness and provide her as well as?
Show counsel first.
I have no objection. And this is not a document that I received or reviewed earlier. It's not a part of the complaint file. It's not a part of the documents that were provided to me, but I still have no objection.
Right, then you may show it to the witness. And no objection to
Objection.
admission into evidence. All right, then we'll mark it as Exhibit 4. One, I need one, they need one. Thank you.
Please take a look at line 1 in this document,
Uh-huh.
where it states broker/firm, who is named.
Regent Properties, and it's on a Sentinel Commercial Properties Exclusive Buyer Representation Agreement form.
Please just answer the question.
When it states buyer, who is named as the buyer?
Alan Thomas,
Was that the buyer in this transaction?
I believe so. Yes, Alan Thomas is listed as the buyer in the purchase and sale agreement that I have a copy of.
Will you please look at line 258 down in this document, the final page?
Okay?
Mr. Thomas, as buyer, signed this when even immediately above it states that the broker is Regent Properties, did he not?
Correct. Or it says a broker firm in the parties below, it says Regent Properties.
So Mr. Thomas obviously understood that Regent Properties was the broker.
Objection to anything that Mr. Thomas could or could not have understood. He's not a witness, and he's not here to present his understanding of this document.
I'm going to sustain that, but I think you could reword the question to elicit the answer you're seeking.
Should it not be clear to an ordinary, I believe you put it, an ordinary consumer, that Regent Properties is the broker in this action?
Listed as the firm, there's a different person who signed it on behalf of the firm.
If you'll speak up, Ms.
Oh, I'm sorry. The firm is listed as, the broker firm is listed as Regent Properties, and then it requires it to be executed by someone from the, a licensed individual from the firm.
Would not a reasonable consumer who signed lines under believe that Regent Properties was the broker in this action?
Again, I'm going to object. I don't know that Ms. Maxwell can testify as what a reasonable consumer.
Well, normally I would sustain that, but she has testified previously that she looks at forms from what a reasonable consumer would see, and so I'm going to overrule that objection because she's already brought that into contention.
I think as a reasonable consumer, you would look at all the items in the box where that information is located.
Will you explain that answer to me?
Yes, there's a box
apologize.
around, or at least on my copy, I don't know if it's on the other copies or not, but there's a box around mine starting at about line maybe 257 or 258, I guess. It says the parties below have signed and acknowledged receipt of a copy, and it says broker firm Regent Properties, and contained within the same box, it says by broker or licensee authorized by broker, and the name is Zach Faulkner, who signed on that. And so that's all contained within the same box. And then below that is another box that contains the signature of Mr. Thomas and his address.
Just to restate, you're saying a reasonable consumer would look at the box as a whole. That's just my understanding of what you said, right? Correct?
Correct.
Have you ever known of errors in headings, whether in real estate transactions or any other transactions, to occur?
You mean like at the top of a statute where it has the wrong name, or the paragraph
Yes, ma'am.
is misdesignated?
Where it would say Sentinel Commercial Properties. Are you aware of a situation like that ever happening in any transaction?
Well, the Real Estate Commission doesn't endorse forms, so we wouldn't write a form. I haven't seen one with the wrong caption at the top, but that, I haven't seen it myself personally, but that, that's just my own experience.
There's a document that's before y'all I'm trying to locate. I have it tabbed in here. I believe, and counsel correct me if I'm wrong, that already presented as a notification pertaining to the transfer of this transaction. I thought you read on.
What's the name of it?
It's notification, and it pertains to the mortgage loan officer has been reassigned to Zachary Faulkner. I believe that document was.
I think it's in
read
Exhibit
earlier.
2.
I think it was part of the collective exhibit.
Excuse me, are you talking about the letter from?
Doesn't say notification. It says notice to underwriting, processing, and compliance / and closing. Is that the one you're referencing? I think he's
Oh,
talking
Your
about
Honor,
that one. Okay. What exhibit is that?
It's the second notification form in on Exhibit 2.
It's at the top it says revised, Your Honor.
Okay.
Locate this in your stack?
I did.
Okay. This notification, paragraph 1, does it reflect that it was sent from the buyer to the seller?
Yes, that's the box that's checked.
And there is specific, in paragraph 4, it specifically says information has been discovered, meaning at that time, information regarding the license status. Is this a disclosure to opposing, to the agent on the other side of this transaction of what had occurred during the course of this transaction involving Mr. Faulkner? I'll restate
don't know.
because
I don't
that
know.
was very poorly worded. Should Ms. Fuqua have understood that this transaction was being transferred to Mr. Cowden?
I'm going to object. Ms. Fuqua is not a party. She's also not the buyer or seller in this, and it doesn't reference her at all in this document.
Sustained. I think, again, you could restate.
Ms. Fuqua, the complainant in this action?
Cheryl, what's her name? Cheryl, I believe it's Miss Cheryl Fuqua is the complainant. I believe her name is Cheryl Fuqua.
I'd like to present, I believe the complaint, the entirety of the complaint has been presented to Your Honor as well as to the committee, which would include the statement of Ms. Fuqua.
Objection, Your Honor. With that part, while part of the complaint itself was not read into evidence at all, in fact, the documentation and everything concerning Ms. Fuqua's complaint was not presented at all. It was a part of the complaint that was originally sent to Mr. Cowden, which is why they have a copy of it. But the issues involving Ms. Fuqua's understanding or not understanding are not issues that have been brought before this commission or part of the facts that are being considered today. So I
Well,
would object.
But I'm looking here in Collective Exhibit 3, and on about page 4 or 5, well, there's official complaint and affidavit from Ms. Fuqua, and then attached to that is complaint against Zachary Faulkner.
That's correct, Your Honor, but this was a complaint that was opened against Mr. Cowden as his role as the principal broker based on the complaint that was opened and not necessarily as the facts in there. But in any event, Ms. Fuqua's name is not on this document anywhere at all. On the Sentinel Commercial Properties document, it's a notification from the buyer signed by a notifying party, and her name or her ability, again, to understand or not understand this notification can't be verified because she's not here to testify.
Well, but in evidence, I mean, now, if he had objected to this being into evidence, I might have considered that objection because she's not here to verify it. But we've got an official complaint and affidavit that she signed, and then, and you asked for that to be admitted into evidence, and then attached to that is her explanation of her complaint against Zachary Faulkner.
Then I would ask if that her entire complaint be read into the record before this particular issue have been addressed to see if there is a connection. I would like her response.
No, it's already in evidence. The commission members can read it.
Okay.
I don't know that we need to take time to go through this page and plus
I understand, Your Honor.
document.
Then I would ask that. The reference to this particular document be read from the document and signing of the complainant. The reference to this document and her understanding or not understanding should then be a part of what she wrote in, and I would ask that be read into the record.
Again, if you want to point out on redirect specific areas, but I'm not
Okay.
thinking we need to sit here and read this whole thing into the record because the commission has it right in front of them, and they can read it a lot faster than, even though Ms. Maxwell is very adept at reading quickly. I think if you want to point out specific sentences or paragraphs, that's fine. But now, I don't see Well, yeah, I do. So anyway, where were we? Mr. Harris? Did
Actually,
you ask a question?
I had not
Ms.
asked
Maxwell?
it yet, and honestly, I don't intend to spend a whole lot of time on this. But you conducted a review of these materials and determined what was appropriate and not appropriate with regard to the way this was handled, this transaction was handled.
The Tennessee Real Estate Commission, as all other regulatory boards, opens every complaint that comes into our office. And if there's a principal broker involved who failed to supervise, which is what the complaint against Mr. Cowden is involved, then a complaint is also opened against the principal broker, which might be based upon the complaint against a licensee that principal broker was failing to supervise.
Who made that determination in this case?
The commission has in the past made a determination if there is a principal broker and an affiliated licensee, the principal broker under the rules in the statute has an obligation to supervise, and a complaint is opened against the principal broker.
But I think the question is, who made the decision to open up the case against the
The
principal?
commission has made a blanket decision, the commissioners, I should say, the commission, not the commissioners, made a blanket decision that the complaint should be open for failure to supervise in situations that there was a principal broker who should have been supervising someone.
Right, I realize the rules and the statute say that, and that's the result of the commission's actions. In individual complaints, I think what he's trying to ask is, has this been presented, this situation been presented to the commission for prosecution, for want of a better word, or did someone else make that determination?
The principal, there's a complaint. There is in almost every instance a complaint open against the principal broker where there's an affiliated licensee. That determination is made by our office because the commission has said that in instances where there's a principal broker and an affiliated licensee, a complaint should, if it's not already filed, some people will go ahead and file against the principal broker as well, the complainant. But if not, then we as administratively open a complaint against that principal broker for failure to supervise.
Thank you, Ms. Maxwell. Does that answer your question?
Part. In this case, does we mean you? Somebody reviewed this and made that initial determination.
The commissioners is sitting, not necessarily this particular group, the commissioners have made a decision that the complaint should be open against the principal broker where there's an affiliated licensee involved, and that's what we do. And so that determination is made by us based upon what the commission has directed us to do, because the commission has the ultimate authority to make any disciplinary decisions. We just carry out what they ask us to do, and that's what they've asked us to do.
I think we're getting a little circular here.
Sorry, I'm trying to answer the question.
I think the question, was, who, when you say we, meaning your office, do you have a staff? Was it you? Who made this decision? We could do this in 3 words.
Okay. Yes. Okay.
No. Don't tell me about the commission again. I already know that. They know that. We know what the rules are. We know what the statute is. And you are charged with carrying out the functions of those rules and that statute. So, who made that determination?
I made that determination.
Thank you, ma'am.
And that determination was based on the information provided you by, let me restate. The initial determination to even request answers was depending on your evaluation of the allegations by Ms. Fuqua.
That's the Tennessee Real Estate Commission.
Judge, excuse me just a minute. I can't hear this man, and I've turned my hearing aid up about as high as I can get it.
I apologize, and I'll make sure
If you will lean into the microphone.
I'll do that, and
All
I'll
right.
move it as close as I can.
All right, I appreciate that. And I'm about to call a halt to this because I think we've gone about as far as we can go.
I'll move on. Thank you.
Okay, thank you.
Thank you. Presented to you as, I believe, Exhibit 1 was the TREC form. I might have the affidavit, the exhibit number wrong, and if so, I apologize.
It is number 1.
Yes, Form number 1, TREC Form 1, Exhibit 1.
Will you please look at line 5 in this document?
Okay.
Do you see the date on which it was alleged to be executed?
I do. It was executed on the date of change of release that was executed says 4/15/2011.
And the date of approval was what?
Date of approval, when we entered it into the TREC system and received it, was July the 22nd of 2011.
So does it normally take 9 weeks for this process to take place?
Frequently, a principal broker will date a form and hand it to the licensee, and the licensee doesn't ever send it, and the principal broker sends it on. We go by the date that we actually approved it. So the date that it was signed, until it's approved and entered into our system, the date that it was signed doesn't have any bearing on it.
But you've based part of your determination on when Mr. Faulkner was and was not licensed. You went from this April 15th date, did you not?
He was broker released on July the 22nd of 2011 in our records. And that was when he received the letter that went out to him was dated July the 22nd.
Correct me if I'm wrong, but I believe, I understood your testimony to be that his license was terminated as of the 15th of April, the date on which this was signed.
I don't recall testifying to that because it's not, it's the date that it was entered into our system, which is 7/22 of 2011.
So until the 22nd of July, 2011, Mr. Faulkner had no issues with marketing properties?
We
Is that under-
We had him in our system as affiliated with Elite, American Elite Realty, with Vicky Sane as his principal broker.
So a subsequent broker, Mr. Cowden in this case, he bears no responsibility for anything that happened prior to the June 22nd of 2011. Or July 22nd, I'm sorry, 2011.
That was when when Mr. Faulkner was officially released, according to our records at TREC.
So could Mr. Faulkner have gone to work for Mr. Cowden prior to that time?
He had gotten a broker release form filed with the Tennessee Real Estate Commission, paid $25 transfer fee. I mean, it would have had to have, the TREC one filled out by the accepting broker, and he would have to have either the affidavit or have a release and then pay the $25.
So the real issue in this case is the Mr. Faulkner services after July 22nd, 2011. Prior to that time, you don't have any concerns of Mr. Cowden's actions because he could have no idea that he had been released. Am I correct in stating that?
I don't know what Mr. Faulkner did or didn't know, whether he had any, I just don't know.
I understand, and I'm not suggesting you should. What I'm asking is, could Mr. Cowden have found out that he had been released prior to the 22nd of July of 2011?
Not from our records, he could, not from the Tennessee Real Estate Commission records, he could not have.
Okay. And subsequent to that, which has also been provided to the commission, is the letter of July 22nd, 2011, in which Mr. Faulkner was given notice of the filing of this document. And is that before you?
Yes, I have that.
This document provides Mr. Faulkner 10 days to fix this situation?
To either retire his license or transfer to another firm. That's correct.
So during that 10-day period, he was still licensed by the state to serve as an agent?
No, he was not. He was in a broker release status. It's
So
just that if you, under the statute and under 312, if you do not affiliate within 10 days, it's a potential violation of 312 for failure to follow administrative measures as required by the statute and the rule.
So upon this letter was sent to 1924 Presswood Drive in Hickson, correct?
That's the address at the top. Yes, that's correct.
Do you know if that was Mr. Faulkner's correct address?
Our records show that that was the address that we had had since his home address, which is where a broker release letter would go. Since you're no longer affiliated with a firm, our communication with you would go to your home. And that's the home address that we had had since he was initially licensed in 2008. We didn't have any change of addresses in our system for his home address.
And when this letter was sent out, if it was sent to Mr. Faulkner at his home address, no longer lived there, obviously he would not have received notice of this.
Well, no state mail is forwarded, so it's all returned to us. And when it comes back to us, if it comes with forwarding information, we forward it along with the Truck One form so that they can also change their address, their home address. And we make a note in the file. There is no note in Mr. Faulkner's file that this came back to our office. We make it in the file, like in their computer file.
You happen to have Mr. Faulkner's file?
I do.
Do you?
I do. His licensee file.
The licensee file. Yes, ma'am. Do you see a letter in there, and all I have is a fax copy produced with the file? I don't have an official copy of this letter, and that's where the information at hand would be in the original letter. Do you see a letter dated sent on the 4th of October, 2010? And just so I'm clear, I'm referring to the stamp, the postage stamp on the upper right-hand side. I have no idea what was actually enclosed in this letter, in this envelope.
2010, is that what you said?
Yes, ma'am.
Trying to ascertain if this morning I got it in with some of these other papers, since I
I
sort of put the
understand.
files all open here together.
Mr. Harris, in order to expedite matters, would it be just as good if you showed her your copy?
Your Honor,
Or
I'll
do you
that.
need to have her testify that it is contained in his official file?
I will provide her the copy, but let me tell you the relevance.
Well, wait. I think we need to.
Okay.
I need to see it as well. I have no objection to her showing him showing Miss Maxwell. Whether she can identify it or not, I don't know.
Did you, I had the return envelope. I thought you wanted a letter. I thought you were asking me if I had a letter. I had the return envelope. I thought you were asking if I had a letter.
Mind if I see that, please?
The return envelope?
Yes. Is there any way to know what correspondence was included in that letter? And let me state that again, since I was far away from the microphone. Is there any way for you to know what correspondence or documentation sent to Mr. Faulkner was included in that envelope? As that document might include the address to which it was sent.
It would have been sent to the address that's on file with Trek as his home address.
And which address was that at that time?
It's the one that we've had since 4/28 of 2008, which is 1924 Presswood Drive, Hickson, Tennessee, 37343.
And that was returned to sender?
This particular one says return to sender. And as I say, if we get a letter back that says return to sender, we put it in an envelope with a Trek 1 form highlighted in yellow where you're supposed to change your home address if you've changed it. And we send it. We cannot change it on the official records of Trek until we get something in writing from the licensee.
So where would you have sent the Trek 1 to the licensee?
Oh, it would have gone, if we get a piece of mail back and all state mail is returned to us since it can't be forwarded, we put a Trek 1 form and send it to this forwarded address along with whatever was in here, which my guess is it was an education letter, but I don't know that for sure. And then we would send it to this address and hope that the person would send us back the Trek 1 form with the correct home address so that we could change it in our system. But we, as I say, can't change it in our system until we get something in writing from the licensee.
So if the licensee fails to turn that back in, the commission will continue to send that correspondence to the address you have on file?
We will,
Correct.
because we don't know whether the person has left that address or, we just don't have enough information from what the United States Postal Service tells us when license mail is returned.
I understand. Thank you. In reviewing the documents in this closing file, do you notice a definitive break between documents signed by Mr. Faulkner and documents signed by Mr. Cowden?
I'm sorry, what?
In reviewing, when you reviewed this closing file, did you notice a definitive break as if Mr. Faulkner signed documents up to a certain date and Mr. Cowden signed them thereafter? Did you notice that when reviewing that file?
If you look at the dates, there's a, there are two documents. I believe there are two documents in this file. They're signed by Mr. Cowden, and one is page 9 of the purchase and sale agreement, that had also been signed by Mr. Faulkner as well, and on a different page 9, but they're the same thing. And then there was one of the counter offers on August the 17th with the binding date was signed by Mr. Cowden on August the 7th, well, it bound the agreement on August the 17th of 2011, and then
At least on that date, August 17th, 2011, Mr. Cowden became listed on the counteroffer as the broker on behalf of Regent. As the individual signing or listed, let me say listed on behalf of Regent. Is that correct?
he's the person who signed as the binding, signed the binding agreement on the counter offer. I don't know that it says his capacity, because I think that's his name, but I can't read. My copy's kind of blurry. But I don't think it says a capacity in which that person signed.
There was some testimony earlier on direct examination, and I'll admit it, I had some trouble in understanding it, although I think you were clear. I'm not suggesting you weren't. And it pertained to American Elite Realty in 2011. Do you recall, I guess, the research, that you did some research into American Elite Realty as of 2011?
I did. Yes, yes, I did.
And what was your finding with regard to the existence of American Elite Realty in Chattanooga?
There is a firm by the name of American Elite Realty, LLC, firm number 259555, located at 5600 Brainerd, is that the way you pronounce it? Brainerd, Suite B2, Chattanooga, Tennessee. Its first license was issued 12/12 of 2006. It has a current expiry of 12/11/2014. The principal brokers have been, the current principal broker is Marcia T. Cowan. Before that, it was Vicki Janine Sane. There was a Mr. Spangler, a Sharon Kriminger, and those are the only individuals that have been the principal brokers of that firm. And that's the only American Elite in Chattanooga.
Are you in Mr. Sharp, did you look into Richard Sharp and whether he's properly licensed as a broker?
I did, and I found him, and he is the principal, Mr. Sharp, Richard P. Sharp, and that's SHARPE. He has a broker's license number 269433, and he's a principal broker of a firm in Coreytown, Tennessee, called American Elite Realty of Knoxville, LLC. And that firm has been in existence since 5/11/2011.
So it's your understanding he had no involvement in Chattanooga, in any realty company in Chattanooga? Is that correct?
A person can only, a licensee can only be affiliated with one firm at a time unless you're a principal broker, and you can have, you can be the principal broker of two firms if they're physically located at the same place, same address. And so Mr. Sharp we have him only with American Elite Realty of Knoxville, LLC, and prior to that, his affiliations were with RE/MAX, primarily with RE/MAX in West Tennessee, and I think he had a brief stay in Mississippi as well, according to our records. And our records do not show that that Zach Faulkner ever worked for Mr. Sharp's firm, but instead that he worked for American Elite Realty, LLC in Chattanooga, Tennessee.
And that's still an existing entity?
It has a current expiry. The American Elite Realty, LLC, that's located in Chattanooga, has a current expiry date of 12/11/2014. So according to our records, it's an active firm with a principal broker who became a principal broker, Marcia T. Cowan, on 1/30/2013.
And Ms. Sane?
Ms. Sane was the principal. She's, I think she's retired, but she was the principal broker from 12/12/06 until, I think, 1/9/12, and then a Mr. Spangler was the, well, then a Ms. Kriminger and a Mr. Spangler were the principal brokers, and as I say, the current principal broker is Marcia T. Cowan.
Well, you'll give me 1 second to just confer with my client, just briefly to see if there's...
Now, Mr. Harris, is there going to be some point when you're going to tie this all together to show why Mr. Sharp and this information that you've elicited is going to be relevant?
Mr. Faulkner will make that clear, and I
Okay.
only have...
Okay, that's fine. Just wanted to make sure.
I only have one final question. The notice letter, the 10-day letter that was sent in June to Mr. Faulkner, that would have gone to the prior, in July, I'm sorry, July 22nd, to Mr. Faulkner. That would have gone to the prior address, the address you had on file, correct?
It would go to the address on file, which is your official address with the Tennessee Real Estate Commission.
Which in this case was the Presswood address.
Yes, that we had since 2008.
I have nothing further of this witness.
Thank you. Ms. Ryan, any redirect?
I just have a minute or two of redirect.
Can we wait like 5 more minutes and so we could finish with Ms. Maxwell? Or if we don't want to wait, we can do it. If we don't want to wait, we can do it.
Wait, Grover, 5 minutes?
Oh, sure.
Okay. Continue on, Your Honor.
Put it on the clock.
Okay, you're done. Let me go back here to the release statement that was sent to Mr. Faulkner at the address on record.
Okay.
The date of that letter was what?
July the 22nd of 2011.
And so he had how many days from that date to re-affiliate?
10 days.
From the date of the letter?
You have 10 days from the date of this letter to either inactivate, retire your license, or transfer to another firm, and each of those terms is explained in a footnote at the end of the letter.
Okay, and do your records show that that letter was ever returned as not deliverable in your file?
Our records do not show that it was returned at all.
So on August 10th, the date of the first contract that you testified to earlier, the first signing of the contract, that was beyond the 10 days, is that correct?
That's correct. He was broker released on the day, on 7/22, though he was no longer able to engage in activities which require a real estate license.
Okay, and then that would mean August 19th and August 17th, he was no longer affiliated either, right?
That is correct.
And that was beyond the 10 days of the letter, is that correct?
That's correct, but as of 7/22, he no longer had a license, an active license.
And one of the dates that Mr. Cowden signed documents, what are the dates?
There was the binding counteroffer was signed as the binding agreement date on the 17th of August on 2011. And then this substituted page 9, there's no date on Mr. Cowden's signature. So it looks like, anyway, it looks like a copy of the other page 9. Except that Mr. Cowden's name is on here.
What was the date of the notice that there was a change? The second release, it's saying second document at the top.
That notification, the
Yes.
revised one?
What's the date of that?
I believe it's 8/20, maybe 8/23 or 8/2011.
So an entire...
8/26 maybe. It's kind of a strange writing.
8/26, so it's a month and 4 days after the date of the July 22nd letter?
That is correct.
Now, when a broker release form is filed, that is filed by the principal broker where the licensee holds their license, right?
The release portion of it, yes, it can. Either party can file it.
Is there a responsibility for a new principal broker to sign or file anything when an affiliate becomes associated with that new firm?
There's a responsibility of the principal broker to make sure that the licensee is licensed, and the principal broker would have to sign the TREC 1 form, and as I said, they would have to send $25 in, and Mr. Faulkner doesn't have any $25 on his payment screen except one for a certificate of licensure that was issued.
And if you received in the TREC office a form with the new broker without a release of the old broker, what could or would occur?
We possibly would contact the former broker, but if the new broker accepts them, then we hope that the broker asks those kinds of questions.
So in this particular case, the fact that the notification wasn't sent until July 22nd would not have stopped Mr. Cowden or Mr. Faulkner from filing a form to associate him with the new firm.
That is correct, because he could have filed an affidavit or he could have asked the person for it. And frequently we get the principal broker one in first, so they aren't the same document signed together.
And in any event, no notice was sent at all to, or a TREC form was sent at all to associate Mr. Faulkner at any time with Mr. Cowden's firm?
No, there was not. He never has another form to affiliate.
Now, going back to the contracts for just a moment, the fact that they are on Centennial letterhead, whether or not a consumer would be aware or not aware of that, could that be considered proper or improper behavior of a licensee firm to not have proper documentation with proper names on the letterheads and the documents?
It could be a potential violation of 312 of TCA 6213 312B, misrepresentation.
Well, would a firm be in a good position to use contracts that list another agency or firm on the letter, on the top as their documents or letterhead? Would that be a proper action of a licensed firm to use documents from another group?
I would not think so.
And in this particular incident, and Centennial Properties was never affiliated or in any way, shape, or form a part of Regent Properties?
No, it was not according to the TREC records.
Although the person that owns Sentinel at one time did work at Regent. Is that correct?
That, I don't know if he owns Sentinel or not, but he did work at Regent's.
But the firm or business Sentinel was never a part of Regent.
No, it was not, according to our records, the track records.
I have nothing further for this witness.
All right, when we come back, I'll let you do more recross, and then I think we need to let the board get into this, and we'll let them have questions next, but let's take a break.
Your Honor, can we step outside of the case for just a second? Just take care of some commission business just for a second.
It's up to you.
Mr. Chairman.
Now, wait a minute.
I just want to let these guys go home if they want to.
I mean, the note that, Your Honor, if we're in recess right now, the note that our executive director gave.
I'm ready to go. If I were in charge, we would have gone before.
What time is it now?
12 o'clock. It's 1 o'clock your time.
I've already told Judge if I could.
Don't slow this proceeding down.
It's not going to slow it down much. I've told a couple of y'all, I have an obligation in East Tennessee that I have got to do tonight to tenants, the Knoxville Home Builders Association. I'm doing a benefit auction, and this is not going to last. I mean, it's not going to be concluded probably another hour and a half, 2 hours. And I am going to have to go ahead. I was hoping to get finished and I could stay throughout to completion, but I'm not going to be able to. I will see y'all in January. We still have a quorum, and I am going to, at this time, turn this meeting, the Real Estate Commission meeting, over to our Vice Chairman, who will do a better job than I would be doing had I be able to stay. But John Grease, you're in charge, and I'll see all of you in January.
Well, Chairman Stevenson, what constitutes a quorum? Because I think Mr. Bloom also needs to leave.
I need to leave at 2.
Oh.
5.
Okay.
5 is a quorum.
Okay.
I just need to leave at 2.
Okay.
Mr. Commissioner Bloom, we should be finished by 2.
Thank you. Chairman Stevenson, drive carefully. Be careful.
My Christmas present.
All right, with that sad departure, Judge, would you take over?
Okay. Then I think Ms. Maxwell is still in the hot seat. So I think since we just finished redirect, I think we'll go ahead and allow any recross, and then I'll allow the commission members to ask any questions you might have of Ms. Maxwell. And just let me say, I would hope, in order to expedite this process, that the witnesses answer the question and only the question. We don't need to read half the form unless that's what you're asked to do. Simply, if it's a yes or no question, try to say yes or no if you can. Then you can explain. But I would ask that you answer as succinctly and directly as possible. We have our commission members here. They know what's going on, so I don't know that we need circumlocution. So I just, and I'm not directing this necessarily at you, even though you've been our only witness. This is also an adjuration for the remainder of the witnesses as well.
Not here, of course.
Well, I will tell them.
Except for Mr. Cowden.
I was going to say Mr. Cowden's here.
We could have shortened this about an hour, couldn't we?
Mr. Alexander, we need to make sure that everyone gets their due process rights. I think I've gone as far as I need to go. All right, Mr. Harris, go ahead.
I'll be very brief. Questions were asked on recross regarding potential misrepresentation through having Sentinel properties on the top, that you thought that might qualify as potential misrepresentation. In the event that there was an intent and an effort for misrepresentation, would Regent properties be named within the body of the documents?
I don't know the answer to that question.
Would there be a benefit to Regent Properties? If they're attempting to benefit through misrepresentation, wouldn't Sentinel Properties be consistent throughout instead of having Regent Properties within the body of the document?
I mean, I really don't know. I don't know.
I think she's answered.
She has. Oh, she has. I'm sorry. I'm moving on to my final issue.
All right, good deal.
There was testimony with regard to the July letter not being returned. We previously asked you some questions about an October 2010 letter that was returned. Will you check your file? And I think I saw it. Do you have a November 9? It was returned on November 9, November 3, 2011, postmarked letter.
I have one that was postmarked, yes, November the 3rd of 2011, forward time expired.
And so it was returned as well?
Right.
Okay. That's all I had.
Now,
Thank you.
I just want to make sure that you don't intend to request that any of these returned envelopes, copies of those be admitted into evidence. I just want to make sure that you've submitted everything you intended to.
I believe
Oh, we've had testimony, so.
I believe the testimony is fine, given that we don't have the contents of what's in those letters. I believe the testimony is fine on that.
All right, thank you, sir. Mr. Grease.
Thank you, Your Honor. Do members of the commission have questions for Director Maxwell?
Mr. Chairman, I do.
Go right ahead, sir.
Ms. Maxwell, would you tell me whose responsibility it is if I move and change my address to notify the commission? And isn't it a requirement that you notify the commission anytime you move?
It's the responsibility of the licensee to notify if their home address is changed.
Thank you. Now, one more, please. You may not be confused, but I'm confused about the contracts. If I look at a Centennial commercial property contract and I look at a Keller Williams contract, and is this a commercial piece of property or was this a residence or what was it?
I don't know what type of property this was.
Thank you, ma'am.
I have two questions.
Mr. Collins?
My question, you don't know whether it was commercial or residential. I wondered why they used a commercial sales contract if it wasn't. And the thing on exhibit number 4, the last page, it kept asking about the broker firm. We know who the broker firm was, but line 263, who's the person signed down there as an authorized licensee?
Zach Faulkner signed
Okay.
that.
Okay, thank you.
Other commissioners?
Mr. Chairman?
Mr. Flitcroft?
Ms. Maxwell, if we take as a true statement number 8 in the allegations of fact that respondent said that Zachary Faulkner.
I'm sorry, sir. I can't hear you very well.
Oh, really?
First time anybody said that about you.
Most people don't want to hear me very well, but that's the difference.
No, we do,
Number 8.
Commissioner Flitcroft.
If we take as a true statement number 8 in the allegations of fact that in response to the complaint, respondent stated that Zachary Faulkner was an assistant non-active agent, what did Mr. Cowden do wrong?
Well, I don't know what you're looking at, but Mr. Faulkner signed as the designated licensee for the firm. Like, if you look at, is this Exhibit 4, the exclusive listing agreement?
Yes.
The parties, it says by broker or licensee authorized by broker to sign on line 259 of Exhibit 4, which is the exclusive buyer rep. And as I said, it says by broker or licensee authorized by broker. And Zach Faulkner is the person who printed and typed their name and appears to have signed it on behalf of Regent Properties.
So I think the question was, what did Mr. Cowden do wrong? Is that
That's what I'm saying. What did Mr. Cowden do wrong?
Well,
Not Mr.
Oh,
Faulkner.
right, okay. I think I've been up here too long. Mr. Cowden, as the principal broker, has the obligation to make sure that the individuals that are representing his firm are duly licensed if they're representing the firm in that capacity.
A failure to make sure that, because the statements that were given on number 8 is that he was employed not as an agent, but as a administrative assistant.
Correct, but on the exclusive right to sell, but exclusive buyer representation agreement, Mr. Faulkner appears to have signed as the person designated as the broker or the designated licensee, person designated by the broker, the licensee, not as an unlicensed individual. And then Rule 1262-01 and following states that the broker has to make sure that their individuals that they hire and affiliate with their firm are duly licensed and hold an active license and have E&O and the other items that are required to have a license.
It's the failure to supervise him.
Correct. Which is a violation of 312.
I have a couple of questions, Commissioner
Mr.
Bruce.
Charo?
Just to follow up there, Ms. Maxwell, an unlicensed assistant cannot write a contract, can they?
I believe that that's something that's defined in 102 4AB that requires a license in order to engage in that activity.
Okay, thank you.
So they could not.
Everybody keeps going back to this revised notification that states that Mr. Cowden's going to be representing the buyer now. Was there ever any proof furnished, such as an email or a fax transmittal, that proves that that form was actually delivered to the other agent or to the seller of the property?
I haven't seen a form that indicates that there was.
Thank you.
I just have one question on clarification. Did this come before us in our legal report at some time?
Yes, it did.
I thought it did. Okay, thank you.
Ms. Maxwell, I'm a little bit confused. So Commissioner Flitcroft referenced a finding of fact where the respondent allegedly stated that Zachary Faulkner was an assistant, not an active agent. I haven't heard that proof, but maybe I just missed it. Is there a document to that effect in your file?
That was, that statement was contained in Mr. Cowden's response to the complaint that I testified, I believe, to that earlier.
Do we have that document? I just need to see that.
I don't know what
I
exhibit
think it's
number.
in Exhibit 2.
That is exhibit 1 or 2.
Yeah.
It's a 2. What's this?
All the way back.
It's in Exhibit 3.
This one. Is it? Probably can't see it.
Oh, that response was to the initial complaint, or is it to the complaint we're hearing today?
It was to the complaint that you're hearing today for the failure to supervise. Is that your question? Is that? It was the response to the complaint filed against Frank E. Cowden.
Exhibit 3.
Oh, okay. I was going to say, I can't find it in Exhibit 2.
It's Exhibit 3.
It's the one with the cover letter
Yeah,
on
it's
it.
Exhibit 3.
And where within the body?
The very top of the correspondence where Mr. Cowden responds to Mr. House. It's on the very top of the second page. Zach Faulkner works as my assistant. He is not an active agent.
Thank you. Other questions from the commission for Ms. Maxwell?
Well, not a question for Ms. Maxwell, but Robin, are you going to change the notice of hearing?
Oh, wait a minute.
I didn't understand what he just said.
The notice of hearing is the notice of hearing. Now, the parties, either of the parties could request that it be amended to reflect testimony that was presented today. But we haven't had that kind of motion as yet.
Technical record includes the continuance.
Technical record does, but the evidence, I'm not sure what.
Notice of hearing says that the hearing is to be held in Farragut on October 11th, 2013.
Just let me point out that there is a rescheduling letter. That's the technical record number. That would be technical record number 6. That is a procedural order that I entered after I emailed both of the attorneys and said, do you know when the hearing is going to be? And even though the previous judge in the continuance order had required a new notice of hearing, I instructed Ms. Ryan that that would not be necessary if she could show that she had communicated with Mr. Harris and that Mr. Cowden knew when the date and time of the hearing was. So, and we can make that a part of the technical record if we need to, if that troubles you, sir.
It does.
It does.
Your Honor, Your Honor, I just wanted to clarify. Actually, the order granted was just said it was set to be heard, and my responsibility which was to notify counsel of the time and location of the hearing, which I did do. I did not file a minute notice of hearing to reflect that, but he and I were in communication as it was his request for the continuance in the first place. So
you're right. The order of continuance says, counsel for the department shall notify counsel for the respondent of the time and location of the hearing. There was no requirement that a new notice of hearing be set. And then I will also mention that in my procedural order, I clearly set out in the first paragraph, which you don't have a copy of this, but it says this matter is set to be heard on December 5th, 2013, beginning at 9:00 a.m. Central Time, before me and the Real Estate Commission. It will be held in Conference Room 1A of the Davy Crockett Tower. Then it gives the address, 500 James Robertson Parkway, Nashville, Tennessee, 37243. So I think that clearly gives the respondent notice that it was not going to be in Farragut and it wasn't going to be whatever the former date was. And I don't think counsel is arguing that he didn't receive adequate notice of this proceeding. Is that correct?
I am not arguing that. No, I'm not.
So, in other words, you're admitting that Ms. Ryan did notify you of the time and date
She
and
did,
place.
and we did consult with regard to the date and came to an agreement as to this date.
Commissioner Philcroft, does that?
That's fine.
All right.
Other comments from commissioners before we turn it back to the judge? Your Honor.
All right. Before we wait a minute. Do we have any additional redirect or recross as a result of the commission's questions?
I do not.
I do not either.
Thank you, Ms. Maxwell. Other proof from the state?
Yes, Your Honor. I would call Cheryl Fuqua.
I hope she's not sitting back there.
She's not. She's not here. I will tell the court that she was subpoenaed, issued November 22nd, 2013. Ms. Fuqua is the complainant, and she is a licensee, but she did not appear today.
So what are you asking me to do about that?
I think I just want that on the record.
Okay. All right. And as you're well aware, if you want to enforce a subpoena, you have to go to Chancery Court. I have no enforcement powers.
I understand that. So the next person I would like to call is Zachary Faulkner.
Over here. And if you'll pull your microphone down and speak directly into it. These are...
We're old and hard of hearing.
I apologize for your wait, Mr. Faulkner. I'm Judge Johnson, and you know this is the commission. And as I recall, you have been previously sworn in. Is that correct?
Ma'am.
Okay. Ms.
Thank you.
Ryan.
Would you please state your full name for the record
Zachary Daniel Faulkner.
and your current address?
Current address 8871 Windy Creek Drive, Ooltewah, Tennessee 37363.
And Mr. Faulkner, were you formerly licensed as a licensee with the state of Tennessee as a real estate agent?
Yes, ma'am.
And when is the date that you became an affiliate with Regent Properties?
The date, I do not know the exact date, and the surroundings. The surrounding of becoming with Regent Properties was a big mess. I originally thought that it had been taken care of in between April and June, but I later found out that had not.
When did you have your new broker sign a TREC form to affiliate you with Regent Properties?
I believe the first one was in June.
That is when you had Mr. Cowden sign as your new principal broker to be your principal and a TREC 1 form?
Initially, I took it to my current broker at American Elite and was going to get her to sign it to send to him, but I do not know the exact date that I took it to Mr. Cowden.
When did you follow up with that to make sure that you were listed as an affiliate with Regent Properties and have Mr. Cowden sign the TREC form required to list you as an affiliate with Regent Properties?
I do not recall the exact date. I know we had been talking about it since the beginning of the year, and I know that in March and April is when I first attempted to start switching over and transferring to Regent Properties. My understanding of the process to do that was to get my current broker to release me and then take that to Mr. Cowden. I tried that the first time and it never happened, so after that I went to Mr. Cowden first, got him to sign it, and then tried to take that back to American Elite to get that taken care of.
Do you have a copy of that form that Mr. Cowden signed and the date he signed it, accepting you as a licensee with Regent Properties?
I do not personally know him.
Does Mr. Cowden have a copy of the form that you presented to him for his signature as signing as the new principal broker for you at Regent Properties?
I doubt that he has it because once he signed it, I took that to the broker at American Elite to have her sign it.
When did you follow up with changing your affiliation from American Elite to Regent Properties with the state of Tennessee?
I called on multiple occasions to the Greater GCAR, Greater Chattanooga Area Realtors. I called multiple times to find out what the status was, and
When did you call the state of Tennessee, where your license is registered, to communicate about transferring your license from American Elite to Region Properties?
Did not call the Tennessee Association. My understanding as a new agent under Vicky Sane was that I needed to take that to the Chattanooga Association. I did not call the Tennessee Association to find out the status from there.
Did you take a licensee examination to become a broker or a licensee in the state of Tennessee?
Yes, ma'am.
Isn't it true that as part of that test, you are required to know where your license is and who governs the rules and regulations concerning your profession as a Tennessee licensee?
Yes, ma'am.
And isn't it true that the persons involved in regard to that fact is the Tennessee Real Estate Commission, and that is where your license was granted?
Yes.
And isn't it also true that as a licensee, as a responsibility, you have a responsibility to make sure your license is current, to make sure that you are not working unlicensed or illegally, which means you have to have a principal broker?
That is correct.
And in August 10th of 2011, you signed documents as a licensee with Region Properties, did you not?
Yes, ma'am, I did.
I'm going to go ahead.
Excellent leading.
I'm going to ask Your Honor at this point, because of this, he's not my client, I'm going to ask that he go ahead and be qualified as an adverse witness so I can continue in the cross.
She called him on direct. That was her choice.
But that doesn't mean he's not an adverse witness.
He is a fact witness.
That
There's
doesn't
no
mean
question.
it doesn't mean he's not an adverse witness.
At this point, I can see why you might think he's an adverse witness, but you did call him. So I'd ask that, at least to begin with, that you refrain from using leading questions and treating him as an adverse witness, because I don't think at this point that the foundation has been established to show that that's what he is.
Thank you. On August 10th, 2011, did you sign a contract for sale of property at 912 Lennox Cove Place?
Yes, ma'am.
Did you sign on the contract on that
Ms.
date?
Ryan, we're asking yes or no questions.
Okay.
I mean, not me, but
Have you ever signed a contract for sale of property? Is that a yes or no question?
Yes, it is.
Then I ask him to be, if I cannot ask that, I ask him to be qualified as an adverse witness. It requires an answer that requires a yes or no answer, Your Honor.
Well, now, I don't mind if you lead up to what you're going to ask him by laying the foundation with a yes or no question. So if you want to ask him if he signed a contract and then ask him to explain the circumstances of that, then I think that would be appropriate.
All right. In August of 2011, where were you working?
With Regent.
Were you working as a licensee or as an assistant with Regents in August of 2011?
The beginning, it was as an affiliate, but as we did research into trying to find out where my status was, I found out that it had not been done according to what we had been trying to do. And that, at that point, I stepped back and took an assistant spot.
So in August of 2011, when you were first working as affiliate, did you have occasion to sign or document any kind of contracts as an affiliate?
Yes.
And did any of these contracts involve any sales of properties in Hickson, Tennessee, or any other place?
Yes.
Did you sign documents at the time, at any time, as an affiliate?
Yes.
Okay. In this present matter, were you given a copy of this complaint when it was filed? Just asking. That's.
I'm not objecting to that one, and neither is he.
Did you get a copy of this complaint when it was filed?
Yes.
What is your understanding of the nature of the complaint as filed?
Please, let's check him up and let it where we can hear.
Yeah. We can't hear you, Mr. Faulkner, and I'm having a little trouble hearing you, believe it or not, Ms. Ryan.
Okay, I'll turn the volume up. Okay, it doesn't work. Okay.
Just turn your volume up, Robin. Use
I
your
did.
outside voice.
I did. Oh, I see. So when you first became associated in August 2011, you were associated as an affiliate? Is that my understanding of what you said earlier?
That was my understanding, yes.
Okay. And as an affiliate, before you discover there's an issue, were there any contracts signed by you as an affiliate?
Before I learned of the issue, I did sign my name on a contract, yes.
Okay. Do you know how many times you signed your name on any kind of documents saying you're an affiliate of Regent Properties?
I do not recall the number. It couldn't have been too many.
Couldn't have been too many?
One or two. I mean, I really don't recall how many.
More than one property involved?
No, ma'am.
Okay. When again, after you discovered there was a problem with your license, did you fill out or have Mr. Cowden fill out a TREC form to list Mr. Cowden and Regent Properties as a new business that where your license is affiliated?
I do not recall filling out a TREC form because of the circumstances of how based around the circumstances of how we came to realize that it wasn't active. The circumstances were, according to my knowledge, while standing in the Greater Chattanooga Association office, I was told it was taken care of.
After you discovered there was a problem, did you make any effort to have Mr. Cowden or you act on your behalf to relist yourself or contact the Tennessee Real Estate Commission to make sure you were listed as a licensee with Mr. Cowden?
Did we fill out a new one? I'm not sure. I know that when I was at GCAR, they told me that if they continued to not respond, that we could file some form to go around it and release myself, and that was the avenue that they were prepared to take at that point.
And did you find or sign some form to do that?
At Greater Chattanooga, yes. But they had Richard Sharp on the phone, and he was supposedly approving the transfer while I was there.
Was Mr. Sharp your broker when you were at American Elite?
No, but I was told I received a phone call from him.
Object to anything Mr. Sharp might have said to him?
Oh, wait a minute.
I just asked if he was his broker.
Okay. I just don't know that hearsay objection, when you call this guy, is going to be very well received.
Well, then I again would like to have him be an adverse witness.
All right, can you explain to me why he's an adverse witness?
Because he is a licensee, Your Honor, who has lost his license and had a complaint opened against him as a result of all these actions, and his license expired, and he is here basically because of the actions he had involved with Mr. Cowden. And I am trying to ascertain the truth of any of these, and so I'd like to be able to answer yes or no. If I can, I'll just show him the documents and ask if he can explain them, and that's fine with me too.
Yes. If you
Mr.
talk
Ayers.
into the microphone.
Yes, I will. I'm having trouble seeing how he's being difficult. I really am. He's answering the questions in a very polite manner, and he's not refusing to answer anything. In fact, instead of even beating around the bush and answering in circular ways, he's responding directly to whatever question is asked. I think that he's not adverse right now. He's a fact witness, and to the extent she wanted to call him on direct, he's answering and he's doing what he's supposed to do.
So what about these yes and no questions?
I object to them all along. I object some of these. I'm not going to sit up and object every time, and I know every question is going there. At the same time, it's hard for us to proceed if I'm going to stand up and object to every question. I think some of these are obviously more important than others, But I would love for this to be asked in a manner that's direct examination instead of cross-examination and being treated as an adverse witness.
And
I think that's correct.
I'll redo it, Your Honor. I'll ask him to look at these documents himself.
All right, since you called him, I think, and I can't really clearly see now how he's an adverse witness. Now, it may become apparent after you ask him these questions that he is, and then we'll revisit this ruling. Yes.
Tell me what that document is and if your name is, and the relevance of that document?
This is the compensation agreement between listing and selling broker. And at this point, I am listed as the affiliate under Regent Properties, and it is dated 8/19/2011.
Now, if the commission has this document, could you perhaps reference it by exhibit number?
They do not have this.
Oh, okay, I'm sorry, go ahead.
What's the date on that document?
8/19.
8/19 of what year?
Probably 14, I'm not sure. 8/14, 8/19, 2011.
2011, okay. And I'm going to ask you if you could identify this document.
And
Purchase
Mr.
and
Harris,
sale agreement.
if you're wanting to see any of these before...
This is all in
they're-
the exhibit number.
Will you tell me the title? Will
Yes.
you tell me, please, the title of that last document you were referencing? I know I have it here. I just wanna make-
Compensation between listing and selling broker.
It's provided by you.
I would like to see it. I'm sure I did provide it. I just want to know which one it is.
Sure.
And
State the title of that document you have in front of you.
This is the purchase and sale agreement.
The purchase and sale agreement between who and who?
Alan Thomas and the estate of Ruby Smith.
And would you turn to the last page and see who might have signed as the licensee on that document?
I did.
And what firm did you say you were affiliated with when you signed these documents?
Regent Properties.
And had you filed the Trek 1 form to change your affiliation from American Elite to Regent at this time?
I
Had you
had.
signed a form?
Wait, let's
Okay.
let him
Okay.
respond. You said
Yes.
you had, so
Yes, I had.
explain that to us.
At this point, I am a new licensee when this is happening. My understanding of the broker is to make sure that the licensees do things and they are a mentor of sorts to the agents. When I was trying to transfer to Regent Properties, I approached Vicki Sane, the then broker, and told her. She multiple times refers to me as her meal ticket because she was also the owner of the mortgage company, so on and so forth. She didn't want me to leave, and she asked me not to. But when I asked her, I said I was going to, she said, okay, well, you need to have whoever you're going to transfer to, have them sign this, you sign it, bring it to me, I'll sign it, and we'll do it. So that's the process I took. I took it to Mr. Cowden, he signed it. Then I took it to her office. I signed it on the spot and gave it to her. She was in a rush to get out, and because, well, she wasn't in a rush until I asked her about how she took my dues that she didn't pay for. But
I'm sorry, I didn't hear that last part.
she deducted my real estate dues out of a check, but then never paid them. I later found out. But I was asking her about that, and that's when she was in a hurry. She took the form and said, I'll sign this, get it taken care of, and so on and so forth. Under my understanding, since he had signed it, I had signed it, and she was taking it to sign it and send it, I was under the impression that the transfer had taken place and was in process. There was a lull when I didn't do any business because I didn't know what the circumstances were as far as how long I had to wait, what had to come in, because I know that once you pass your test, you didn't have to get your number or your card back as long as you got your. I mean, I didn't know, but Vicki abandoned the office and moved to South Alabama, and left the office in disarray. So when I was trying to contact my broker and say, can you please tell me what is going on with this transfer, I was met with resistance on every end, and I called over and over and over again, showed up at her office over and over and over again, went to GCAR over and over and over again. When I was saying I went back to GCAR and they called Richard Sharp, the reason they did that is because as soon as I walked in the door, they knew I was there because I kept coming in saying, what the heck is taking so long? I just want to get my transfer done. And they kept seeing me come in there. They kept seeing my efforts, but Vicki never did it. She left the office in disarray, and that's why all the agents just kind of scattered. And so as a new licensee, I thought that I'd done what I was supposed to do because my then broker told me that it was taken care of. It wasn't until months after that when I started to get other clients coming in and I wanted to pick back up with it that we started noticing something's not right. So we started trying and hunting it down again. That's when I called Vicki again, no response. And then finally, Richard Sharp comes down to Chattanooga, calls me, and now all of a sudden he tells me, well, I'm going to take over American Elite, and Vicki's still in it. And I'm a new licensee. I don't know what all that means. And I said, listen, Mr. Sharp, I've been trying since March and April to transfer to Regent. He said, well, we don't want you to go.
Your Honor, I mean, I realize he's my witness, but I don't have any idea what he's saying. And he is talking about hearsay of somebody I do not have for. I know that Mr. Sharp has been subpoenaed, but he's not here.
These are my specific actions trying. I'm trying to show I made ample efforts as best I knew how within the Code of Ethics and what I was supposed to do. I made every effort to get that taken care of.
Mr. Harris?
Can I respond, please, to the hearsay objection? This is presented not necessarily for the truth of the matter asserted. To the extent he was informed of this and he based his actions on it, then that is what this is presented for. He's not here to testify that he actually owned American Elite. This is just what was represented to him, and actions were taken based on the information given.
So you're saying that this shows his motivation and his reason for acting?
Right, and his understanding of what was going on.
So it doesn't matter if it's true or not?
I think it does matter that it's true, obviously, but I think when it comes to this discussion, this specific discussion, I think it falls within the hearsay objection.
All right, I am going to overrule that objection. Now, Ms. Ryan, if you believe your witness is going far afield, then you can certainly stop him and redirect his testimony in the way that you wish it to go. And then Mr. Harris can, when he does his cross, he can bring out whatever else he wishes.
Thank you. Then let me ask you this, Mr. Faulkner.
Closer to the mic.
Let me ask you this, Mr. Faulkner. When did you go to Mr. Cowden as your new broker, and apparently the person is supposed to be overseeing you and leading you as a new licensee? When did you go to him and say, we need to address this because it's not been resolved?
It was within the first 2 weeks of August.
Within the first 2 weeks of August. And when then did Mr. Cowden, as your new principal broker, file anything with the state of Tennessee showing that you are now an affiliate with him?
I don't know that he did, because at that time I signed away my responsibility and said, this hasn't been taken care of, so I'm walking away. And at that point, Mr. Cowden took over the entire file, because I don't know what the heck I'm doing with all that. So if there's a problem with my license, I didn't want to take part in it. So I rescinded all my responsibilities to the file.
I'm going to show you a document and ask if you can show me on this document where you and or Mr. Cowden has signed a TREC form. This is the TREC form that was filed. Can you show me your signature and Mr. Cowden's signature on that document?
It's not on here, but this is only one of 4 that went out.
And what's the date of this one?
Vicki Sane signed it on 4/15/11, but it was
And
approved.
and the date at the top?
July 22nd.
And could you open up the second page? What's the date on the top of that letter?
July 22nd.
And when did you first sign, as you said earlier, what's the first date on these contracts that you signed?
8/10.
And did you sign anything after 8/10? Or are there any documents in here that show dates after 8/10? Could you look for me?
I will look, but I didn't get this letter. That's the wrong address. First glance, I don't, but
Document you referred to earlier, the compensation agreement, you said that was 8/19, is that right?
14, 19 is one of the.
14.
14 or 19, I don't know.
Notes that you took for today?
No, these are just things that I was going through.
And why are they up here? Are you referring to these notes?
Microphone.
I just have them here. I mean, it's been sitting just like this with this stuff over top of it. I mean, anyone can.
Your Honor. I do have a problem with this being open in front of him because it's relevant to, I cannot tell what it is, but I do see references to issues here today in this notebook.
I'll be more than happy to show it.
I just
had back surgery, and I remember things based on timelines. I write it down. There's no timeline here. You are more than welcome. Anyone can.
So you're objecting to his reference to notes when he didn't let you know that he was
Yes.
going to be.
That's correct.
All right. Do you want to look at it?
Yep.
Mr. Faulkner, is that okay with you? Mr. Harris?
If he took them up there, yes, I'm okay with that.
I fear about original tract form having change of address. What is that from?
Microphone.
That note you have in there that says original tract form has change of address, what is that in reference to?
That is just in reference to, I was trying to think back to how many different tract forms I gave to Vicki. And so I was going through my mind, trying to go back and recount each event. The very first tract form that I took to her, that Mr. Cowden and I had signed, when I showed it to her, she was going to do it, and she said, well, you know you got to change your address. I said, yes, ma'am. She goes, you can do it on this form. So I wrote it on there, and that's the one that she took. And then, I mean, that's all that's on there. I'm just going back trying to recount each time I took it to her.
Could you show me that document that you just have here?
This
That
one here? Yes, ma'am.
And you're talking about change of address for your new firm? What change of address are you referring to that's in this tract form?
She told me that there had to be a form signed to transfer my personal residence.
And when did you file that with the Tennessee Real Estate Commission?
That was with the tract forms, because she was the one that told me that I needed to file that.
Did you take the broker's exam, Mr. Faulkner? Do you realize your responsibility as a licensee? I'm just asking.
Yes, as a licensee.
Okay. What did Mr. Cowden say he was going to do as a result of the problems getting your license transferred to his firm?
At the point that we found out there was an issue, the plan was for him to take over files, and then in the event that I wanted to continue the real estate, we would do whatever we needed to do to get the license activated. But at that point, I also have a mortgage company. It was a refi boom, and it wasn't needed for me to. I didn't have time for real estate, and so all real estate files were handed over, and I went back to mortgages.
When you first met with Mr. Cowden, when you went over to Regent, what information did he get from you to make sure you were currently licensed at the time and able to act as a licensee?
When I first went over there,
Uh-huh.
when I first started talking to him about it, it was
When you went to
first quarter of 2011, and I was active.
When you the first day you were in the office, or were planning to be in the office of Regent, what information did Mr. Cowden get from you to be sure that you were currently licensed and able to work at that point in time?
I would assume he got my license number. I don't know what exactly he got, but he told me that we needed to, in order for me to come over there, we needed to fill out a TREC form, which is what we did.
I have nothing further.
Mr. Harris.
You just testified you also have a mortgage business, is
Yes,
that
sir.
correct? So after you realized or learned of this problem with your license, did you ever fill out a TREC form to try to have anything reinstated?
No, sir.
No. And you made that decision because you weren't interested in having your license reinstated at that time?
Correct.
So it wasn't some willful attempt to, leave things hanging out there and not taking appropriate measures to have things reinstated. That just wasn't your intent at that time.
Correct. At that time, the refi boom was going, and I didn't have time to do
Now,
both.
There was testimony with regard to prior TREC forms. Did you say there were 3 TREC forms?
I remember 3 TREC forms, yes.
The original form, that there was a form provided, I believe it's up there, Exhibit 1. Do you have that?
I don't have any others.
Okay. Let me bring you a copy. Just provided Mr. Faulkner a copy of what I believe is Exhibit 1. The document I did give him has not only the form on the top, it also has the letter underneath. And I'm not sure if they were introduced together, the June 20 or July 22 letter. So Mr. Faulkner, that specific form, did you give that to Ms. Sane?
This specific one?
Right.
I did not give this one to Miss Sane.
Were you aware that that document was ever signed?
No. No,
Were
sir.
you aware that that document was ever sent in?
No, sir.
Did Ms. Sane ever tell you she was refusing to transfer you? Instead, she was going to release you?
No, sir. Yeah, that's correct. She released me with best wishes.
But then did you have discussions with her and she agreed to transfer you
Yes.
to Regent?
Yes.
Was it your understanding then that you went to, the first time you took a transfer form to her, did she agree to sign it and turn it in?
Yes, sir. And it was fully executed by me and Frank.
And that's the document that you had the change of address on?
That's correct.
Now, I think we probably missed some of that last answer that may be important. He asked you if it was signed, and you said it was fully executed by me and...
I guess I shouldn't have used fully executed. The first TREC form that I provided Miss Sane, I had signed Mr. Cowan had signed, and then I also had C, change of home address of licensee. I also had that marked with my address being changed. And so the first one that I provided, Ms. Sane, had all that stuff, just needed her signature and to be sent. And I was assured that it was being done and they would drop it off that day.
And when was that?
Yes, ma'am. This was early, probably April.
Were you aware that there is a legal requirement for the prior broker to make a submission of that document to the commission?
Yes.
Were you relying on that requirement when you provided her that form?
I had understood that it had taken place because that's the information that she gave me.
Did you then go to Ms. Sane a second time?
Yes.
Did you take a TREC form to her at that time as well?
Yes.
Who had signed that TREC form?
The second one that I took to her, I believe that I know I had signed it. I believe Frank had signed it as well. There were two that happened really close together, back to back, and one of them, Mr. Cowden had not signed. I took it over there because she was supposed to be there, and she wasn't. I was going to get her to sign it and then bring it back to Frank so we can make sure it got done this time. But I believe the second time was signed by us, both. But I'm not going to, I don't remember honestly.
When you went to American Elite, where she was a broker, you believe you had you don't recall whether Mr. Cowden
The
signed
first
that
time was the only time that I saw her in person. The second time, left it on the desk. She was going to be right back. I waited for over an hour and a half. She never showed up. The third time, when I brought one that wasn't signed by Mr. Cowden, I brought another one, and I had emailed her and set up a scheduled meeting for me to get that one signed, and she no-showed again. That was when she disappeared to Alabama, and no one heard from her again.
Was she still working at as a broker out of that office?
She was
at that
still the
time?
broker of record, and I called GCAR and said, I don't know the rules on this, but I understand brokers can't live more than 50 miles away. I don't know what to do. My broker's gone. And they said they would look into it.
And had you had conversations with GCAR during this period of time from, April to July? Is that?
Yes, sir.
How many times had you had discussions with GCAR?
Between phone calls and stopping in, it was, if it wasn't double digits, it was close.
Was it your understanding that they had access to the same information, to the access, the licensure information for the commission?
It was my understanding that that's where, since we were in Chattanooga, that's where we needed to handle the documentation. Everything, when I was able to speak to Miss Sane, everything that had to do with forms, she would always say GCAR, GCAR, GCAR. So in my mind, I thought that was where all this was supposed to take place.
And then at some point you came into contact with Mr. Sharp, is that correct?
Yes.
And did you contact Mr. Sharp?
He contacted me the first time.
And where were you when that occurred?
When that occurred, I was on the road. He had showed up at the GCAR saying that he was taking over the office. I was called by GCAR saying.
Whoa, let's wait here.
Well, again, a big part of the issue in this whole matter is the understanding that Mr. Faulkner had about what was going on. So to the extent that he's receiving calls saying, I'm taking care of all this, that explains what's happening in this entire case. So I do think this is hearsay admissible because I don't believe it's, admissible just for the sole purpose of the truth of the matter asserted. These are the representations made to him. To the extent he's accepting these, I mean, he's relying on representations made.
Well, I do think in the form of the question that you ask that it is hearsay. So I'm going to sustain the objection. Now, if you want to ask questions about what his understanding was based on communications with this Chattanooga agency, I'm not sure there's a whole lot of difference there, but I would be inclined to allow that.
Based upon your first contact from Mr. Sharp, what was your understanding of what needed to be done?
My understanding of what was being done, and just so it wasn't Mr. Sharp on the phone, it was one of the workers there. My understanding was that he was there to take over full ownership, and
I'm going to object to that too, Your Honor. What is the issue today is really not what Mr. Faulkner understood and what Mr. Faulkner did or didn't do. That is not the issue before this commission at all. So it's not relevant. The relevance is what Mr. Cowden did or didn't do.
Right, but his actions were based on representations that Mr. Faulkner made to him.
That's right, but our issue in that is that he has a responsibility separate regardless of what Mr. Faulkner did or didn't do.
That may be true, but he's not the subject of our hearing today.
Right, he's not.
So I think as far as what he understood that he was supposed to do, whether that was a valid understanding or not, and to the extent that Mr. Cowden relied on that, I think that's an important issue to explore. So I don't want to go too far down this road, but I would like to ask, if you would ask, remind us again who Mr. Sharp is.
Mr. Sharp was Mr. Sharp, the individual you understood was taking over American Elite.
Right, yes. Prior to that phone call, he was co-owner in the mortgage company with Vicky, and that was my only run-in with him.
Into the microphone and clearly.
Oh, sorry. Prior to the phone conversation that I received from GCAR, with him present, my only run-ins with Mr. Sharp were he was a part owner in the mortgage company that I worked with as well. Him and Vicky Sane both owned the mortgage company, and they both owned, or she owned the real estate company, and this phone call was saying he was taking over that, and he asked me if I would stay. He wanted me to stay. And when I told him I've been trying for months, he said, okay, well then we'll just go ahead and transfer it. And this is while he was there, and I heard everybody in the background at the bookstore.
Well,
and
again,
GCAR.
what you heard somebody else say,
Sure.
somebody who's not a party to this
Right.
action, it can be hearsay. If you're offering it to prove that that's what happened. So I would caution you not to say what somebody else said. Again, you can talk about your actions based on your understanding, your actions particularly as related to Mr. Cowden, because your license isn't at issue today. There's no discipline that's going to be imposed on you as a result of this proceeding today. So we're here about Mr. Cowden. So that's mainly what the commission wants to know about.
Okay.
And just for the record, I did subpoena Mr. Sharp. I was actually contacted by Mr. Sharp, who told me he had a significant fall last Thursday and would be unable to attend this hearing for that very reason. But I did have him personally served with a subpoena. So Mr. Sharp was previously, you had met Mr. Sharp before,
Yes, sir.
and he had been affiliated with the businesses that you were involved in. You can
Yes, sir.
speak. This wasn't somebody you had never heard of or met before.
That's correct.
Did you see Mr. Sharp at the American Elite building at any point after this?
I did not.
Did you ever send Mr. Sharp a copy of the forms necessary for your transfer?
I did not personally know.
It was your understanding, though, that the transfer had occurred.
Yes, based on what I was told, I thought it was taken care of.
And when do you believe that?
Excuse me. Did we say a date for this, when this was? Because I'm having trouble understanding when this all occurred. Do you have a date for that?
Well, I think maybe that's for Cross.
Okay.
So let's hold off
Okay.
just a minute.
Can you give us a rough timeline of when these events took place? When do you believe you first discussed the transfer with Miss Sane?
I first discussed the transfer with Miss Sane in very late March, early April, and that was when I gave her the TREC form for the first time.
Were you having discussions with Mr. Cowden at that time about transferring?
Yes.
And the second time you provided her this, when you provided her the signed forms, I believe, was that the second occasion that it was signed by you and Mr. Cowden?
Both first
times.
and second.
And so the first time you provided her the documentation was approximately when?
That would have been in April. And I had 3 different transactions going, and I left them with her because in the transfer, I knew I couldn't, do anything. So it was just a clean break.
And you didn't retain a copy of these documents?
No, sir.
But you did provide them to her?
Yes.
The second time you took her the form signed, when did that occur?
The second time, I would say it was probably in May-ish. It was very, very difficult to get her. I had emailed her multiple times about it and never got a response, called multiple times, called her husband, never got a response. So after about 2 weeks of delivering the first one, I kept trying to get information, but I wasn't getting any answers, and so I was trying to give her time to do it. But I would say it'd probably be in May.
So then when Mr. Sharp got involved, did you think your problems had been resolved?
Absolutely.
Did you think that...
I was told directly they were.
And did you think that since Miss Sane was no longer involved, that it was going to expedite and make this process work?
Yes.
Was that? And when was your understanding that those forms on that occasion were submitted? What date, or generally?
This was towards the end of June, early July.
And thereafter,
Somewhere.
At that point, did you have any contracts?
No.
Or at
Well,
least,
I had some, but I'd already relinquished those to American Elite.
you relinquished them because of your understanding the transfer was taking place?
My understanding of transferring the listings stay with the broker unless they decide that they want to release them to you. I was just ready to. She had abandoned the office, and I just wanted a clean start at Regent.
After you understood these forms were submitted, did you continue to check back to determine whether or not your license had been switched over?
Multiple times.
And so were you checking your licensure status? You were checking your status to determine whether
Yes.
the transfer had taken place. And when did you really decide something immediately needed to be done? What?
I realized something needed to be done when I received the phone call from GCAR and Mr. Sharp, and they were still asking me the questions that Vicki had asked me in April. Well, are you sure you want to leave? We want you to stay. At that point, I was like, it was obvious that she hadn't done anything, and went to Frank. Is like, I don't know what's happened in the past few months. But it was at that point when I received the phone call from GCAR, that was when I realized she hadn't filed a single thing.
Yeah, I hate to interrupt here because I know this is, you got your flow going. However, we've had a request for a break. So if you have several more questions, then maybe we could take it now. Or if you have just like one or two.
Why don't we go ahead and take the break?
All right.
I'm comfortable with that.
All right, let's make it a 9-minute break.
9 minutes. All right.
All right, Your Honor.
All right, I think we're ready to take up again. Mr. Faulkner, we're in cross-examination with Mr. Harris.
I want to note, Commissioner Bloom.
Oh, I did, thank you. For the record, I would like to say that Commissioner Gary Bloom has been called away and has had to leave the hearing, so he is no longer present and will not participate in the deliberations. However, Commissioner Grease, do you still have a quorum? Okay, we do.
So, at what time did you think your license was transferred by Mr. Sharp?
It was right around that late June, early mid-July is when I got the phone call, and I was told it was taken care of that day.
And where did you reside at that time?
Well,
let me
1024 Falcon Run, I believe.
Did you reside at 1924 Presswood?
He asked and answered that already, Your Honor. He already said where he resided.
Overruled.
In 2011, I did not live at Presswood. No, sir.
Did you receive a letter dated July 22nd, 2011, informing you that you had been released
No,
by
sir.
your broker? Were you aware that that had occurred at
No,
that
sir.
time? Did you believe that you still had a license? You were appropriately licensed at the time you began discussing the property at issue and the transaction at issue in this case?
Yes, sir.
And is that what you told Mr. Cowden as well?
Yes, sir.
And prior to that time, if you were looking online, prior to the July 22nd, did you ever look online and you talked to GCAR, didn't you, to see if you were licensed?
I looked on online initially after the first one, but after that, it was just stopping by and calling GCAR.
Your Honor, would you ask him to restate his question?
All right, can you say that again?
Trying to remember what I said.
Two questions.
Asked, I believe my question was, frankly, I believe it was, what did you find out? I can't recall. I'm sorry.
I think it was.
Can we ask the court reporter to restate that?
I try not to do that.
I know, but If he really wants to hear it.
If Mr. Faulkner recalls, he might have a better memory than me. I was flipping through the papers at the time, preparing for the next question.
So,
It was.
Madam Court Reporter, can you read back that last question from Mr. Harris?
Did you ever look online and you?
Right. I don't know that that was clear. Did you ever look online and did you talk to G-Card to see if you were licensed?
Yes, that was the question. And in the early stages, right after I gave Miss Sane the first one, I did check online. But after that, I kept calling G-Card to find out, and they were extremely nice and pleasant. So from then on, if I needed to know, I would call them or just run down there because it was very convenient. It was my understanding that they had direct access to that information, and so that would be sufficient.
You didn't receive any commission from this transaction, did you?
Yes, sir.
Verbal answer?
I'm sorry?
If you'd give a verbal answer?
Oh, no, sir.
And at the time the purchase and sale agreement was executed, was it your understanding that you were still licensed?
Yes, sir.
Was that the representation you were making to Mr. Cowden?
Yes, sir.
And that was based on information provided to you by your prior brokers?
Yes. Whenever I did get the new client, Mr. Cowden was persistent on me getting him the license. I mean, he would ask me on a daily basis if we'd gotten anything from Vicky or heard anything, or if I'd gotten anything in the mail.
So at the time that you believed your license was forthcoming, didn't you?
Yeah, I was waiting on it in the mail because it was my understanding that we had sent the transfer off, and the next step was to actually receive it, to hang it in Regent's office. So, we were waiting for my license to be able to hang in Regent Properties office. And, up until that point, I had just assumed that it was a part of the time frame. It was just taking that long. But then when, it was time to write a contract, wanted to make sure. And that's when started inquiring, and which ultimately led to finding out that they hadn't done it, and that's when I relinquished.
What did the Sentinel commercial properties heading on these documents, how did those get there?
The Sentinel, I went on to Tarnet under Regent and was doing a purchase and sale agreement, and when they printed out, they had the Sentinel on there. At this point in time, those documents, I can't remember if it was when Mr. Cowden had heart surgery or his arm or something, but he wasn't there that day, and Mr. Thomas was. And for me, being in the mortgage business and being around this for the past 10 years, there's all kinds of mortgage companies that, it's Gateway Mortgage, but they operate under a DBA. So when I saw Sentinel Properties, but it was under Regent's Tarnet account, I just assumed that was standard practice because there's a lot of times where you see, at the top of the contract, it's got this team name, not the. So when I saw Sentinel, I just thought it might be a DBA because that was normal to me. I see it all the time.
There was a notification presented to this court. I believe it was part of Exhibit 3. Is that correct? It is the document whereby the buyer notified the seller of the change in the mortgage loan status, of the change in Mr. Faulkner's position. And I apologize, I don't have which exhibit number that is in right here in front of me.
I think it must be 2, because I
That-
don't see it in 3, but I'm still. Okay.
I apologize. I approached Mr. Faulkner so he can take a look at this document.
Okay.
You tell this commission what that document is.
This is the standard notification form that is published by Tennessee Association of Realtors, notifying of any changes to the file.
Was that notification sent to the agent for the seller?
Yes, sir.
And how did you send that to him? Or did you send that to them?
I did send it. I do not recall if it was fax or email, but I'm 90% sure it probably would have been email, but it could have been fax. I'm not sure.
Was your client aware of this transition, is Mr. Miller?
Yes.
And at closing, did the seller obtain knowledge of this as well, or even prior to closing?
I don't know if the seller did. They should have, because it was provided to their agent.
I think at this time, Your Honor, I have no further questions.
All right, I'll let you do redirect, but I think it might move things faster along if we go ahead and let the commission ask questions, and then I will let you, so then you all can respond to concerns that the commission may express.
Members of the commission, Mr. Alexander.
I do too.
Mr. Ferguson, when were you first
Faulkner.
licensed? Faulkner. When were you licensed first?
To be
Okay.
honest,
Was it
I
11,
don't
12,
know.
13?
I would say it was probably in 2010.
Did you go to work for American Elite?
Immediately.
What about 4/15/2011? That's all right. It's in material at this point. If I asked you what TREC meant, what would you say?
TREC,
Yeah.
Tennessee Real Estate Commission.
Okay. If I asked you what TAR, what would you say?
Tennessee Association of Realtors.
Which one governs the license?
Tennessee Real Estate Commission, I believe.
No. I believe you stated that American Elite Realty, the broker there, didn't pay your dues. Is that correct?
That is correct.
Then why should they have any responsibility of telling you anything if you're not even if you're not a member of that association? If you don't pay your dues, you're not a member.
Right.
Is that right?
That's correct.
So you didn't pay your dues.
I had not paid the dues when I had a closing. Miss Saint asked me, she goes, I've got to pay mine. Do you just want me to go ahead and pay it, and I'll take it out of the check? And I said yes.
Now, who agreed, that we've talked about the transfer form, track 1, transferring to Mr. Cowan.
Yes, sir.
Who was going to pay the transfer fee?
I fully intended to pay whatever fees were associated with it.
Well, who'd you give the check to? If you carried the check carried the Trek 1 form back to Mia Swain, did you carry her a check? Did you expect her
I
to
did. I did not give her a check. No.
Huh?
I did not give her a check. Not that I remember.
Were you aware that it took $25 to transfer to Mr. Cowan's firm?
I did know there was a fee, but generally the way, ever since I started with Vicky Sane, anytime there were anything like that, she would always take it out of checks, and I had some more coming in.
But you wasn't an agent for her. You were trying to get broker release. You were trying to get a Trek 1 form to go to work for Mr. Cowan, were you not?
Yes, sir.
Why didn't Mr. Cowan or you one write a check?
The reason that I mean, I can't speak for him, but the reason that I did not give her a check is because prior to signing the Trek 1 to go to Mr. Cowden, I'd had some deals that were completing, and
You wasn't responsible to do that. You were gone. When the Trek 1 sign was signed, you were gone.
this was before that.
Well, why would you expect her to take it out of your commission? That's her responsibility.
I mean, that was probably oversight on my part, but I'd worked with the lady for 10 years, and I trusted her.
10 years as a what?
Mortgage.
Oh, okay. All right. Now, did you alluded a while ago that Mr. Cowan had heart surgery? Was that right?
Yes.
Do you know when it was?
I do not.
Did he ever look at these contracts when you signed them, got them signed for the purchase agreement? Did you carry them to him, and did he review them?
Not initially, no, sir.
So you got the contract signed by the purchaser,
Yes, sir.
and then you sent them on to the listing broker. It never passed through him. He never saw them. He never laid eyes on them.
Initially, no, sir.
Huh?
Initially, no, sir.
Okay. Now, when did you get subpoenaed to testify?
I received the subpoena to testify, I believe I got an email Monday.
Monday.
Yes, sir.
This past Monday. Is that right, Ms. Ryan?
You can't ask her that.
Okay.
Sorry.
I'm just trying, Your Honor. Everybody's gone around in a circle today.
I know it.
That you know what, we've heard the same repetitive question every time, and every one I've asked has been different. At this point, I'm not going to have them. I'm going to let somebody else.
I have.
Ms. Haynes and Mr. Charo.
To get your license, did you have to get educated? Did you take some educational
Yes, ma'am.
courses? And do you know how many hours you had? And what those courses were? And or if you don't, where did you take those courses?
I took the courses at Trees.
At Trees?
Yes, ma'am.
Okay. And did at any time the Chattanooga Association tell you that there was a difference between realtors and the Tennessee Association of Realtors and TREC, Tennessee Real Estate Commission?
I had found that out at some point, but it wasn't whenever I passed and officially, graduated the class, I did not know at that point in time.
So when you went to the Chattanooga Association, what made you believe? Did you believe that they were actually taking care of your transfer, or
Yes,
were
ma'am.
they just advising you how to do it?
For me personally, I was acting off what I had known to be true, and that was probably completely my fault. In the mortgage world, there's a governing entity, but when you want to get something done, you go to your local one. And so I just thought real estate was the same. You know, there's the banking and finance division, but if I need something done, you know, I can go to the local one. And so I thought that the GCAR was directly linked to TREC and that their systems were meshed.
They were meshed, and nobody ever told you different
No, ma'am.
at any time? You never heard that there was any,
The-
that you can remember? I know you may have heard it,
Right.
but when you were working with the Chattanooga Association, nobody ever told you that they were not meshed?
No, ma'am. Every question I asked, they would say, let me pull this up in the computer. And then they would turn around and say, okay, here's where you paid these dues. Here's, because I was asking about the dues as well, because they said it wasn't paid. And I told them about Vicky. And they said, well, she didn't pay hers either, so on and so forth. That's when I informed them that she had abandoned. So
I think what...
I felt they were handling all of this.
Well, I think what Mr. Alexander was trying to say is that your association and your association dues is totally different from the state of Tennessee. That is a voluntary organization in which you choose to join.
Right.
So what they were talking about was totally different, and that's where I'm concerned, is that you were never told that TREC was different from the Chattanooga Association. And apparently you still don't understand.
Well, I knew there were two different fees, and it's been a while. I think one of the fees was somewhere around $800, and one was somewhere around $400. I knew that there were two set of fees, but then again, with the mortgages, there's a bunch of fees split up.
Apparently you still don't really get that there is one is just a volunteer organization.
Right.
You volunteer
I understand that now that I understand that I can be involved with TREC but not GCAR.
Well, the state of Tennessee is where your license is housed and taken care of. So nobody in Chattanooga ever, when you were talking with them all these times, or
when I was
brokers,
in GCAR, no, ma'am, they did not say that.
Let her finish the question before you answer.
Sorry.
or any of your brokers ever explain this, because there's been several brokers apparently involved, ever explain that they were two different entities totally?
No, ma'am.
Okay.
Thank you, Ms. Haynes. Mr. Charo.
Okay, I am looking at the offer to purchase that you wrote in August, and you said that you went into transaction desk and pulled these forms up and printed them out.
Yes, ma'am.
Whose password did you use to get into transaction desk?
I was understanding that it was just the offices.
Well, the office doesn't have one. It's two individual agents. Whose key did you use to get into the property?
I don't think when I didn't go show I did not show Mr. Thomas the property. He viewed the property in an open house and came straight to me to want to write the contract.
So in the super log that we were given, where the property was opened by Mr. Cowden's key, you did not do that?
What was the date on that? Because I'm not sure. It might have been during an inspection, and
Well, there were several dates that the property was open with Mr. Cowden's key. But I don't see at any time where a key was used by you to get into the property. So you never viewed the property, you never went inside the property?
I was able to get inside the property. The whole development was being developed at one time, and so pretty much all the doors were left unlocked as a walk-in.
So on August 10th, which is when this contract was written, and the property was shown, you were not the showing agent?
I very well could have been. I mean, before we wrote the contract, Mr. Thomas was the one that went through and saw the property at an open house. I had my super key, and Mr. Cowden had his, and both super keys were sitting on the desk side by side, and I grabbed one. I don't recall. I would assume that if it's on the 10th, then yes, it was. Me.
Super keys have a password to get in that are unique to each individual
Right.
agent. So if you grab Mr. Cowden's key, that means that you also have his passwords to use his key?
No. There was one time that I did not have my key, and Mr. Cowden was on his way, and I asked him, and I was let in. But there was no, here's my key, go do whatever.
And you had a key, a super key, when you were not a member of the Chattanooga Association of Realtors because your dues had not been paid?
Yes, ma'am, I still have my key.
And it was active?
Yes, ma'am. I kept having to call. Every time I would go show a property, it would have that 1-800 something something, and I would call that. And there was one time I called, and this is when the dues issue came up, because Miss Sain had said that she had taken it out to pay the dues, and I was going to show a property, and it wouldn't let me in, and I called the number, and they said that it had been cut because of the dues, and I paid with a credit card on the phone, and they reset my code. They went through and did that re-key whatever, and had that big long 16-digit number. So but it happened every single time, and when I got somebody, they told me that it was because of the dues. That's why I went to Miss Sain and said, why are my dues not paid? I just had to pay them twice. And, she took it out of my check, but didn't pay. And I was extremely frustrated about that.
You are aware that you cannot be a member of an association just by calling into Supra and giving them a credit card number. That doesn't eliminate the problem here that I'm finding.
Right. Yes, I know that the super key doesn't give me any type of memberships, but that's during this whole time that all this was going on. Keep in mind, every attempt that I was trying to make to get clarification on what I needed to do. Like I said, I'd worked for Vicki for almost 10 years, and I was getting no direction on that. And I know Super doesn't have anything to do with the association, but I was still under the assumption that the association, everything was taken care of. So, I was still a part of GCAR, but she didn't pay my super dues either. I don't know if that makes any sense, but
Well, you're not a member of anybody if you don't pay your dues.
right. Yeah, I fully understand that, and I've been trying to find the paycheck stub where she even wrote on my paycheck stub where she deducted it for the dues, but it's been years, so I don't have it.
Okay.
Collins.
On this log, I don't see where you ever showed the house. It was Frank, and then Frank was supposed to have been in the hospital, is that right?
He was in the hospital, but I have no idea what the dates
It's got
were.
a date here of 9/28 on 29 on that house, and apparently you used his key then. So what you're saying?
It could be that date. I don't know what dates he was in the hospital, but I don't know if.
Were you employed by him at that time?
And what was the date?
Or are you employed? When are you still employed by him?
No, sir.
Oh, okay. But you were at that time.
Yeah. Well, what month are you talking about?
The time of the sale.
Yes.
Okay.
It was my understanding that I was an affiliate. I was an affiliate under Regent Properties, and then when the second communication with where I went to GCAR and they called Richard Sharp. The first time he was there and they called me. The second time I was there, they called him. That was when I realized it's hit the fan. I don't need to be a part of any real estate transactions until this gets solved.
You know you can fax the form in to transfer you and just send the money a day later, don't you?
No, sir.
Okay.
Mr. Flitcroft.
On the second notification form, since that time when you were assigned the real estate status to Mr. Cowden, what did you do for Regions from that time forward?
The second notification where,
Yeah, from the date of that second notification, what did you do after that time for Regions?
from then on, it was very, very minimal. Maybe answer a few phone calls, do any type of, emails, or just answer calls. Hey, how's the stuff going? After the second notification, I began to take the mortgage roll again. So, when Mr. Thomas would call and ask questions about his loan, I would answer those. But I wasn't doing anything as far as the real estate. At that point, I was acting as a mortgage broker.
Did you attend the closing?
Yes, sir.
How
And I attended as the lender loan officer.
was the check to the real estate firm made out?
That
Or do you know?
I don't know. I usually don't get those checks. The only reason I was there was to make sure that all the documents were correct and that the funding number was given.
Mr. Faulkner, just a couple of follow-up questions. Do you recall the day that you wrote this offer?
Yes, for the most part.
Was it at your office that you wrote it?
It was at my office, yes.
And shortly before that, Mr. Thomas apparently saw the property. That same day, maybe an hour beforehand. Do you recall whether you were present for that showing?
He had seen it a few days before that, but on the day of the contract,
Yes.
I believe we went back over there.
But it was not new construction, correct?
That one was not, but most of the development was.
So I'm just trying, you're not on trial today, I promise you. I'm just trying to understand.
And please don't take, me saying I don't know as
I
trying to
understand. That's
evade
cool.
something.
But we've got a timeline here that indicates the property shown using who you believe to be your principal broker's lockbox about an hour and 20 minutes before the offer was written. And I'm just trying to understand how the sequence worked. You don't think you showed him the property?
Well,
before you
if
wrote it?
that, I know there was one time where I did have to use his key because I grabbed the wrong one. That
Can you recall whether that was just before you wrote the offer?
I don't know. If the house was shown, and I don't see how it couldn't have been me.
Mr. Faulkner, your broker, who you thought was your broker at the time, correct?
Right.
You think it was?
I don't know. I think that there was a time that he was on his way, but I don't recall which is which.
On a second question, I'll be done, and this is neither here nor there, but do you find it odd that you don't have copies of any of these TREC forms? You're in the mortgage business at the same time, and copies are everything. I would think that you
Yes, sir.
might have that. Do you think that you were cavalier at the time and didn't think you need them, or they've been misplaced, or
Which documents are?
those where you believed you were getting a release from your previous broker that you testified a couple of times, you took them to Miss whatever her last name was.
Hussein, yes.
Yeah. No copies, though, as far as you know.
I didn't make a copy. I didn't feel the need to. I thought it was just going to be sent in.
Any other questions from the commission?
I got some more.
Mr. Alexander.
Mr. Ferguson? Faulkner, I'm sorry. I don't know how I got the Ferguson part. Could you have been using the super key from American Elite Realty? Maybe you didn't turn it in. You still got that key? You say you still got it.
I don't have it now, no. No, sir. But
Was it possible, though, that you was using that key?
it is possible. I mean,
Well, that
I had,
didn't apply and get you a key. Your so-called or your thinking broker didn't get you a key.
no, sir, I had my own key, then I thought, I didn't know that I needed to transfer it.
A while ago, you said you'd never been in the house. You never showed the house. Tell me what it was. Was it a condo? Was it it is a family house or where people live?
Well, let me correct something. It's not that I never showed or never went in the house. I was in the house. I have been in the house, but
Never showed Mr. Thomas.
I was there at the house with Mr. Thomas, but for inspections, appraisals, and
But before you wrote the contract, you never showed him the house. Why don't you tell me that the agent for Keller Williams actually had showed Mr. Thomas' house? Did you ask Mr. Thomas had he been working with another agent?
she didn't show him the house. It was an open house. When I talked to Mr. Thomas,
Now, what I read in the complaint and the answer.
it may not be,
My
but that's
my question, just a yes or no. Did you ask him if he'd been working with another agent?
yes,
What did he say?
no.
Okay. Now, what kind of compensation, since you didn't get your track form in and you didn't pay the check for that, what kind of salary were you drawing for this from your new principal broker?
It was just going to be a percentage of the split.
A percent of the split. Don't you know it's illegal to take a person doesn't have a license, illegal to take a split? You told
Right.
me, you said you didn't get paid.
I didn't. The agreement was, as an affiliate, I would get paid. But when we found out that there was an issue, I never received compensation.
So nobody ever told you you didn't need to use a commercial contract on a dwelling?
That was when I was in Tarnet, it was a residential contract, but it had Sentinel Commercial on top of it.
There's commercial property, Sentinel Commercial.
Correct, but that's the heading on the residential contract.
You actually go into this and print this off, or was this laying around the office like the key?
That was
Did you
printed
print
off through Tarnet.
Did you print it?
Yes.
Okay.
Anything else, Mr. Alexander?
Oh, I have a lot, but I won't quit.
Anybody else? Any other further questions from commission? I hear none, Your Honor. Back to you.
I'm gonna wait for the principal broker.
All right. Of course. Go ahead.
You stated earlier that you thought you were licensed in 2010, is that right?
It's just a speculation.
Would it surprise you, I'm just asking, to know that Ms. Maxwell testified earlier from the track record you were actually licensed in April of 2008?
It wouldn't surprise me, no.
So, okay.
You have to understand, I had 2 accidents in 28 days that left me in the hospital for over a month.
In 2008 or 10?
In 2011. A bunch of the stuff before, I'm not trying to be evasive when I say I don't know, but I don't know. I was in the hospital for over a month and I've had multiple back surgeries, and I mean, I don't know. I'm not trying.
Okay, I just wanted to ask, when you said you were a new agent in 2011, I was just trying to clear that up. So, were you a new?
Well, he asked when I was an active agent, and I said I thought it was in 2010.
I know, but you had said you were a new agent, and that was part of the reasons you were doing what you were doing, and I'm just trying to clarify that about when you were a new agent. That's all. Also, you said you checked online the status of your license. Where did you check online the status of your license? What did you check with?
You go into just go into Google and do a real estate license search, and it takes you to the Real Estate Commission's website.
So you checked on the line and didn't it show that there was a problem with your license when you were checking? Didn't it show when you checked that there was a problem with your license when you were doing that checking?
No, ma'am.
Okay. Now,
Like I said before, it was when I initially gave it to Miss Sain, so that was earlier on in the year. This was before all the stuff, all the garbage happened.
well, I'm sorry. I thought you said that after you had problems, you were continuing to check online the status of your license, continue to check online. And I'm not
Ma'am,
really
I
trying to be
didn't.
difficult, but I thought that's what you said.
I did not. I said that I did check online initially, and then from then on, it was convenient to call or stop by GCAR.
And GCAR is the person that held your license and had that information?
Already gone over this. I understand. I mean, you don't sit there and try to make me look like a fool. I did check on the Real Estate Commission's website one time, maybe twice, in the April when I first tried to get transferred from Vicky. As I found out there were issues, the website doesn't fix any issues, and that's when I started going to GCAR. And the fact that I was making so many calls to GCAR and they were pulling stuff up on their computer saying, here's what's happened, here's what's happened, here's what's happened. I didn't know that there was somebody else I needed to be going to, because every time I would ask them a question, they were giving me all this stuff showing me that where I was and what had been happening and all that. If they would have just said, you need to call Tennessee Real Estate Commission, then I would have done that. But every time I inquired with GCAR, they would go through and show everything that they could. So I thought that I was doing the right thing.
And let me just ask a question. During all this problem, you were constantly communicating with Mr. Cowden and asking him as your new broker, what should I do, what should I do? Were you?
Not constantly, no.
Did you?
We did talk about it, but just like it took time for my license to come in, I thought it was a part of if I can't expect for me to file a form on April 21st and know that it's going to get back on April 22nd. There had to be some processing time. So yes, I asked about it, but I wasn't going to sit there and go every single day. I thought we were waiting on the license to come through.
Okay, let me ask another question. You were asked earlier about this revised notification statement where you were asked on Cross, and it says, where the information has been received, discussed regarding the license status of Zach Faulkner, and it's been taken over by broker Frank Cowden. You remember that? You were asked by that from Mr. Harris. When this was filled out, did Mr. Cowden say to you, hey, this is on Sentinel headline, we should make a change or anything?
No, ma'am.
Okay. Well, how about when Mr. Cowden wrote the counteroffer where he is signing it? Did he talk to you about the fact that it was on Sentinel Commercial Properties documents? Did he talk to you and say, hey, this is not appropriate, we need to make a change?
No, ma'am, because I knew that they had a commercial division and a residential division. That was normal to
Asking
me.
you if he talked to you about the fact that it was a sale and it was a form, and did he say, this is not appropriate, we need to change the form? Did you guys talk about that?
We had talked about it, but it was after the fact. When I was doing this notification, no, I did not know that I needed to change that. And
Okay, thank you.
Left American Elite. And Miss Sain?
Can you get closer to
Yes,
him?
I'm sorry.
I'm sorry. I lost my place. I had one more question to ask. I'm very sorry. It was just one more question. What was your salary as an assistant in this time period? How were you getting paid? What was your salary?
I wasn't going to, there wasn't set a salary. As an assistant, when I switched to the assistant role, the idea was get the stuff fixed and then go back to being an agent.
What did you get paid?
I didn't get paid. Mr. Cowden has sent me business before. I didn't need to be paid to help out. He's helped me out. I mean,
You didn't get paid at all this whole time period? You were an assistant, not an agent?
I was an assistant for a very, very short time. I had my own company, my own mortgage company. I didn't need to sit there and have somebody pay me $8 an hour when I'm making $120 an hour doing my own mortgage stuff. What's the point?
Okay.
You were with Miss Zane for 10 years.
Yes.
Part of that time you were handling the mortgage business.
Yes.
Microphone.
I am so sorry. I'm not used to the mics like this. I'm trying. You were with Miss Zane for 10 years.
Yes.
Part of that time, most of that time, you were handling the mortgage business,
That's
right?
correct.
So when the question was asked about 2008, you becoming licensed, during that period of time, was your primary means of support real estate?
No.
Were you really supporting yourself on the mortgage company?
Yes.
So was this more of an aside, essentially?
Absolutely. Just a supplement.
And Ms. Zane, questions were asked about the $25 payment. Did Ms. Zane owe you money?
Ms. Zane owed me a significant amount of money.
In the past, had she paid these amounts of money? Had she made these type of payments, the dues?
For 10 years, everything that she owed, she was good for.
And you knew she owed you a significant sum?
Yes.
So did you expect that amount to be taken out of your check before she sent you the remainder of what was owed to you?
Yeah, $25 is nothing.
How much do you think she owed you?
Right now, she's right around $8,000. Well, plus the bills that I paid for her to keep her open.
And is your 10 years of experience with Miss Zane, is that the reason that you didn't believe it was necessary to maintain copies of all these things?
Yes, I hadn't. Obviously, I had a foolish amount of trust for her.
Had she refused to do things like this for you in the prior 10 years?
No, sir. She had always been very, very compliant. At the time her mother passed away, a bunch of stuff happened. She just hit depression and then she left.
And the only other question is during your questions about how long you were an assistant. The time you were an assistant, it was going to be for the period of time while you were trying to fix your license.
That's what our intent was, but the refi boom happened and I didn't need to go back.
And when you decided not to reinstate your license, is that when you essentially stepped down as an assistant?
Correct.
How long was that?
It was weeks.
Thank you. I've got nothing more.
Commission members, any further questions? Oh, okay. All right. Okay. Then, thank you very much, Mr. Faulkner.
Thank you.
Do we want to release him, or do you think he might be needed for rebuttal?
I do not need him for rebuttal.
Are you sure?
We don't need him for a rebuttal.
Okay, then, Mr. Faulkner, if you'd like to leave, you're welcome to do that. If you'd like to sit in the audience and see the rest of it, as long as nobody recalls you. Nobody can recall you if we're going to let him sit in here. Got it?
Would it be better for me to go outside?
Just in case, Mr. Faulkner, in case I have one or two final questions, would you step
I'm not
outside?
sure whose these are, but these are still up there.
You can leave there.
Thank you again, Mr. Faulkner, and thank you for your patience. So, Mr. Faulkner, you are going to wait outside, right? Yes, ma'am. Okay, good. Further proof from the state.
Your Honor, I would like to call Mr. Cowden as an adverse witness.
Mr. Harris.
If she chooses to call somebody on direct examination, that's her call. Maybe it is her, right now she hasn't even asked him a question to figure out how he's going to respond.
Well, I think it's, now I'm more sympathetic to Mr. Cowden being an adverse witness because you're on opposite sides.
I do. I understand the request completely, but if she makes the determination to call on direct exam, I think that's her determination, knowing that she is asking the questions on direct exam. If she instead has me, ask him questions on direct, then she would have free turn to handle the cross-examination. That's just what I think, but obviously the court can do whatever it sees fit.
Oh, sorry to interrupt you, sir. I believe, according to the witness and exhibit list, she can call him, and I think it's just obvious that he's an adverse witness. So I will, as long as it stays civil and polite, I will allow you to treat him as an adverse witness.
Thank you, Your Honor. I call Mr. Cowden.
Now, before Mr. Cowden gets up there, do you guys want to run in there and get a snack?
Back on, Your Honor.
He's gone. Sorry. All right.
Thank you.
Ms. Ryan.
Would you please state your full name?
Frank Edward Cowden III.
And Mr. Cowden, are you principal broker of Regent Properties?
I have been since 2003 when I opened the company.
2003. So that means you were the principal broker in 2011?
I have been since 2003 when I opened the company.
So the answer is yes.
Yes.
Okay, thank you. And then I guess you were the principal broker in August of 2011 when Mr. Faulkner signed those contracts?
That is correct. I was the broker in August of 2011 when he signed the contracts unaware to me.
And when you signed the counter offer dated, let's see, August the 17th of 2011, were you the principal broker?
Yes.
Okay. I'm going to have you look at this document for me for a minute. That is your signature?
That is how I signed the document that day.
Okay.
Zach was incorrect. I was not in the hospital for my heart. I had actually broken my hand.
Okay, but you did sign it, that document. You signed that?
Yes.
Okay. And at the top of the page of that document, what does it say?
The top of the page of the document, which is a printed TAR form, pre-printed TAR form, it has the logo of an individual who used to work for me.
What does it say?
It says Sentinel Properties, which is...
Okay. It says Sentinel Property. I'm just...
I think you need to let him explain. I mean, you did call him.
I did.
Tad Bromfield worked for Regent Properties. Tad Bromfield worked for Regent Properties for about 4 years as an affiliate broker for him to get his broker's license. I knew he was leaving the whole time. And when he started his new company, Sentinel Properties, I'm not sure what date it was, 2009 or so, he set up the paperwork for his new company while he was still part of my company. Didn't do anything wrong that I know of because TAR is not TREC. So when he set up his forms, it said Sentinel at the top, but I don't use TAR forms because they are not TREC. G-card does not equal TREC. TAR does not equal TREC. And so when Zach printed these forms out and I was getting my hand set, he didn't know that it was not part of or a DBA for Regent Properties because everything else said Regent Properties.
Well,
go ahead.
He didn't know, but you knew.
I wasn't there.
Did you sign that document?
Ma'am,
I'm just asking you. Did you sign that
I
document?
signed that document because it's a pre-printed form from TAR. I don't know how to get it off today. After I graduated from West Point in '85, I'm not a computer expert. I knew this was on there because the way I knew it was on there is Tad, when he left my company, was getting phone calls to his company.
Your Honor, I just asked him if he signed the document, and he's already explained the issues. I
All right,
want to know if
all
he
right.
signed the document.
All right, if
And
you'll
I-
confine your answers to, and you can explain your answers.
Yes, ma'am.
But simply confine your answers to what she's asking.
Yes, ma'am, I've been hearing this all day.
So on that day, did you stop and say, we need to reprint this in proper forms from my company because Sentinel is not a part of Regent?
No, ma'am, I did not, because on this day, Zach was working not as an affiliate agent. After I came back to the office and found out that he had printed forms and signed a contract, I said, "Oh, mister, we don't have your license." And then that's when he's supposed to be working for me. So I said, call T-Rec to find out where your license is. I didn't know that he thought T-Rec was G-Car. That was before my time.
Wait a minute. We're getting a little far afield here.
I'm asking-
She's just asking you about this document. And when your attorney asks you questions, you'll have a chance to explain everything.
Yes, ma'am.
I'm just wondering why on that day when you signed, you didn't have discussion with whoever you thought Mr. Faulkner was, that these are the wrong documents and you need.
I had it beforehand.
Let her finish the question.
And we need to put the documents on the right head because Sentinel is not a part of Regent.
I had the discussion with him beforehand. I did not have it on that day.
But you signed the document.
That's correct.
On the date, the commercial properties notification was signed by Mr. Thomas, wherein it says that you're going to be the principal broker. That date was looks like August 25th, 2011. Were you there August 25th of 2011?
Yes, ma'am. I was there August 25th. I was cleaning up the file to get ready for closing.
Okay, well, let me bring this document and have you show it. Let me show it. Is there a form letterhead on this document?
Sentinel Properties form letterhead is on that document.
Okay, so how come on that day you didn't say, hey, this is not a part of Regent Properties, we need to put this on the proper form?
I had already said that, and Tad was working with the people to get the Sentinel form off there. Regent Properties has never had letterhead on TAR.
Well, wait a minute, my question is, why didn't you stop and have it put on the right document? That's my question.
The TAR forms are not T-Rec forms. Regent Properties has never had letterhead on TAR.
Okay, do you
I don't have a letterhead contract on TAR.
Okay, do you have forms that say notification for Regent Properties? Do you have any forms that deal with purchase and sales agreements that have Regent at the top?
Asked and answered. I think this has been asked and answered thoroughly.
I do not. I
I don't think so. Now, Mr. Alexander had an issue.
I don't understand what kind of contract he's
Oh,
saying by saying-
wait. It's not your
Okay.
turn to ask questions. I'm so
I don't
sorry.
understand him, though.
You what?
You can't understand him. Back off from the mic a little bit.
Yeah, these are kind of scary.
You got a feedback.
You have to be close, but you can't be too close. I know. It's tricky.
It's a happy medium.
Don't worry, I'm about as flustered as you are.
Let me ask that a question again. Do you have forms that have Regent on them for your sales and contracts that you write for buying and selling properties?
No, ma'am. I do not have Regent Properties residential forms from the TAR website.
I didn't ask from the TAR website. I asked if you, Regent Property, have forms for sales of properties, sales and purchases of properties.
The answer is no. The purchase and sale agreements that I write, as say purchase and sale at the top. They don't say any company at the top.
So how come, in this particular day, you didn't say, hey, we need to make the change, that one that says Sentinel Commercial Properties, and take that off and rewrite it on a proper form?
On that day, I had already told him that. we did not need to use these forms. And
You
his,
do it.
Let him finish.
Okay.
I had already told Zach, first of all, that he was no longer to act as an affiliate. Second of all, that the Sentinel was to be taken off, and that's what got Tad Bromfield involved. I'm not a computer expert. I'm sorry.
But you signed other documents already. You signed documents, and you didn't take care of those either, did you? I mean, we just looked at those documents. You didn't make that change.
I realize what you're trying to make me look like, ma'am, but the TAR forms are, it's a set TAR form. I don't know how to take the letterhead off
Why didn't you provide a non-TAR form?
because all the forms were already printed and already in use. I have used other agencies' forms for residential real estate before. I've used Keller Williams forms, I've used Crylike forms, and they say those other companies at the top. But then you put Regent Properties on it, it's just a form letterhead. I didn't have access to TAR. I don't know if I was supposed to hear that question or not, but
I'm just thinking out loud.
Okay, when did you get your license, did you say? When, do you know?
I got out of the Army in 1992. I think I got my license in 93 or 94.
Did you have to take a test to become a broker?
Yes.
Okay. And in that test to become a broker, did you have to answer questions about your responsibilities if you're a principal broker and supervising other licensees?
Yes, I did.
Okay. Mr. Faulkner says that for a period of time, it was discovered that somehow a TREC form wasn't provided by the previous broker. When did you send in a TREC form transferring him to your business and providing the $25 transfer fee or the signature? When did you do that?
According to the law, it's the affiliate's responsibility to make sure the transfer happens, and he had been having issues with his other broker several times. Now, I signed two that I know of, or 3 different TREC forms.
Oh, okay, but how come you didn't verify that all of this had been taken care of before you allowed him to go ahead and draft contracts signing as a licensee and affiliate with Regents?
I did not allow him to sign a contract as an affiliate with Regent. When I found out he signed the contract is when I told him he could know, and said, we don't have your license yet, you call TREC, you don't call GCAR.
Well, how come you didn't know this transaction was in process and question it before it happened?
On the Wednesday, the 10th of August, 2011, I was getting my handset.
Okay, so when the forms show that the house was showed on August 10th of 2011 with Frank Cowden, that wasn't you, is that right?
It was not me. Zach, I don't know why I don't know what he was thinking. I mean, he's had several medical issues, but what the deal is, I had my real estate key on my desk, his real estate key, I don't even know if it's active, I didn't, but my password is on the back of the key. And he, as he said to the court, he picked up the wrong key.
So who in your office manage things when you're not there to make sure people don't pick up the wrong keys and use the wrong forms and make sure people are licensees if you're not there? Who does that?
Who manages my office?
Well, yes, to take care of those details I just discussed.
He was the only other agent. He was the only other attempted agent at the time.
So if you weren't there and things weren't happening, there was nobody to oversee this person in any way, shape, or form?
He was not there most of the time. He was at his office, which was a mortgage company office. I think he said that. His real estate license was not an issue until he got a contract, or till he started to get a contract. When he got the contract signed, I said, where's your license? We've been through this for several months. Where's your license? Well, I've called GCAR. No, you call TREC.
Now, if you'll,
I'm sorry.
Okay, well, after August 10th of 2011, and sometime in August, when did you file a transfer for his license to be placed with your firm after it was discovered it wasn't done, you think, by his previous broker. When did you become proactive and take care of that?
I did not, because I didn't want him as an agent.
You wanted the money from the commission, didn't you?
Not appropriate.
Okay. Did you get paid a commission on this?
Yes.
Okay, and in fact, what you said in your response, let me just find it here.
May I add that Zach was
just
so
ask you
that
about-
Zach was so busy with his mortgage company business, he didn't have time to pay attention to being an affiliate.
When you filed this response, and this response was filed, let's see,
October.
November the 3rd of 2011, okay? You said, he was still with you, because you said he works as my assistant, not an active agent. Do you remember
I
saying
was
that?
referring to the time when he was there.
Well, that's not what your letter says, sir.
You're correct. I was referring to the time, that time period.
Back up just a little bit.
I'm sorry. May I see that, please? Okay. So he was acting as an assistant, not as an agent. I don't want him as an agent. He doesn't have time.
How come? Here, all you said was he works as my assistant. How come you didn't make that clear?
Because the biggest mistake I made is I did not hire an attorney to draft my response.
So you suggesting an attorney would have, never mind.
I'm suggesting that we wouldn't be here if I'd have hired an attorney back then instead of trying to make it simple and saying, look, when I found out he wasn't an agent, I said, don't act like an agent. We'll get it straightened out, or don't be one.
Well, how about between October, or let's say August, when you knew for sure he was not an agent, and November, what actions did you try to take to make him become your agent? What
I
form?
answered that saying that I did not want him as my agent. He would work as an assistant. And in that form, give me leads that came into his office as a mortgage company to help people buy houses.
Okay, so what did you pay him from August, let's say, to November of 2011 as your assistant?
Nothing.
Nothing. Okay. I have nothing further, sorry.
Frank, when did you have your heart attack?
I actually had my heart attack on President's Day of 2012.
So that has nothing to do with the proceeding today.
Well, not today, but it had a lot to do with getting the complaint and finding out what the fine was going to be.
And what did you do in Desert Storm?
I was advance party for 7th Corps Artillery. They sent myself and a command sergeant major and a major. I was a young captain we were advance party into the desert by ourselves.
I am going to overrule that. Just as background information, I think that's fine, if we don't go far down that road.
How long were you there?
I was there for the entire war.
And when did you get back?
I'm sorry, sir?
When did you get back?
I came back from the desert to Germany, back to the United States in 1992.
Did you know Zach was going to take your key on that day?
No, I wasn't. I was at the doctor. He was wrong. I wasn't at the hospital. I was just at a doctor's office.
Did you ever give him permission to?
No.
Did you expect him to do that?
No.
Have you ever heard of, did you think you needed to keep every key under lock and key at all times?
No.
Have you ever had any other agents?
Yes. I've had, at one time, I had up to four other agents.
In the last few years, though, how many have you had?
Back off just a bit.
I'm sorry.
We're having trouble with hearing up here.
Maybe I can just talk louder like this. Can everybody hear me?
Yeah.
We have to pick it up. That's good. And there's some
Doing
they are
good.
so percentage.
When of the last, since the recession started, the fall of '07, I lost 2 of my agents. Let's see, and then I have not had another agent since. So none since the fall of '07. Is that okay?
Did Zach keep you informed of efforts he was making to transfer his license over to Regent?
Yes. I met Zach when he was actually looking for space for his mortgage company a year or so before. And when he came to me with the problems of his broker leaving town, trying to be a broker from South Alabama and couldn't contact her and keeping his money, I said, well, you know, I'm ready to expand again, so let's try. After this experience, I'll be one-man show.
What kind of work do you normally do?
I normally do commercial work, but I do sell homes for family and friends, help them buy homes.
So you don't use any of these TAR forms?
No.
You have your own documents that you use, is that?
I have a firm, Miller & Martin in Chattanooga, made several purchase and sale agreements and different types of forms that we need.
You had some attorneys put together forms, and that's what you use for your normal everyday business?
That's correct.
And I assume you prefer to use that than a canned form that's on a TAR system?
It's a lot simpler. We've had a couple of inspections even, and they're happy.
How long after you found out that what was the delay between finding out that he had these licensing problems and you stepping in and taking back over the file?
He signed the contract on the 10th. I was in the 11th. He made phone calls and followed up, and then I was on the job at the 12th. I think there's even a form signed by me on the 12th.
Did it take these forms that had Sentinel at the top and wrapping up the transaction? I guess opposing counsel has made the suggestion that all of these forms should have been redone, I assume. Did the parties want to blow up this deal?
The buyer and seller are happy. The buyer and seller, Mr. Allen is happy with the transaction. And I said, we can go back and we can redo all this and try to get signatures again, or we can just use what we have and I'll represent you and take care of you. And instead of redoing it and the fish can get out of the boat, I thought I was taking care of Allen.
When did your problems with the heading on these documents finally get corrected?
I know the phone number is corrected. But as far as the heading itself, I haven't printed another TAR form. I couldn't say that it is corrected. I think it is. Tad said it was, but TAR is not TREC.
Approach and provide an exhibit to the commission?
Has this already been admitted into evidence?
It has not.
Oh, well then, make sure you show
has
it
not.
to Ms. Ryan.
Actually, it has, Your Honor. It's part of the complaint and the response from Mr. Cowden.
So which exhibit would that be?
I think.
3?
That would be exhibit number 3.
Okay.
Apologize.
No, that's fine.
I'm referring to an email from Frank Cowden to Michael Burleson.
attached to Mr. Cowden's response in this document.
Okay. It's like 4 pages from the back of Exhibit 3.
In here, I mean, you referenced you had hoped to have this changed before. Is that correct?
That is correct. Tad, I put the onus on the other broker since he was the one using TAR forms and to change back whatever he changed in the system before he left my company. And the way I found out about it, like I said before, is that my phone calls would go to him. And so a couple of brokers said, Frank, what's going on? And I called Tad and said, fix this. The phone numbers got changed, but the heading didn't get changed. I've never put a Regent Properties headings on TAR.
Did you expect Zach to be using these forms?
I didn't expect him to have a contract at all. I mean, the commission's great. They they get a license out in 3-4 weeks normally. So we didn't have a license. I didn't expect him to be, as far as I know, he was doing his mortgage business. Now, we talk about real estate. If he got a lead in his office, assistant, he would call me and say, Frank, here's a lead of somebody who's looking for a house. They qualify for a loan of $145,000 or whatever. And so we didn't have any, but that was the plan.
If you have ever gotten a call from Ms. Fuqua, the complainant in this case, could you have sat down and explained all of this?
Her or her broker. Didn't hear from either one of them.
And reading the complaint that was put together, were the facts accurate?
Her version?
Yes.
No, sir.
Do you have anything else you feel like you need to explain to the commission pertaining to this transaction?
I think Zach's transfer to my company was a mess up from the beginning. I understood it as the affiliate's responsibility to transfer his license. I wish I had known that he did not understand G-Car when he worked for those other people. That's the same as T-Rec. And that, because to call them would have solved the whole problem. And like I said before, if I had called you back then, maybe I wouldn't have had a heart attack.
So how long was he in your building?
He has had a desk in my building for a couple of weeks, not, no long amount of time. He worked mostly as a mortgage broker.
So he had really only been over, with Regent at all for how long?
I hadn't even talked to him in I couldn't tell you how long. We became friends, and we're trying to do a different business venture, not in real estate or mortgage, but I hadn't even talked to him until he called me and told me he had a contract. And I'm like, well, where the blankety blank is your license?
But you knew at that point he was transferring over to Regent.
We were trying.
Yeah,
but you still have to have the license.
Right.
My rule is no paperwork, no go. So I didn't know if he was still working with. We were trying to get it done, but no license.
I have no further questions.
Commission members.
Does any commissioner wish to ask a question or two?
You want to start?
Mr. Charo, you're up.
How did Mr. Faulkner get into Transaction Desk?
He used my password. I don't know why he wouldn't say that, but he did.
Did you ever sign a Trick 1 for Mr. Faulkner?
2 or 3.
But you never went online to verify that he had a license?
No, ma'am.
You just left it entirely up to him to flounder around?
I left that part up to him. He was fighting with his brokers, not knowing where one broker was, or apparently this other guy wasn't even the broker.
On the 12th, you said you came back into the office and kind of took matters into your own hands at that point. I have a counteroffer here as a part of Exhibit 2, Mr. Harris, that is typed, and it appears to be done on transaction desk again, which is dated August 17th.
Yes, ma'am. That would be that's correct. I think I signed that form.
Well, you bound it. You were the binding agent, but who actually completed this form?
Zach typed out that form.
Okay.
As I said, he was acting as my assistant.
Okay. I have also, as the last document in this Exhibit 2, the last page of the contract, of the purchase and sales agreement, which is signed by Mr. Thomas on the 10th, and Mr. Carmichael on the 12th, and then your name is on that form.
I think those are out of order. I think I think those are out of order. The purchase and sale agreement.
We have 2 page 9s to the purchase and sales agreement. One that was signed by Mr. Faulkner and one that was signed by you.
I'd have to see the signature, ma'am.
Judge, can someone show him that?
No, you stay right there. Mr. Harris will bring it.
Mr. Harris, is the last page in Exhibit 2.
Mr. Harris, you know what it is she's referencing.
Yes, Your Honor, I do. At the bottom of that page.
Ma'am, that's not my signature.
Whose is it?
I'm gonna tell you.
Did somebody sign it on your behalf?
I can tell you. Zach Faulkner signed the purchase and sale agreement.
Okay, we have an agreement that Zach did sign that page 9 of, and then we have that. But that looks like it says Frank Cowden, but that's not your signature.
Ma'am.
Okay, thank you.
Any other commissioners? Mr. Cowden, I have just a couple of questions. Do you know how Zach got a hold of Mr. Thomas as a customer or a client?
He came in, Zach advertises a lot on the radio as a mortgage company. And so it's my understanding that he came to Zach's mortgage company looking to pre-qualify for a loan. I don't know when. And then came back, it could have been the same day, and said, I found a place I want to buy.
So you didn't give him the lead. You didn't know Mr. Thomas prior to Zach working with him.
No, sir.
There was a signature page in there on an agency disclosure that said Zach was a designated agent for the buyer. Is that your company policy? And did you know he had represented that?
No, sir.
Had you ever had a discussion about agency?
I didn't have his license. I didn't think he was working as a real estate agent.
So your testimony is that basically Zach did all this without your knowledge. Once you found out, you stepped in and got him out. Is that the
We
summary?
had gone over passwords. We had gone over, some stuff as far as the TAR password. I don't know what it's called, but but as far as acting as an agent, no, sir.
I'll ask you the same question I asked Zach. Did you keep copies in those Trek ones that you
No, sir.
signed? Retrospectively, do you wish you had, or would it have made a
Absolutely.
difference?
Absolutely. And like I said, I'll be a lone wolf from now on.
Just this is just maybe more of an observation, but on the counteroffer where your signature ultimately or initially appears, did you not think about maybe just taking a piece of white paper and putting over Sentinel on top of it, so at least we could see where you stepped in and got control of the situation?
I did not think about it, no, but printing tar forms at that time, Sentinel was just at the top of it.
Thank you. Any other commissioners? Mr. Alexander?
You kept referring to TREC forms. What are you talking about? Contracts? T-Tracks, something I couldn't.
Tennessee Association of Realtor form, sir. This is a tar form. Tar.
Oh, I know about tar
Yeah.
form. I commend you for not using a tar form. I don't use them things either, so, I commend you there. You were smart.
But what I was saying, sir, is that TAR, Tennessee Association of Realtors, just like GCAR, TREC is who is in charge of us, not the guy who makes these forms. And
You're not telling me that you use a TREC form?
no, sir.
Okay.
I don't.
All right.
Now TREC Form 1 you'd use if you got an agent. I mean, there are certain ones that you'd have to use.
But I'm talking about buy and sell contracts.
No, sir. No, sir. I hired Miller and Martin to take care of that years ago.
Well, if we'd have put you on this thing first, we'd have saved a lot of time.
No.
I'm sorry.
Okay. Mr. Collins, do you have any questions?
I'm through. I'm ready to go home.
Your Honor, we'll turn it back to you.
Ms. Ryan says she has some follow-up.
Sorry, it's just to take a minute.
And then I'll have to read you my charge, and then I'll turn it over to you.
Okay. Mr. Cowden, you said.
Can we take another break before she starts again?
I only have a minute. It'll only take a minute.
Well, if the commission wants to take a break, I think we need to do that.
We'll take about a 4-minute break.
All right. It has come to my attention that Mr. Cowden has someplace he's supposed to be, and he and his attorney and Mr. Faulkner are all three in one car. So Mr. Cowden has suggested the possibility of, after his questioning is finished, leaving before you deliberate. Attorneys, let's hear from you on this issue. I've never seen this happen before, except when somebody got mad and walked out, but.
Well, if the commission wants to.
Go ahead.
No, let's hear arguments about it first, to see if this is proper. Can you do this? Can you, well, you can. I'll just tell you that, but.
An option. Well, first, there are a few options. I've told Mr. Cowden, and I mean it, there are ways back to Chattanooga other than my vehicle. If y'all want me to stay, I'm comfortable staying, and he can go back. Another potential option, if y'all want him involved, and I completely understand that, is some type of conference call where he can still be on the road and he can listen in. I mean, that might be a doable option. This is a large deal for Mr. Cowden. They've been working on for years now. And we thought we would be done by now, frankly, and I think probably
We all
did
thought
as
so.
well.
Yeah, we should have been.
So, yeah, we are in a bit of a quandary, but I don't mind, again, staying, and he can definitely participate by phone if
Well-
this is determined appropriate by the commission.
I don't know that we can do that at this point.
Once we get to deliberation, he
Yeah,
can't say anything
you will
anyway.
have no role anyway. You can't talk, unless the board votes to recall, to ask a legal question. But that doesn't happen very often.
May I explain to them?
Yes, if you'd like to.
Sir?
Well, maybe Mr. Chairman Reese.
It's the chair's sense that if we just got this procedure going, it might not take too long to finish.
Okay.
It might, and at some point you said, this is my drop-dead time to leave, then I think that'd be the appropriate time to make the request. That's just from the chair's perspective.
Okay. You all haven't talked to each other.
Absolutely not. That's
Okay.
no.
All right.
I have a question to you.
Uh-huh.
And I'm sorry I missed part of the conversation. Are you saying that these three folks rode down there together?
Yep.
Well, it's funny why I just come by and asked this man, I just asked if he could leave. He said he had somebody gonna pick him up.
Well, maybe he's made other arrangements.
That might be correct. I have not spoken to
I'm
Mr.
just,
Faulkner.
you know,
Well,
that bothers me.
so, Mr. Cowden, what is your drop dead time?
Well, ma'am, as we said, it's a community meeting on a 190-acre multi-use rezoning, and this is our last meeting. We've worked on this project for probably about 7 years, and it's actually the drop dead. It starts at 6 o'clock Chattanooga time, and we're almost at 3 o'clock Nashville time. I'm going to be pushing it anyway. I mean, I figured, I didn't think it'd take this long. Sorry.
Well, Ms. Ryan.
He can leave. I still have redirect for him, though.
All right, let's go ahead and do his redirect, and any questions the board has, commission has, and then we will go ahead and excuse you, and we'll make it clear for the record that this was at the request of the respondent, and the respondent realizes that he will not be present for the deliberations.
Ma'am, during the deliberations, we don't.
You don't participate. You sit here and listen.
Y'all are going to take me to jail, are you?
I did
You never can tell.
I did wonder if we could do a settlement like we did last time.
Close it.
Okay, let's let Ms. Ryan ask her questions and get this
Let
done.
Mr. Cowden get out of here.
Please.
Go ahead, Ms.
Thank you.
Ryan.
Mr. Cowden, you stated earlier that on the 12th of August, you were back in the office and in charge of things and telling Mr. Faulkner he was to do nothing further. Is that right? Is that what you said?
As an affiliate, that is correct.
Okay, then I'm going to show you a document and ask you if you can identify it. Can you read what the document states? What, at top, what is it?
It's the compensation agreement between listing and selling broker.
And down at the bottom, what's the date and who signed it at the very bottom?
It'd be Zach Faulkner,
And what's the date?
19th,
Of what?
August.
So on the 19th of August, even though you're back in the office and in charge of things, he's still doing things as an affiliate. Is that right?
That is exactly why I don't want him as an affiliate.
That's not my question, sir.
Oh, excuse me. Yes, ma'am. That is exactly why I don't want him as an affiliate.
Now, you also said earlier that Mr. Broomfield, is it? He was in your office at one point? Is that right?
Tad Bromfield?
Yes. Mhm.
Yes.
And when he was in your office, was Sentinel Commercial Properties a part of Regent?
No, ma'am. I explained that Sentinel Properties was the company that he moved his license to as a broker
I
from
understand.
Regent.
I'm asking, when he was in your office, was Sentinel Properties a part of Regent?
No, ma'am. Sentinel Properties was the company that he moved to.
Okay, but somehow when Mr. Faulkner accessed TAR forms using Regent, it came up Sentinel?
When
When the TAR forms were accessed using the Regent's password on TAR, he got Sentinel documents?
Before Tad left Regent Properties, he was setting up his own company, and he somehow put his phone numbers and his letterhead on the Regent, underneath Regent Properties, underneath the passcode for Regent Properties. Ma'am, as I said, I'm not a computer expert. It took months for him to get it fixed. This email shows right here that it's fixed. There has never been a Regent Properties letterhead on the TARnet or TAR key forms.
And when he left the company, I'm sorry, in 2009, is that right? Was that right? I don't remember, I'm asking you. Is that
I
right?
believe that's correct.
Okay. I have nothing further.
Obviously, I have nothing.
Not obviously. Okay, now is when I would normally let you make closing statements.
You have a closing statement to make. I'm sorry.
Okay. Fine with me. I'm here. Do you want to,
I will ask if Mr. Cowden can be released.
I'm not leaving you here. Go ahead. Well, I'll wait.
if, like I say, if you all are going to waive being here for the rest of it, you're welcome to do that, and because you won't participate. I don't know how that will look to the, well, anyway, I'm not going to speculate on that. But if you wish to leave, I don't see any legal problem with your doing so. Unless you want to talk settlement, but no. I don't know what Mr. Collins was talking about there.
I just would like to know what he was charged for originally before he decided to appeal to the commission. Was that?
He did.
$4,000.
No, wait. No, we can't go into that. Those are settlement negotiations that are not a part of this whole deal. So,
Your Honor, would you proceed with closing arguments, please?
all right. And like I say, if you guys feel like you need to leave, it's up to you. Pardon?
No, I just need my notice of hearing and charges. Where did that go? Did you pick up my notice of hearing? My notice of hearing and charges document, I don't see it here.
Commission members, I didn't give you a final chance to ask Mr. Cowden questions. No?
Yeah, the notice of hearing and charges document. Oh. It was
Are you looking for the notice of hearing?
Yes, it's my notice of hearing and charges, that's correct. Your
Do you
Honor.
have to have yours, or can you use the one
I
from
can
the
use that
technical
fine.
record?
I'm sorry, it was just out and I don't know where it
Is this it? Here it is.
Thank you.
Oh, she found it.
This is it, I guess.
And I have another copy, which might be hers as well.
The issue we have here this afternoon, morning, day in December is the failure of Mr. Cowden to do what he needs to do and needed to do as a principal broker. I don't doubt that there were real issues in getting the transfer resolved, but the responsibility also was on Mr. Cowden to make sure somebody wasn't doing something illegally while under the purview of Regent Properties where he is the principal broker. And that is exactly what happened. Not only that, also, as a principal broker, he allowed documents to be signed, and he signed documents that led itself out to believe that somehow Centennial Properties could be involved with this particular agency. As a principal broker, as all of you know who are principal brokers, you do have responsibilities. You are not employers, but if there is some affiliate working for you, you have responsibility to make sure that affiliate is licensed. And you have responsibility to know the laws in Tennessee and the forms that are required in Tennessee, including the TREC form that could have been filed by Mr. Cowden at any time and was not. I'm not asking today, and we are not asking the state for a revocation or suspension of license. But we are asking this commission to consider that these allegations are serious and that should be a civil penalty attached for these violations, because Mr. Cowden needs to understand that if he is going to hold himself out as a licensed person with a principal broker and have anybody working for him as a potential licensee, he has responsibilities. We would assert that he failed to supervise his potential employee, that what he did was improper, and that therefore he is in violation of Tennessee Code Annotated 6213-302, where he had someone working for him who was not a licensee at the time. 312, because in the case of a licensee, he failed, 312B, he failed to exercise adequate supervision over that little person. Number 20, that conduct which is of a different nature or different character that is either improper, fraudulent, and dishonest. And we're not saying it's dishonest or fraudulent, but it was improper. That is our position. And that he has violated the rules of the chapter otherwise. We're asking that this commission assess a civil penalty and importantly, that he be charged and taxed with the costs today of the hearing. And that whatever civil penalty and costs that you assign, he be required to pay that within the time allowed by law, which is a 30-day period pending any appeal. Thank you.
Thank you. Mr. Harris, do you wish to make a closing statement?
About 30 seconds. I think there are a few reasons here. We've gone through all the confusion and all the problems. I think looking at these charges, I think one of the biggest problems and one of the reasons we're here today is exactly one of the last things she's talked about. Any conduct, whether the same or different character, which constitutes improper, fraudulent, or dishonest dealing. That's a pretty serious charge. So based on what we're dealing with here, so here we are, fighting this, and that's the reason. We ask it be dismissed. You heard Mr. Cowden explain what happened, and we appreciate your time.
Thank you. Does either party have proposed orders?
No, I did not do a proposed
Okay.
order. I'm asking them to consider the notice of hearing charges facts.
All right. I'll do this quickly. It's now my duty to charge the commission in this case. As decision makers, you're the exclusive judges of the facts as well as the application of your statutes and rules to those facts. In reaching your decision, you must conduct open, audible deliberations before all parties. You must have several parts in your findings of fact. In your final order. Findings of fact, conclusions of law, disciplinary action, if any, and a policy statement. The notice of hearing and charges filed by the state is not in evidence, but you may use this document as a guide in helping you make your decision, but only after careful consideration that the notice accurately reflects your own independent recollection. In making your decision, you may consider the evidence in light of your own training, expertise, and common sense. You must determine the credibility of any witnesses. Statements made by counsel are not evidence. When you make your conclusions, first there will be findings of fact. Then when you make your conclusions of law, you need to decide whether or not the respondent committed the acts or omissions as alleged in the notice of hearing. And then you must specifically tie those charges, those violations, to the facts that show that those violations were committed. These are your conclusions of law. Then disciplinary action, if any, and a policy statement which states why your decision is appropriate. Any motions must be carried by a simple majority of the panel members unless there are questions. I will be available to answer legal questions if you have those, even though, as I say, I will not participate in the deliberations. Unless there are questions, I will turn the hearing over to the chairperson, Chairman Grease.
Thank you, Your Honor. Would you just quickly remind us again about preponderance of evidence? You broached that subject this morning.
Yes. A preponderance of the evidence simply means that there is 51% in favor of what you're deciding. If you can think of the scales of justice, if it's just tipped a little bit, 51% to 49, that's a preponderance. It's not the beyond a reasonable doubt like you would find in a criminal case. And the state has the burden to prove that the respondent committed the acts or omissions as charged.
Members of the commission, I direct you to the second page of the notice of hearing and charges. The state has provided us a list, a partial list perhaps, of some allegations of fact, and we might use this as a guideline to determine whether or not these are indeed findings of fact after hearing the presentation today. And I'll be happy to make a motion on each of those and then discuss it, unless you all have a different way of going through these findings of fact. Commissioner Flitcroft, do you have a thought on that?
Yes, I think Commissioner Collins is on the right track, and I think we ought to sit down and propose and see if we can work it out. I don't think the parties are that far apart.
I'm not sure, Your Honor, if that's appropriate at this point.
I'm not sure it's appropriate either. Now, the parties can discuss it, but once you've heard the proof, then you can either approve or disapprove any settlement that they wish to make. But as far as you're suggesting something and seeing if they'll agree to it, no, not now.
Your Honor?
Yes,
Mr. Chairman,
Go ahead, Mr. Alexander.
Let's see if the two attorneys can get together here for about 2 minutes. and make-
I have not been given any authority to negotiate resolution, ever. Do you want to give me authority to do that? Because I'm happy to do that, but I've never had authority to negotiate any settlement at all.
All right, Mr. Chairman?
I'm gonna
Closer to the microphone.
Mr. Alexander,
Mr. Chairman, I move that we give our legal staff the authority to negotiate.
now, before I honor that request, I'm going to yield to the judge on this matter. Is that the proper motion at this point as we start our deliberations?
Well, that would be up to you, actually. I don't think it's proper for you to participate in the negotiations. But if you want to authorize the state's attorney to enter into negotiations, then when they come back with an agreement, you can either approve it or disapprove it. And if you want to only authorize her for this one case,
Just for this particular case.
Okay.
Okay, so there is a motion by Commissioner Alexander that a state's attorney be given authority to attempt to negotiate a settlement in a short period of time. I think you said that too, didn't you?
Yes, I did, about 5 minutes. Not as long as they've argued all day.
Is there a second to that motion? Seconded by Commissioner Collins. Is there discussion on the motion? Hearing none, all those in favor of the motion vote aye.
Aye.
Opposed, no. It's unanimous. We'll start the clock, council. 5 minutes, see if there's anything can happen.
Right, if you...
Please, ma'am.
Your Honor.
Go ahead.
When we last parted, we sent you all out in the hall to see if settlement can be reached. Is that a possibility?
Well, we're going to present, I'm going to have Mr. Harris present his proposal and let you decide, and I will tell you my opinion on it, but I'll let you decide whether or not it's acceptable.
No, I think we got to have an agreement here.
Okay.
If we don't have agreement, then you guys have to do findings of fact and conclusions of law.
We have discussed the terms, and Mr. Cowden and Mr. Harris and I discussed that he would be willing to enter an order finding him guilty of failure to supervise a licensee, pay civil penalty of $1,000, pay one-half the court costs, and attend a meeting within 180 days, or 60 days.
180.
180 days, attend a two-day meeting within the 180 days. That would be, if that's acceptable to you all, that is what we have talked about and negotiated.
Mr. Chairman,
Mr. Alexander,
I move it be accepted.
I'll second that.
is there discussion? Let me tell you, my only concern about that, this is my personal discussion. In my opinion, he's more than attended a full meeting today, just listening to this stuff. And I would, my opinion, take that out of the settlement, but that's me. And so I'll amend the motion.
No problem.
I think he needs to hear what we discuss on a regular basis in the rulemaking hearing, and I don't think he'll be opposed to coming back and spending 2 more days with us.
We're talking about that right now. There are a couple of holes that I'd like to see.
I withdraw my amendment to the motion. The motion's on the floor. Is there further discussion on the motion?
Off the question.
I hear none. All those in favor of the motion, please vote aye.
Aye.
Those opposed, no. It is unanimous. Your Honor, the commission is pleased with the settlement offer and
Your Honor, may I make a statement for the record for the commission? In the future, commission, if you wish to have me have negotiating powers, please tell me beforehand or before the hearing starts, because we can go forward with it if you give me the power to negotiate. Otherwise, I can't do that.
That's a topic for another meeting, I
Right.
suspect.
But I just want to
All
put
right.
that out there.
Thank you very much. And so, Ms. Ryan?
Kelly, get the sausage out.
Then, I guess what's going to happen is you all will...
I will draft an agreed order and I will
send
fax
it to him, and he will sign it,
or email
and
to me.
then it will be signed by our chair.
Chair. Will he sign it, or will the chair sign it?
No, he needs to sign it.
Co-chair. Mr. Grease.
Yes. Right.
All right, are we officially adjourned as far as the hearing is concerned? The hearing is officially adjourned.
Get your deal done, get on the road.
Director Maxwell, is there anything else to come before the commission today?
No, there is not.
This commission meeting of the this meeting of the Tennessee Real Estate Commission is hereby adjourned. Travel safe going home, everyone.
Merry